Can I ask if you can identify that photograph?
This was a photograph that Julie Jensen had given me, I believe it was in August of '98.
Is there a note on the back of that photograph?
Yes, sir.
And whose handwriting is that note?
It is Julie Jensen's handwriting.
And what does it say?
It says found 7/3/95 in truck.
And so, Judge, this would be the first exhibit that I'm showing.
Right, go ahead.
Dude, the clip, that holy shit. Holy shit. Did you see that? What a fucking mistake by the court. They are going to fuck my stream up over that shit. Holy shit. Somebody screen grab that shit. All right. Good morning, people. How are you guys doing on this Sunday morning? Just getting everything shared out here. So, I've been spending the entire weekend clipping testimony from the Mark Jensen trial that we are covering. I told you guys Monday we were going to go live. We're going to play some 2008 testimony. And from watching just a bajillion hours of testimony while kind of clipping the modern day version of testimony for this trial, I was watching the Aaron Dillard testimony from 2008. Dillard was a pivotal witness for the state. He is the Jailhouse Snitch that came forward to the prosecution to say that Mark Jensen had confessed to killing Julie Jensen while the two of them were in the Kenosha County detention center. Because of Dylan's testimony in the 2008 trial, it was a dramatic shift for the prosecution's case. You're going to hear a lot of things. So we're hearing some reference in today's version of the trial about testimony from 2007. And I've seen a lot of questions on social media about, well, what the hell happened in 2007? So there was a bond forfeiture hearing for Mark Jensen, where a lot of these people ended up testifying in that hearing. And you're going to hear a little bit more about that today. There's a part in Dillard's testimony kind of made me chuckle a little bit. But I think it's something to note for modern day trial, modern day version of this. So he's going to testify. I'm just going to do a little spoiler alert because I want you guys to pick up on this and think about what if you were a juror on this case. Okay. Dillard, in this first part of the testimony that we're going to play, he's going to say something about the 2007 bond forfeiture hearing, about Jensen laughing at attorney Robert Jamboy. So he was the prosecution for the 2008 trial, and he's back for the modern day trial. And he's going to say something about how the pathologist lost all of their reports. That's interesting to me. That's interesting. We didn't hear that in this trial. They lost the reports. And if you guys remember, we clipped out the pathologist, Chambly, Dr. Chambly. We clipped his testimony out. You can find that. So all the testimony from this trial so far, 3 days of trial, we've clipped it out. You can find it on the playlist on our YouTube channel, on the Mark Jensen playlist. We didn't clip out the 2008 testimony because, oh my God, chat, has that been boring? But we clipped out the modern day testimony for you guys. So if you just want to hear what's said for each witness, you can go on our YouTube channel under the Mark Jensen playlist. But I thought that Dr. Chambly was absolutely destroyed by the defense. Put in the chat what you guys think on Facebook and YouTube. Put in number 1 if you think the defense just absolutely mopped the floor with Dr. Chambly, or put a 2 if you think Chambly was still a credible witness. Now remember, he testified in 2008 about the effects of antifreeze and how, that ended up killing Julie Jensen. And in the modern day trial testified that he actually doesn't know anything about antifreeze, even to this day. And he regrets testifying to that. But in what we're about to watch this morning, and I think we're going to do a marathon today. We're going to do a marathon because remember, they are off court tomorrow. So we're going to do a marathon of streams today, playing some archived footage. A lot of you didn't know anything about this trial. A lot of you never watched the 2008 trial unless you were from Kenosha or you were into super cringy, courthouse trial videos. Remember, in the 90s and early 2000s, these court trials were super cringy to watch. So we're going to do a marathon of things today. We can only stream for 8 hours on Facebook, a little bit longer over on YouTube, but I'm going to play testimony pretty much all day, and then we're going to do the same thing on Monday as well to prepare us for Tuesday morning when they come back to court. So welcome to the stream, everybody. Make sure if you are on Facebook, please like and follow the page throughout the stream. Spam that chat with thumbs up and hearts, and tag your friends, invite them over, share the stream on your personal pages and whatever groups you're allowed to share streams in. We are trying to get as many viewers and followers over here. So you guys can get your questions answered and all of that. If you're watching on YouTube, make sure you guys hit that thumbs up to like the stream and subscribe if you are not. Okay. 50 some odd % of our viewers on YouTube are not subscribed to our channel. So hit the subscribe button and hit the bell for all notifications so you know when we pump out new content for you guys. For those of you on Facebook that are watching that are not perma-banned over on YouTube, because I see some familiar names and some of you are perma-banned on YouTube, but for those that are not, come on over to YouTube and subscribe to the channel. There's a lot of good content. For those watching on YouTube, if you're not following us over on Facebook, come over there, NSM News Updates, and follow us over there too. We post a lot of content between the two different channels. We're posting a lot of reels. We're posting a lot of clips for those of you crazy ones that have TikToks. So we were dumb enough to create a TikTok because of a juicy story that we started writing about a TikTok thing. So now Never Stop has a TikTok. So we got some clips over there. Follow us over there too. All right. Any questions from anybody on Facebook or YouTube? Any questions about this trial so far? Post some comments. We'll highlight some comments in this stream. We've got some pinned links on Facebook and YouTube. So if you guys like what we're doing over here, a great way to support the stream is through some donations. On YouTube, you can send in some super chats. You can become a member on YouTube. That helps us be able to continue what we're doing. But any questions before we get started? Because we're going to start pumping out this content. Testimony from Aaron Dillard. He's a juicy key witness. I want to see what you guys think about his credibility. Remember, he is a jailhouse snitch. He is a con man. Okay. He has quite a bit of a lengthy record when it comes to fraud, not only in the United States, but also in another country. You guys are going to learn that too. Any questions before we get started? We're going to set the stream up here. Good to see a bunch of you from Facebook back again, joining us. That makes me so happy. So we got all day to play some streams for you guys. It looks like nobody has any questions, so that's great. We are going to jump right.
State your first and last name and spell out your first and last name.
Aaron Dillard, Aaron Dillard.
And, you may be here for a while, so if it'd make you more comfortable, take your coat off.
Okay, thank you.
Jennifer says that pic is my new screensaver. That's funny. Yeah, I've posted up some clips. Okay, we obviously had to do it, super Fight Club style, Tyler Durden, super fast because of legalities. But remember, that stuff went around live, so it's available somewhere. I originally posted the timestamps, and then I'm like, nah, we're not going to post timestamps. But it's around, perhaps. If you guys don't know what we're talking about, we played a clip right at the beginning of the stream. The court screwed up, and they were showing an exhibit, and they showed a very lewd photograph that they accidentally broadcast live on every single stream that was going out. One of our viewers was nice enough to screen grab it for us, obviously because of legalities and all of that. We had our chat send an email if they missed it. A bunch of people got up and walked away from the screen because we were watching some boring video, and people got up and walked away and heard me losing my shit. We played the clip at the start of the stream, losing my shit on stream, and ran back to the computer and went, what the hell? What did we miss? What did we miss? And so I was like, just email us. We'll send you what you missed. So if you guys missed it and you want a screen grab picture of what was shown, you can email us, neverstopvoices@gmail.com. We'll send you the pic with a legal disclaimer that you asked for this shit. We did not just solicit it to you. It's graphic. It's naughty. It involves some male stiffness, let's say, and painting of a facial portrait. What's up, Jess? Jennifer says, my husband definitely wanted to have a talk after I showed it to him. I'm sure. He was probably like, what are you watching during the day? Now he's questioning every single move you make during the day. All right, here we go. Let's get to it.
Right?
Yes, sir.
How did that happen?
In agreement, the state, I provided information on this trial, and the state offered.
Is it that,
Let me just back this up a little. There we go.
and Mr. Dillard, you just walked through the front door of the courtroom. It was promised by defense counsel during his opening. And how is it that that happened, that you were able to walk through the front door of the courtroom instead of being brought in here in prisoner's clothes, if you can tell us?
Well, I got released from prison.
So you were in prison, and then you talked to me, and then some period of time later, you got released from prison, right?
Well, yes, sir.
How did that happen?
In agreement, the state, I provided information on this trial, and the state offered a recommendation to the state for probate, or to be released, to get released on extended supervision.
So that was a pretty good deal for you, wasn't it?
Yes.
Now, tell us about the conversations that led up to that resolution.
With Mark Jensen, or
No, with
yourself?
me.
The conversations with you I had were pertaining to the case of Mark Jensen, In regards to that, you offered to make a recommendation for probation or for extended supervision to be re-extended.
What were your concerns about, remaining in an institution
Well,
after you cooperated with authorities?
Subjection to relevance. Improper bolstering.
Yeah, it sounds like something that wouldn't be appropriate at this point in the examination.
Well, what are the terms of the agreement that exists between you and the prosecution in this case?
Well, objection to the extent that it calls for the same answer.
No, I don't think so.
Well, it's not the entirety of the answer, but I think it's a portion of it.
I don't know what the answer is going to be until the witness tells us, and I certainly think it's appropriate, Your Honor, to ask a witness if there's an agreement. In fact, I'm ethically obligated to let the jury know what kind of agreement.
Speaking objection.
Just.
Look at Bruce Schroeder just lounged back in his chair, sucking
Objection's
on
overruled.
probably.
That means you can
some
answer the
type of-
question. You remember what the question is, sir?
Yes, it's to tell the
Gross
truth
candy.
and that I uphold all obligations of the law.
Now, when you were released from custody, does that mean you're discharged from your obligations to the criminal justice system?
Absolutely not.
Why is that? What obligations that remain with respect to your obligations to the criminal justice system?
I am on extended supervision and I face about 4.5 years of prison if I were to violate any conditions of my extended supervision.
And what are the conditions of your extended supervision?
To obey the laws. I'm not allowed to do certain things. They have certain conditions set against me. Like I can't have over $100 in my pocket at one time. Can't use credit cards. Just general rules like that.
You can't steal any money from anybody?
That's I would believe falls under the obeying the law.
And tell us about your prior criminal history. Do you have any idea how many prior criminal convictions you have in this country?
I believe 7.
And do you have any prior convictions in any other countries?
Yes, Lithuania.
And what kind of convictions do you have in Lithuania?
The visa fraud, immigration visa fraud.
Do you know how many counts you were convicted of there? Or I don't even know if they call them counts, but
They don't call them counts, but there was, I believe, 5 victims.
so 5 different crimes.
Yes.
And you've had victims here in the United States as well.
Yes, sir.
So let's start with the earliest portion of your criminal history that you can remember. What was your first criminal conviction about?
I issued a worthless check. I bounced a check to a ski company.
I'm sorry.
I bounced a check to pay for skis.
And how long ago was that?
1993, I believe, but I was convicted in 95.
And how much was the check for?
I believe, I can't recall the exact amount. It's about 800 to 1,000, I would believe.
So they're pretty good skis.
Yes.
And when you wrote that check for $800 to $1,000, did you have any reason to believe that there was enough money to pay for those skis in your checking?
Yeah, I believe I didn't. I knew there wasn't at the time, but I hoped to put it in time. I was expecting some money, and I wanted to go on a ski trip. Just it didn't fall through, and I didn't put the money.
So you kind of made a promise you couldn't keep.
Yes.
And do you think that kind of falls into the category of a lot of the problems that you've had in your life?
Yes.
A lot of problems you created in other people's lives too.
Yes.
You made promises to people and then you didn't keep them.
Yes.
And what's the promise you made to the prosecution in this case?
To tell the truth.
And let's tell the jury about the next criminal piece of activity that resulted in a criminal conviction in your case.
I believe the next one would be also, I bounced a check to Walmart in 99.
And how much was that check for? Do you remember?
It was a low amount. I don't remember the exact amount.
Less than $500?
Yes. Yes.
And what was the next criminal piece of activity to engage in after that?
In 2000, I forged a check. I printed a check on a computer.
And how much was that check for?
There was a number of them, about $400 a piece.
How many?
8, 7, somewhere around there. So about 3,200 roughly.
And tell us about that scam. Who cashed the checks for you?
I printed them on the computer, used check stock and just printed fake account numbers on it and just went to like different bars and cashed them as payroll checks.
So as you were doing this, you knew that these people that were cashing the check were going to likely be out that money, or the bank was going to be out that money,
Yes,
and you did it anyway.
yes,
And so you were convicted of that offense.
yes, I was.
And what's the next piece of criminal activity that you engaged in where you got a conviction?
In regards to this case, I was out on bail and I didn't show up for court. So I got a bail jumping charge.
When you say which case, what?
When I forged the checks.
So you were out on bail.
Yes.
And what happened while you were out on bail?
I went to Nevada and then didn't show up for court.
And how was it you were able to afford to go to Nevada?
I really couldn't afford it, but I also had other forms of income as work and just doing side jobs, construction jobs.
So who'd you go to Nevada with?
My cousin.
Anybody else?
Yes, I did on that trip. I forget her name. It was a woman. I just can't draw the name out of my head.
And while you were in Nevada, you used her credit card to pay for your hotel room, right?
That is not true.
Oh, well, tell me what happened.
On that trip, she got a little upset with my cousin and I and ended up leaving. She paid for the hotel and she stayed with her ex-husband and said we were supposed to pay for the hotel room. So she actually went to the hotel with us. She booked it in with her credit card and signed all the receipts herself.
So you didn't take her credit card in, she took it in?
Yes.
But you didn't pay for the hotel room?
No.
And did you ever reimburse her for paying for your hotel room?
No, I did not.
And you got a bail jumping charge on that.
Yes, I did.
And what's the next piece of criminal activity that resulted in a conviction?
While out on bond as well, I, in Racine County, forged a check to an ABC supply company.
Tell us about that.
I needed a compressor to do a construction job and I didn't have the money, so I wrote a check,
And how much was the check for?
$800.
And that was enough to pay for the compressor and some other things?
Just the compressor.
And you had no money to pay for that check?
Correct.
And so you ripped off the supply company.
Yes.
Did you ever pay them back?
I'm in the process of doing that now.
Because you're ordered by the court to pay them back?
sorry.
Because you're ordered by the court to pay them back?
Yes.
It's a condition of your probation?
Yes.
And what's the next piece of criminal activity that you engaged in?
Then in Lithuania, that's the one that falls in that time bracket as well. I promised people visas and didn't produce them.
You promised them visas and you had them pay for the visas.
Correct.
How much would you have each of these people pay for a visa?
Anywhere from $3,000 to $5,000.
And this is in Lithuania.
Yes.
And would you say Lithuania is an impoverished country?
Yes. I mean, as far as our standards go, as far as their incomes, it's acceptable with the amount of money they make, they can live.
So $3,000 to $5,000 is a lot of money in
A
Lithuania.
lot to them, yes.
A lot more money than it is here.
Away. Yeah,
Some of these people, is it like their life savings?
pretty much.
So you take their life savings,
Yes.
promise them a visa,
Yes.
and then you wouldn't produce it,
Correct.
crushing their hopes
Yes.
and emptying out their bank accounts.
Yes.
And you did that several times in Lithuania?
Yes.
And you got busted in Lithuania for that?
Yes.
And you served some time in Lithuania?
Yes.
And then what happened?
I came back. I got deported to America.
Lithuania threw you out.
Yes.
And you're an American citizen?
Yes.
So we had to take you back, right?
Yes.
And what happened when you got back here?
I was released. I was free, and then I violated my probation. Then I got sentenced on the forgeries, and I was on probation, and then I violated that probation.
How'd you violate it?
By doing construction jobs that I wasn't supposed to be doing, and other things, just lots of violations.
And so you got locked up again.
Yes.
And you were looking to get revoked, right?
Yes.
In fact, had they completed the revocation hearing?
On that revocation, yes, they did.
And how much time did you get sentenced to?
A year in prison.
And have you served that year in prison?
Yes, I did.
And were you on probation or parole supervision at the same time on some other charges?
Not at that time. I was on the Racine case too for the forgery as well. So both of those.
All right, nothing I can do about the commercials in the archived footage. There is going to be a commercial that comes up in this. I'm going to end up having to stop the screen share because they actually show something that will probably get a copyright strike. We've been getting a lot of networks that are claiming copyright on our streams, random streams too, claiming that we're showing stuff that is not even in our stream. And we've had to appeal a lot of things with our streams recently. Just random networks. It's crazy. Random networks. Yesterday, we had a copyright on our Jensen trial, a copyright from some random ass network saying that we played a basketball game. I'm like, what the actual F? There's not even a basketball game anywhere in this. So we had to appeal it as a false claim, and we won, surprisingly. All right, here we go. Make sure you guys share the stream up. Let's try to get a bunch of people over here today. Keep the chat going.
To serve the 1-year term and you got out.
Yes,
How long were you out for before you got locked up again?
roughly a year.
And what'd you get locked up for the next time?
Same violations, doing construction jobs that I wasn't supposed to, possessing a cell phone, things like that.
You were violating conditions of probation supervision?
Yes,
And you also caught a new case in Racine, right?
yes, I did.
And have you been charged with a criminal offense in Racine yet?
Yes, I have.
What have you been charged with in Racine?
Theft by contractor.
And how much money was involved in that? Do you know?
I believe she says $6,200.
And that case is still pending?
Yes,
And you understand that by testifying here today, you waived your right, your Fifth Amendment right against self-incrimination?
I didn't understand that in this case. I thought that this case wouldn't be discussed because I didn't think it had any relevance, but I understand it now.
You understand that it can
Yes.
be? And you're still here testifying?
Yes,
And it's a condition of this agreement that you testify truthfully?
yes.
And is-
Objection has been asked and answered twice.
How is it that you came to contact the authorities concerning this case involving Mark Jensen?
I wrote a letter to my lawyer and asked to talk to you.
In that letter to your lawyer, did you tell who is your lawyer, by the way?
Gretchen Rosanke.
In your letter to Attorney Rosenke, did you explain to her why you wanted to talk to us?
Yes, to discuss the Mark Jensen case.
And this is a communication to your lawyer?
Yes.
And, well, why did you want to talk to the prosecution about the Mark Jensen case?
To provide information because of what he did.
And what did you hope to get out of it?
Just my extended supervision release.
And tell us about the first time that you saw Mark Jensen.
The first time I saw Mark Jensen is when I walked into his cell block in Kenosha County Jail.
And when was that?
I believe it was the middle of August 14th, I think it was.
Of 2007?
Correct.
And what cell block was that, and what jail was that in?
Kenosha County Jail in J Block.
So when you first walked into that cell block, Mark Jensen was already there?
Yes.
And what were you doing there?
I was waiting to be sentenced on my extended supervision. I would come back from prison to be sentenced.
And had you and your attorney discussed how much time you were facing?
Objection. Hearsay.
It doesn't strike me as being offered to prove that the matter is certain. Objections are.
What was your assessment of how much time you were facing at the time that you were in the Kenosha County Jail awaiting sentencing?
I was facing roughly 4.5 years, and I believed I would have gotten about 1.5 to 2 at most.
You thought you might get up to 2 years?
Maximum, yes. I figured a year, 1.5 years.
Were you just being unusually optimistic, or did you have some information from your lawyer that caused you to think that?
It's just kind of standard procedure. If you get revocated according to your violations, it's either 30, 60, or all your time. So I was basing my categories on a 60% or a 30% violation.
Do you remember what your agent was recommending, your probation agent?
Yes, my agent was recommending 3 years.
3 years?
Yes. Well, she in the beginning, she was recommending 3, and then she jumped it up to the full 4.5. So in the end, she ended up recommending 4.5 years.
So she was recommending 4.5 years,
Correct.
but you were hopeful it was only going to be 2 years.
Yes.
And then you met Mark Jensen.
Yes.
Tell me about meeting Mark Jensen.
I just met him in the cell block. We just started talking and just had a general conversations in the beginning.
How much time elapsed between the point where you first saw Mark Jensen and the point where you first started talking to him?
I would say within 30 minutes, I bet you we were talking.
And did you initiate the conversation with him, or did he initiate the conversation with you?
I think it's a mutual thing. I mean, everybody just starts, there's only 10 people in a block, and everybody just kind of talks to everybody. So I could have initiated the conversation.
When you first saw Mark Jensen, did you know who he was?
I knew of him, didn't know him though.
But you knew of him, you knew he was charged with murdering his wife.
Yes.
So tell us about this initial conversation that you had with Mark Jensen.
The initial conversations are just basically, well, what are you in here for? What happened? You know, things like that. The conversation, he told me that he got his bond revoked because of Edward Klug's letter, or he came forward and said that he wanted to poison his wife, and they revoked his bond for that. And then we just started talking from there.
And did Mr. Jensen seem upset with Mr. Klug?
Yes.
And what was it that Mr. Jensen said to you that caused you to believe that Mr. Jensen was upset with Mr. Klug?
Well, he said it was, excuse my language, said it was bullshit, and then he was just an attention getter, and he, why would he come back 9 years later and say anything, or 7, whatever years it is, and say anything about it now, that he's lying, things like that.
And by the way, when I'm asking you to quote something, even if the language was the language that might be acceptable in a prison and not in a courtroom, you're supposed to quote the person exactly if you can. So how did you respond to what Mr. Jensen said to you?
I basically asked him, well, why would he come forward? Why would he say anything as to that matter?
Now, at the time that you were having this conversation with Mr. Jensen, was it your intention to try to utilize this information in some way against him or to your benefit?
Not in the beginning, no.
Well,
it was just general conversation.
Okay. So what else did you and Mark Jensen talk about at that time?
At that time, basically, we just kept talking about the Klug situation and what happened, and he let me read the Klug transcripts from the court proceedings.
Well, did he ever ask you what you were in there for?
Yeah. And I said I was being revoked on my extended supervision.
Did you tell him what you were being revoked for? Did you tell him anything about your prior criminal history?
Yeah, I did. I told him that I was, had served time in Lithuania for the visa fraud, and I told him about the home improvement fraud because he owned a construction company too. So we went into conversations about that.
Well, tell us about the conversations you had about the construction industry.
Well, we have a couple mutual friends that we didn't know at the time knew each other, and we were just talking about them. And we talked about my case as far as, what I was there for is like the new case in Racine that I was being charged for supposedly taking a deposit and then not completing the job. And it was just general conversations about that. I don't know the exact details of the conversation as far as what words were used when we talked about the case, but we just basically, I told him everything I was in for.
So when you were first talking with Mark Jensen, would you say the conversation was predominantly about the things that you had in common, or was it predominantly about his case? Or
in the very, very beginning, it was things we had in common. Then it moved on to the case because the Klug thing came up.
And how long after you commenced talking with Mark Jensen was it before the Klug thing came up?
It was the first day, and I believe I got into the cell block around 6 o'clock, and lockdown's 9 o'clock, so anywhere in that 3 hours.
6 p.m. and 9 p.m.?
Yeah. It was towards the end of it.
And so he was telling you in his words that it was BS.
Yes.
And how did you respond to that?
Well, I responded by, why would they come forward? And then he gave me the transcripts to let me read it. And that was it. I said, well, I said, it is what it is. It's.
So when did he give you the transcript to read?
I believe it was that night. That night he gave it to me.
And it was a transcript of Ed Klug's testimony at the forfeiture hearing?
Yes, it was.
And
About the commercials, a couple of these I gotta just stop the screen share just because of what's in the background. What do you guys think of Dillard so far? We'll get this back up as soon as this commercial is done. Curious to hear your thoughts on Dillard so far.
that entire transcript?
Yes, I did.
And that was before lockdown at 9 p.m.?
Yes.
And where was Mark Jensen while you were reading this transcript?
In the day room, and he gave it to me, and I went in my bunk. It's maybe 10 feet away is the distances.
Do you remember how long you spent reading the Klug transcript?
Roughly in 45 minutes, an hour.
And after you finished reading it, did you have any conversation with Mr. Jensen?
Yes.
And did he initiate that conversation with you, or did you initiate it with him?
Well, he gave it to me expecting a response from reading it to see what I thought of it.
Well, what did he say to you when he gave it to you to read?
Well, he just says that, he was looking for what I thought, what my opinion of it was, if it was anything that was credible or anything like that.
So he was asking your opinion regarding this testimony.
Yes.
And so you read the testimony?
Yes.
Did you tell him what you thought of it?
Yes.
What did you tell him?
Well, I told him that you're pretty much fucked. And because of the words that were in there, he told Klug all this, and Klug was making phone calls to his secretaries or his wife. And in the testimony, he said that he spoke, when he got back to the office, he spoke to his secretaries or somebody at the office, and said in the thing that he told them what happened. And I said, if they corroborate that story, I said, you're fucked.
And how did Mr. Jensen take that news?
Well, he kept saying that Klug was an attention seeker, and that's basically it, that it's all bullshit, and that's the way it was. You said you wanted quotes, so I'm sorry.
I want to hear exactly what he said and exactly what you said. So when he was making these statements about the Klug statement, how did you respond to that?
Well, like I said, I told him you screwed, that, if they corroborate that story, then there's nothing you can say about it. It's you did it.
And how long did that discussion persist?
Well, until lockdown, and then it started up again the next morning.
So tell us about the last exchanges that occurred between you and Mr. Jensen before lockdown.
It was basically exactly what I just said. It was just, you're screwed. And then he would tell me how he's an attention seeker, and that he says it's all bullshit, that this never happened, and to that fact.
Now, at the time that you were talking with Mr. Jensen, was it your intention to relate your honest impressions, or were you trying to scam him or con him in some way?
No, I was telling him the truth, what I thought about it.
You had not at that point thought that maybe there was something you could use in this case?
Not in the beginning, no.
Okay. Well, then you woke up the next morning?
Mm-hmm.
And how much time elapsed after you woke up before you and Mr. Jensen started talking again?
Well, I mean, it's a small pod, so it was pretty much right away. Everybody talks in the morning. But as far as conversations regarding this case, I would say about 10 o'clock in the morning.
And who initiated those conversations, you or he?
Both of us. I believe it was just a mutual thing. We talked, and we blend into every conversation.
When you and Mr. Jensen were having this conversation, Were you in the midst of a group of inmates or were you off by yourselves?
Most of the time we were off by ourselves,
Where were you?
in the back of the block.
And what's in the back of the block?
It's just the wall, where the heater vent is, and it's just away from the TV and the tables.
Were you sitting or standing?
Both.
So there are chairs back there?
No, you'd sit on the floor. You just, it's jail.
sit.
You make do.
So this conversation started up again 10 o'clock the next morning.
Yes.
And tell us about that conversation.
Well, the conversations basically pertain to the Klug testimony. Sorry, I keep mistaking his name, but pertain to the Klug testimony. And as far as, what I really thought about it, and then it just kind of blended into, what do you think I can do about this? What can I, how can I get around this?
And Mark Jensen was asking you that?
Yeah.
And how long after you started talking with him the next morning was it that this issue came up where he said, how can I get around this?
I would say noonish. Through the conversation, they're long conversations, so blended time, I'd say a couple hours.
So he was asking for your advice?
Yeah.
Do you have was there any information you conveyed to him that should reasonably cause him to think that you were a good person to talk to about this?
All right, let me pause this for a second. So Jay Bean over on YouTube asks, why does Jensen need a jailhouse person to agree with him? So for those of you that have never been to jail, so there are a few things here. So they're talking about this cell block, right? This pod that they're in. They're probably, I'd show you guys, but my house is a disaster zone right now. They're probably the size of my tiny ass little apartment, really small. You walk into a pod, you'd have a metal table with, a few chairs, like benches. You probably only fit like maybe 5 or 6 people on there. You'd have a TV. They used to have the bubble TVs. Now they do have flat screens. Most of the pods, flat screen TV in there, and then a tiny little shower thing, little tiny area for a toilet. Each jail is different, obviously. There's really not a lot of room. The way Kenosha County is set up, their detention center. So you'd have like this, you'd have this pod, and in between, like if you're staring in one direction, it's like this big glass window, and there's like this room where the COs sit, and you can see into the next pod. Very, very tiny. So, and people have a tendency to talk to each other about their cases. They have a tendency to show each other, their jail paperworks, their arrest paperworks, criminal complaints, whatever discovery that their lawyers would have given them. And, everybody becomes, a jailhouse lawyer. Everyone is a criminal, right? So everyone has these kind of fantastical brains of how to manipulate the system. And, there's a lot of times, I'll be honest, there is a lot of times that people in jail have some very clever ways of manipulating the system and destroying, the state's chance at something, right? They may not have had a similar crime, but there's similar situations when it comes to certain types of evidence and how to get certain evidences suppressed. So you may have a situation where, let's just say for argument's sake, Jensen's talking to Dillard and there's a piece of evidence and Dillard says, hey, in this case I was fighting 5 years ago, we were able to get this evidence suppressed by using this scenario. And then Jensen would go and call his lawyer and be like, hey, have you looked into this type of scenario to get this piece of evidence suppressed? So there's situations like that. So it's very common. And the other thing too, if you guys remember, right, kind of in this time era, right, there was a lot of jailhouse snitches that were jumping on cases. There were a lot. So, keep that stuff in mind too. And because we're going to kind of marathon stream, a lot of this 2008 footage for you guys, so you understand some history behind this and you can kind of compare 2008 to modern day. We're going to see several jailhouse snitches that come forward. one of them that will end up showing, this is where there's allegedly a conspiracy or a plan to kidnap Ed Klug to prevent him from testifying in the 2008 trial. So we're gonna see a jailhouse snitch that testifies to all of that, and he's another one with a pretty ridiculous criminal background. So that answers that question. A little long-winded on the answer there, but trying to give you guys some full details.
Well, I mean, we talked about my Lithuanian stuff and just, I mean, we talked about a lot of things. So I guess he was just talkative.
And so he asked you, is there any way to get around this?
Yeah.
And what'd you say to him?
I said the letter is only if they don't corroborate what Klug said. If they don't corroborate it, then you're fine. But if they corroborate it, you're fucked.
And that was around noon, that conversation turned that way?
Yes.
Did you ever start challenging Jensen from your own perspective as to whether or not it appeared that he was being truthful with you?
Throughout the course of this day, it was towards the end of the day, yes, then I started challenging a little bit. But most of the information he was given, he was just talking about different things going on in the case.
Oh, what kind of things was he talking about going on in the case?
Well, he was laughing at you about your Benadryl.
Well, tell me about that.
He was laughing that he said you came in and put the bottle of Benadryl on the table and, said he poisoned his wife with Benadryl and antifreeze and things along that sort. And he was kind of laughing about, well, if I gave her that much Benadryl and I mix it with antifreeze, she'd be full of Benadryl, that kind of thing.
Okay, so he was pretty dismissive of my theory from the forfeiture hearing.
All right, so let me pause there. So this is crucial. So if you guys remember, we've been talking about on the stream that they really didn't fully know how Julie Jensen died. And we've seen some testimony in the modern day trial about Benadryl. We heard Joanne Klug testify to Benadryl and even Ed Klug for a portion there. And Joanne testified that she was looking some stuff up because she wanted to know how you could die from Benadryl. So when Mark Jensen got arrested in 2002, they suspected antifreeze and Benadryl. And in the bond forfeiture hearing in 2007, their theory had nothing to do with Paxil and Ambien. Nothing to do with that. Remember, there was a lot of shifts in the state's case. That's why, there's some stuff. I definitely don't think Mark is innocent, right? There's a difference between innocent and not guilty for sure. I don't think he's innocent. There's a lot of shit that is just super suspect about Mark Jensen. What I don't like is some of the evidence. What I don't like is some of the shit that the state did. What I don't like is questionable things. We're losing pathology reports. We got a pathologist that's not reviewing crucial investigative materials that he needs to make a determination. Falsely testifies in 2008. There's just a lot of weird shit. And that's Kenosha. For those of you that don't live in Wisconsin, don't know Kenosha, that's why we spend so much time investigating the Kenosha unrest from 2020, because there's a lot of bullshit that Kenosha does. It's a very corrupt city. But yeah, so that was a very interesting detail. It was all focused on this antifreeze and Benadryl. They later start shifting to Ambien.
Yes.
Did he say anything else about the Benadryl?
That the only Benadryl that he would use was, or in the house at that time, was gel caps.
He specifically said gel caps?
Yes.
So they didn't have Benadryl in liquid form in the house, according to him?
According to him, yes, that's what he said.
Aside from Klug's transcript, had he given you any other documents to read in this case?
No.
Did you ever see any other documents that he had in his possession?
No, I have not.
So this conversation where he was being dismissive of the theory that I had about the Benadryl, when did that occur?
That day, throughout the conversation from 10 o'clock on. So it was fairly early in the day.
So it was still in the morning or was it in the afternoon, or don't you remember?
I would say mid-morning, mid-afternoon, right there.
So what happened after he made these remarks about the antifreeze and the Benadryl?
Well, I mean, it was just, well, I questioned him, well, then how'd she get the antifreeze in her system, then that. And he says, well, I don't, he gave me this, what am I supposed to do? Hold her mouth open and pour it down her throat or stick a tube down her throat? He was saying stuff like that. And then trying to discredit everything about, he was proclaiming his innocence at that point.
And how were you responding to his proclamations of innocence?
Well, I kept, trying to give him, well, why would they say this, or why, how did it happen? How did she get it? And you're saying she drank it? What are you saying? And he would not give me a direct answer at the time.
Now, at this point, were you just playing devil's advocate? Were you just having a conversation with him, or what were you doing? Why were you asking him?
Playing devil's advocate at the time, just to try to find out and have a conversation. I thought it was interesting. Mark Jensen's an interesting guy.
And wasn't a whole lot else to do in that jail block?
Nope, there was nobody else really to talk to, anything like that. It was kind of a,
So as you and he were having this conversation throughout this day, where were the other inmates?
at the table or sleeping,
And where were you and Mark Jensen while you were having this conversation?
in the back of the day room.
Sitting on the floor, standing?
Yes.
So how long did that continue, where he was telling you his version and you were playing devil's advocate?
It happened off and on all day, but I would say in the course of that day, we probably spent about, I would say, throughout the day, 6-7 hours talking at least.
Was it hard to get Mark Jensen to talk to you?
I mean, as far as talking, no, it wasn't hard at all. He was he liked to have conversations. So
He liked to talk.
yeah.
Did you see him talking to any other inmates in the cell block at that time?
Not too much. There was only really one other guy. I mean, there would be general conversations, but as far as talking to anybody, there would only be one other person I think he would talk to.
Who was the other person he would talk to?
I'm not sure of his name. He was in cell block 6 or cell 6.
Can you describe the person that was in cell 6?
He was white, probably about 5'10", about 220 pounds, a little thicker.
All right, we gotta stop it on that. We don't want to get whacked. We're actually showing a basketball game. Probably gonna get whacked for the 2 seconds that popped up. All right, what do you guys think so far with Aaron Dillard? Does he sound believable? Make sure you guys like and share the stream out.
Well, how long did you and Mark continue to talk during the course of this day?
Like I said, about 6-7 hours at first. I mean, throughout the course of the day, because we get broke up for, you eat lunch and stuff like that. So, and then in jail, you take a lot of naps, I guess.
Do you remember any other specific factual representations he made concerning this case?
Yes. I mean, there was a lot of things that we talked about through the course of that day and the next day.
Well, tell me as much as you can remember about what you talked about during the course of that day.
The course of that day, it was in general, just I told him about the blood test because we were trying to find ways around things, and I said, well, demand copy. You said, because, oh, that's right. He told me about that you guys lost all the transcripts or all the paperwork from the toxicology reports and all that stuff. And then he was making comments about that. I said, well, then if that's true, then you can just make your lawyer order new blood tests and have your own blood work done. And if they can't produce the blood samples, that should be a pretty decent way out of it.
And how did he respond to that suggestion?
I believe he talked to somebody. He was interested in it, very interested, and he talked to somebody on the phone about it.
You didn't hear the conversation?
I didn't hear the whole conversation, but at the end of the conversation, I was like, did you tell him I told you? That kind of thing.
You were asking
Mark if he told him because I heard him talking. I said, you didn't tell him I told you.
Why were you concerned about that?
Well, I just, we were having a conversation. I guess I just didn't want to be a part of it at that time.
A part of the case?
Yeah.
When did this phone conversation occur?
That phone conversation, I believe, occurred. either the second day in the evening or the third day in the evening. I can't remember for sure.
Now, well, tell us, let's get back to the second day again.
Mhm.
He would tell you something and then you would challenge it?
Well, I would challenge it or agree with it either way. I would try to find out why he was saying what he was saying. I mean, it was more of an interesting conversation in the beginning. I was trying to see what he was about.
And were there any other factual representations or statements he made to you during the course of the second day?
Well, I mean, he was telling me that basically his wife was crazy, that she was insane, and that she would self-medicate herself, things like that, things along that line, that she was taking, what was it, St. John's wort, a lot of just things. She was keen on St. John's wort a lot. He said that word a million times. But he would talk about how she was just depressed all the time, things like that. And just,
Well, let's for a moment try to remember, think if you will.
Okay.
Mention, can you remember all of the drugs that Mark Jensen made reference to that he said that his wife was taking?
St. John's wort, the Benadryl, Literal, I think Literum, something for Mark's esophagus problem. Paxil, Ambien, and some other, I don't know the other ones. I think that was pretty much it.
So the information you got with regard to these drugs that all came from Mark Jensen?
Yes.
Nothing, no other source?
No.
And was that when was it that he started mentioning those drugs? Was that during the first, second, or third day, or?
I think it was the second day still. It was the second day because we were talking about, because in that day he was also talking about, like I said, as far as his wife being crazy, and she was nuts and she was depressed all the time, and she, yell at the kids and this and that, and he didn't know what was wrong, and she was self-medicating. That's was his saying she killed herself, that kind of thing at that time.
So how would you respond to that?
I would just say, well, I don't know, because I would talk about the Klug testimony and say, well, why could he come up with that one?
And how would he respond to that?
Well, basically it was that he's an attention seeker and that never happened. At that time, that's what he would say.
And how long, at some point, did Mark Jensen ever change his story?
Yes.
When did that occur?
On the third day.
When during the third day?
Well, we started talking again in the morning, and it just bled into that conversation about what happened. And I would tell him, I was telling him I'd think of what he could say or do, or, what I thought of the case and stuff like that. And then that next day, it just got into a little bit more deeper conversations about the kids and things like that, about how once he came home and one kid was naked in one room and the other kid was naked in another room, stuff like that.
He told you that?
Yes.
And that was during which day?
Third day.
When during the third day?
I would say from the morning to noonish, somewhere in there.
And how did that come up?
Well, we were talking about his wife being nuts again, and he was talking about the wife's brothers, committed suicide, or, it's just that suicide ran in her family and all of them are nuts and everything along that line.
So he was telling us all about the Griffin family?
I didn't know their names at the time, so.
Julie's family?
Yes, Julie's family.
Did he ever say anything to you about Julie that would cause you to think that he in any way regretted her death?
No.
Did he ever tell you that he missed Julie?
Never.
Did he ever express any emotion at all when he was talking about
I
Julie?
object to the relevance.
It doesn't, overall, or sustained.
Did he ever, at some point, did Mark Jensen's explanation to you of what had occurred in this case change?
Yes, the third day, if I'm understanding the question right, is you asked if he changed his view on what happened.
Changed his story to you about what
Yes,
happened?
yes.
When did that happen on the third
The
day?
third day, more towards the middle afternoon. That's,
So you and he had been talking the whole day?
yeah, on the third day, we talked a good chunk of the day.
And tell us about the conversation that led up to this point where Mark Jensen changed his story about what had happened.
In the evening, that's when it started when he started talking about him saying that Julie was crazy and about the kids being naked in one room and this, and how he would snap on the kids in she would snap on the kids in restaurants and just yell all the time and just go crazy at odd points. And then he started getting a little bit more.
Stop. When he was telling you this, was this during the second day or the third day?
This is the third day, as far as that, about the kids naked and that.
When in the third day?
That I told you, I believe, was between 10 and 12 in the morning when we were talking about that stuff.
Okay. And how did you respond to what he was telling you?
I mean, I just kind of was like, well, wow, what's going on, And then that's when he told me she was crazy, kept going on. She was crazy. She was insane. She'd do all this stuff. She would, he said he wanted her to get a job. He wanted her to get a job, something like that, that he wanted to get out. So she would try to loosen up and go out with people, that he would try to convince her to go out with friends, and they would go places, things like that. And I would be like, well, why does she act like that? And he goes, well, that's why she was self-medicating herself, is to try to stop doing these things.
So you were asking questions and he was explaining the answers.
Yeah.
And so what led up, how did the conversation tend in the direction where he changed his story about what had happened?
Well, that's when we were talking about the kids being naked in one side of the room and the other side of the room. And then that's when he started getting a little bit more emotional about everything.
How did he start getting more emotional about everything?
Well, I mean, it seemed like he was getting more into his feelings when he discussed his kids.
What was it that you saw about him that caused you to think he was getting more emotional?
He was a little bit teary-eyed, just, glassy-eyed, things like that.
When he was talking about his children?
Yes.
What happened then?
That's when the conversation progressed a little bit more. And then, basically the whole point of where we said, I said, everybody has their problems. I mean, I think, that's where the point came up where I said, I think you did it.
Well, tell us about what you said to him when you confronted him in that fashion.
I believe my conversation went into the line of, well, we all did something, to get where we are, and, you did it. And then he proceeded. That's when he said, well, yeah, we all have situations.
He said, we all have situations?
It's something to that line. I don't know the exact words that were said. It was, this is how many months ago that the conversations were.
And so he said, well, we all have situations. And how did you respond to that?
I go, yeah, we do. And then we all did it to get here, and I implied that he did it.
And how did he respond to that?
That's in the point. And he just was like, yeah, yeah, just simple answer.
And he said, yeah. And then what did you do?
Well, then the conversation proceeded of, well, then, Mark, how did she get the antifreeze? And then that's where the conversation turned into where he started explaining what he did.
Tell the jury what Mr. Jensen told you about what he did.
Mark Jensen said that this is the conversation out of his mouth for what happened to that. He said that they went to the doctor because she was really depressed and things like that. And that when he went to the doctor, they gave her Paxil. And then they came home, she took the medication. And at that point is when he said that she got loopy because she took Benadryl, Paxil, and then I think it was the Librium at that time. And that she got real loopy and this and that, and she wanted to lay down. She just was real tired. So he gave her juice to drink. And that was when he told me at that point it was mixed with the antifreeze.
Did he tell you how much antifreeze and how much juice?
No, not exactly the amounts. He didn't go into detail about that.
Did he tell you what happened next then? By the way, when he said that to you, how did you respond?
I was just wowed. I was just like, that's the point where a lot of things changed.
What do you mean?
Well, at that point, I decided it was a way out.
You're hearing about a confession to a murder.
Yeah.
And you thought you might use that.
Yes.
So you started paying careful attention?
Yes, that's when I started paying a little bit more attention to everything.
So he told you about the antifreeze and the juice.
Mm-hmm.
And what time of day was this conversation was taking place?
After lunch.
Where were you located?
In the back, in the back of the cell block.
Were there any other inmates around?
Not at that time, but I was talking to another inmate saying, this guy's telling me everything.
Objection, hearsay.
Do you love Coldplay?
All right. Interesting. So these, because of Dillard's alleged knowledge of a confession, this is how the prosecution's theory changed. Remember, Julie died in 1998, and they had no idea what actually killed her. Everything was undetermined. Their shift in the prosecution's case with the suffocation and the antifreeze being mixed with juice, this all came from Dillard's alleged confession, jailhouse confession testimony.
Well, it strikes me that this particular comment is not being offered to prove the matter is the truth of the matter asserted. And beyond that, I would it strikes me as
And look at Schroeder.
excited utterance.
Schroeder is explaining so much law in front of the jury.
So who is this inmate that you're talking to?
What's up,
Deanne
Tara?
Hardison.
Welcome.
How'd you know Deanne Hardison?
We rode on the bus back from prison together, or from prison to jail together.
Where was Deanne Hardison when these conversations were occurring between you and Mark?
In the day room or in his cell.
Did you ever see, what did you say to Deanne Hardison besides, this guy's telling me everything?
I was like, I was trying to get him to come out and listen to what we were saying.
Deanne Hardison?
Yeah.
And did Deanne Hardison attempt to come and listen to what was being said?
Yes.
And what would happen when he would do that?
Basically, the conversations would stop.
Mark would stop talking
Yeah.
until Deanne Hardison moved away?
Yes.
And then would Mark start talking again?
Yeah, we would go back into the conversation.
So after Mark had made this first statement to you
Mm-hmm.
about the antifreeze and the juice,
Yeah.
did you at that point go talk to Deanne Hardison, or did you just continue to ask Mark Jensen questions?
It was still more questions asked, but in that time frame within 20 minutes, I was saying, you got to hear what he's saying.
And after Mark Jensen told you about the juice and the antifreeze,
Mm-hmm.
what did he say next?
That night he said that she went to bed and then she was acting all drunk and jumping around on the bed. And he was kind of laughing about it, like, the fact that she was acting drunk and being stupid and stuff. And that's when they went on to the computer and checked the side effects of the Paxil.
He told you he did that.
Yes.
And did he tell you why he did that?
To confirm that it was a side effect of the Paxil, so she would calm down.
So she wouldn't think she was being poisoned?
Objection leading.
Sustained.
Well, did he explain to you why he wanted her to calm down?
He didn't explain it. He just said that they went online and checked the side effects, to prove to her that it was a side effect. But as far as him telling me why he did it, there was no why, specifically why he went to check the internet, just to comfort her, I guess.
What else did he tell you after that?
At that point, that's when he told me, that she went to sleep. And the next morning is when he went to the doctor and got her Ambien. Or he went to the doctor and told the doctor that she was up all night and she was wired and she couldn't sleep and things like that.
And did he tell you what the doctor gave him?
Yeah, he gave him Ambien for sleeping.
And did he tell you what happened after that?
Yeah, that's when he came home and he gave her an Ambien that morning so she could sleep. Did
he describe to you what Julie's condition was like when he came back from the doctor?
I'm not sure if he described it at that moment, of when he came back, but throughout the course of the day, he said he gave her the Ambien, she slept, and then she started throwing up that day.
And did he tell you what he did about that or where she threw up or anything like that?
No, he didn't tell me where she threw up. I would have to guess it was a bathroom or a garbage can or something. I don't know at that point.
Well, what did he tell you then about that after she'd been throwing up?
He said that she couldn't keep anything down, that she would throw up and they would try to give her water and she would throw that up and she was just having throwing up a little more than usual. And then that night they were all laying around and she was in bed and that the kids were there. The kids were laying on the bed with them and they were watching TV and things and that she just didn't feel well and she was really, really drawn out.
And did you say what night this was?
This was the next night, the first night when he gave her the Paxil and she was jumping up around on the bed. Then the next day, this is the second day of it was the point where she was just laying on the bed and couldn't, just was real lethargic, just laying there, very sick.
And what did he say about where the children were?
They were laying on the bed with her.
Trying to comfort their mother?
Yes, because she was very ill.
Did he tell you anything about how the children were responding to their mother being so sick?
All right, I'm going to pause this real quick. I don't know if you guys caught some of the inconsistencies that we've talked about before on the streams. We know that the Julie's doctor, right? We know from this original trial that Julie went to go see the doctor and was concerned about some mental health issues in the family, alcoholism, this and that. She was acting a little crazy, and the doctor prescribed her the Paxil and Ambien. This guy's testifying that Mark went to go see the doctor. The little excerpts from the doctor, that's not what was told. And we also described, we went and we researched Paxil, we researched Ambien. Both those drugs came out in 1992. And when they originally came out, the initial dosage that they were prescribing people was a pretty high dosage for those medications. And you got Dillard right here testifying that she takes this Paxil and she's jumping around the bed, right? And when we went into the detailed history of Paxil and Ambien, that is not a side effect of the Paxil. There's a lot of psychomotor impairments that happen with those things. So little bit of a discrepancy here, something I picked up on. I don't know if you guys did. So I don't necessarily believe this part of the testimony.
They were very worried and that they wanted her to go to the hospital.
Tell us about what he said about the children wanting her to go to the hospital.
Well, he was saying that they were pushing an issue that mom's got to go to the hospital, things like that. And he would say, well, if she's not feeling better tomorrow, we will, things along that line, that she's just sick.
Did he tell you what happened then after Julie had been laying in bed watching television with her children?
That night, he said that they put the kids to bed, he put the kids to bed, they went to bed. And that night she was pretty bad. And the next morning she came in and she was breathing really hard. She was just couldn't really raspy, things like that. And that night he also, he gave her more Ambien that night to help her sleep.
Did he ever say anything about giving her more juice or antifreeze?
Yeah, that night he did. He gave her more.
When did he give her the juice and the Ambien? The juice and the antifreeze?
I believe he said that was when she was laying down in bed before the kids. That's because she was throwing up all the time. And then for throwing up, that's when he gave her the next glass of juice.
And did he say where the children were at the time that he administered that glass?
No, he didn't say that.
So, see, I think you said he took the children to school or something. Tell me about that.
Oh, that's the third day.
Okay.
Yeah, that's the third day. The next morning when she woke up, she was breathing really raspy and really hard. And she said that she was really labored breathing and she was having a hard time, and that the kids wanted her to call the ambulance for her.
His children wanted to call the ambulance for the mom?
Yes.
And did Mark tell you how he responded to that?
He told them that if she wasn't better by the time they got home from school, that he would call the ambulance.
He was telling you this?
Yeah.
Well, what did he tell you next?
Well, at that point, that's when he told me that he took the kids to school, and then that's when he came home and she was breathing better, or he did something for work, and then he came home and she was breathing better.
What did he tell you? Do you remember as you're sitting here now, did he tell you what he did for work?
Stockbroker.
But you said he did something for work. Did he tell you what he did for work?
I think he said he met a client. Something about meeting a client.
And what happened then after he did this thing for work?
He came home, and that's the point when he came home and she was breathing better. And he said that he got really nervous. He got scared.
Did he tell you why?
Well, she was breathing better, and he didn't think she was going to die
And why would that scare him?
because the kids wanted to take her to the hospital. And if she wasn't better by the time he got home, that's where they were going to go.
Did he tell you how he responded to this?
As far as her breathing better,
What did he do when he came home and found that she was breathing better?
and that's the point when he rolled her over and sat on her back. And
Did he describe to you how she was, what position or condition she was in when he got home?
no, he didn't describe that. He just said that she was breathing better and that she was still sleeping, but she was breathing better. And it wasn't so labored. It didn't seem like she was having as hard as a time breathing.
So what did he tell you that he did?
That's when he said he rolled her over and just sat on her back and pushed on her neck into the pillow,
Push what into the pillow?
her face and neck.
Then did he tell you what happened?
Said she died.
He suffocated her? Did he use the word suffocate or not?
No,
Did he tell you how long he had to sit on her and shove her face into the pillow?
he didn't give me a time.
What was his demeanor while he was telling you this?
Through most of the conversations, as far as this part, his demeanor was nothing. There was no emotion. There was nothing.
Were you able to tell, or did he ever indicate to you why he was telling you this?
No. I'm just, if I had to assume, I think he's just needed to talk. He wasn't in
Objection to any
jail.
assumption by this witness of anything.
Over how long a period of time did this conversation between you and he, where he was telling you what had happened, over how long a period of time did that conversation take?
This one took probably about 2 hours for that part, I would say, just to go through it all because there was little breaks and I would tell Dion to come out.
And after he told you this, after he told you what he'd done, did you have any further conversations with him after that?
This was the third day and I left that morning at 6 a.m. But the conversation just pretty much just after that point, it was getting, lights out. So everybody kind of broke up a little bit. And I said, I talked to him in the morning. And that morning I actually got transferred back to prison, which I didn't know I would.
So you never talked to him again after that?
No, it was kind of an abrupt end to our conversation.
Can he tell you what happened after he killed his wife?
Yeah, he brought the kids home from school. He went back to work. And then I believe he picked up the kids from school. And when he came home from school, he said he made the kids wait outside, and he said he'd go in and check on their mom.
So he didn't want his children to see their mom dead in that fashion?
I believe so.
Conoce a la futura mamá.
All right. So we're going to marathon stream a lot of these Jailhouse Snitch testimonies from the 2008 trial. So right now we're listening to Aaron Dillard, supposedly, I can't talk. You guys know I can't talk. Supposedly, Jensen confessed to Dillard exactly what happened and how he killed Julie Jensen. We're going to watch testimony from another Jailhouse Snitch. Allegedly, there was a conspiracy or plan for Jensen to kidnap Ed Klug, who we heard testify Friday. Jensen was planning to kidnap him to prevent him from testifying. So we're going to hear from another Jailhouse Snitch named David Thompson. Kind of another long one here. We're listening to Aaron Dillard talk about another Jailhouse Snitch named Dion. His name is Dion Hardison. So this is somebody else that kind of overheard some things with Jensen. So we're going to listen to him. And we got quite a few more. We have Bernard Bush. So we've heard that name through some pretrial motions. So we're gonna listen to that. Then we have another Jailhouse Snitch, Frank. I gotta watch this video. So it's either Frank Quintana or Brad Montgomery. I gotta see. I haven't clicked on this video yet, so I'm not sure which name associates with the prisoner. There's another. I think there's one more. Whenever this case is done, so it's expected to last 5 weeks, right? Whenever this is done, and they're going to get ready for sentencing and verdict and all of that. So whatever day that is, we're going to play you guys the prosecution's closing argument, the defense's closing argument from 2008. We'll play you guys the verdict, the sentencing, and then the impact statements from 2008. So be prepared for that towards the end of this trial, the closing up of this trial. Let's take some comments here. So Jennifer over on Facebook says he sure has a lot of details. That says, I thought snitches get stitches. He was sure housed with a lot of them. Yeah, there's a lot of jailhouse snitches that came forward. Now remember, again, during this time, folks, there were a lot of jailhouse snitches that were jumping on people's cases, trying to get their sentences reduced or completely gone away. Dillard was one of those. He's facing 4.5 years in prison for his crimes. And he ended up getting an entire 4.5-year sentence, completely taken away. Jay Bean over on YouTube says she was throwing up. I don't buy the Ambien and Paxil BS. So what do you guys think? I don't know. There's a couple of things with Dillard so far for me that I'm just like, I'm not sure. However, having some knowledge of the jail system, unfortunately, some firsthand knowledge, people talk about their cases and they talk too goddamn much. So I don't know. We'll see. What do you guys think? Put in a chat, put a number 1 if you think Dillard seems to be credible, or put a number 2 if you think he's not credible. We'll see how Craig Albee responds when there's the cross-examination. Here's what I think for the modern day trial. We have seen so far in today's version of the trial that Jensen's defense team is going for the jugular with every single witness. We've seen them destroy the pathologist, Michael Chambly. We saw them challenge very hard with Joanne Klug. Had her in tears. I kind of felt a little bad for her. She was in tears in a few of those questions. Kind of made me feel bad for her. But they are going for blood. And what's interesting, keep this in mind. So imagine if you were on the jury, right? You obviously are going to have some prior knowledge of this case if you're on this jury today. But a lot of these witnesses, Julie died in 1998, and people are not coming forward for nearly a decade with this crucial information that helped convict him, right? So there are some, maybe a little bit of doubt as to, did this information actually exist at the time, right? There's too many people. I could buy it with Ed Klug where he's like, I'm not sure. I really want to get involved. He's kind of going through this moral dilemma. He's like, I don't know. I'm really not sure. But we've heard it now from several witnesses that didn't come forward for nearly a decade. For me, that's just too many people that are just suffering from moral dilemma about, do I say something? And keep in mind that he's charged in 2002. The criminal complaint would have come out. You would have had tons of news articles. Mainstream media, would have been covering this on TV. And a lot of these details would have come out. And here, all of a sudden, nearly a decade later, now these people are jumping on this case. A lot of this stuff the year prior to the 2008 trial, in the 2007 forfeiture hearing where they forfeited his bond, there was testimony, that these people again were not giving, and it was a whole nother year before these people's testimony was coming out. There's inconsistency with their testimonies, and we're watching Jensen's current defense just absolutely rip these people apart. Jennifer over on Facebook says, I'm still unsure if I think he's credible. Brittany says, I think he's credible for the most part. Christine says, so far, I kind of believe what he's saying. I kind of believe what he's saying too, except for a couple little spots. It makes me kind of question some stuff, but I am trying to keep an open mind. Keep in mind, there's, not guilty and guilty verdicts. And then there is literally somebody's innocence, which is different from guilty or not guilty. I definitely don't think he's innocent. There's some culpability there. I think he was definitely tormenting her, about the affair and that she had, all of that stuff. A lot of manipulation, a lot of narcissistic stuff, some gaslighting going on, and just being an absolute prick. I do believe that. We saw from the, a previous stream, we kind of showed a little bit of a clip of his interrogation in 1999 with law enforcement. And he does say in that interrogation, she's suffering, she's not doing very well, she's basically dying, and I just sat there and watched. I didn't do anything. So could there be some lesser involved charges? Could there be manslaughter, reckless endangerment, things like that, right? I'm not sure if he's guilty of murder yet. There's some things that I've questioned, that I've picked up on, but he's definitely not innocent for sure. All right, here we go. Back to Dillard's testimony. Thank you guys for tuning in. This is fun. Glad we're able to show you guys this stuff. So you guys are getting a little bit of background details that the rest of the world is not getting because they're not on this stream watching. Here we go.
After he'd started telling you this, what had happened, did he ever make any reference to attempting to poison her on any previous occasions?
Yeah, this was actually in the beginning of that conversation. That's where he said he really fucked up there, because if she would have died, he said he tried poison her before he went to a meeting in whatever, I don't know, some stockbrokers meeting, and he said he tried poisoning her before that, and that she had thrown up all over the house and had trails of vomit through the house, and that she just covered it up with paper towels, and that left it for him when he got home, and he had to have the carpets cleaned and all that.
And how did you said he described this as he messed up?
Yeah, he fucked up. That's his words. He fucked up and said that he mouthed off. He was drunk and mouthed off to Klug.
So he did tell you that.
Objection leading.
Overall,
So he did talk.
prior answer.
So he did talk to you about Klug,
Yes,
and he'd also changed his story about Klug. Then
yes.
tell us what he said to you about Klug.
He said that he would have been really fucked if she died that weekend.
Did he tell you why?
Because then he had mouthed off to Klug and he would have came forward right away.
Did he then go back into this conversation with Klug at all with you or not?
That's just at the point where we were starting this whole conversation, the conversation about how when he started saying he did it, and that's when he told me he fucked up with Klug and mouthed off to him when he was drunk. So there wasn't a lot of conversation about it, but he said that he's glad it didn't happen then, and that she was because he was going in throughout this conversation, he was going into his defense about how he was going to combat everything you guys were saying about him, and throughout this conversation, he had said that he was glad. That's when the Klug thing came up, that he was glad that she didn't die then, because he was going to make it look like she practiced it and got sick and couldn't go through with it. And then he also told me at that point about the defense, about there was pictures of antifreeze in his house that you guys were saying that he said that the detective said that you did it, Mark. There was no antifreeze here, and she had to get antifreeze somehow. You took it away. But he was saying that he's got defense of that as far as this, that he's got pictures that show the antifreeze in the house that you guys took. So he was combating that. And then he was saying about the Librium, that how she would always get his prescriptions refilled, that he would never call the doctor, that she would do it all the time and go pick it up herself. So he was telling me how he saw all his defense to how he was going to combat it all.
Oh, well, did he tell you anything else about the defense?
I broached the internet subject with him, and I found out, well, I was asking him, what's with the internet, because this came up throughout the conversations.
Objection 971-23-1B, I believe.
I don't smell any pizza yet. Well, I guess we'll take we're going to take a short break that may turn into a long break. So let me ask you to step out, and please don't talk about the case.
Please, all right.
Judge, just off the top of my head, I have no recollection of ever seeing any notice, summary report, or anything else. Mr. Dillard discusses computers. And if I'm wrong, fine, but I just don't have a recollection of that.
What's up, Mr. Jamboys?
Well, I don't have a recollection of it necessarily either. I know every single thing this witness has to tell us about what, I know this, anything that I've got in documentary or recorded form regarding Aaron Dillard's statements have been turned over to Mr. Elby, but I don't know that that's a legitimate objection.
Well, it is if any oral statement of the accused which you plan to use at the trial. So whether it's in documentary form or not, if you have foreknowledge, then.
Oh, I understand that, Your Honor. And what I don't know, as I was sitting here asking a question, and as he started talking about that, I didn't know what he was going to say, but excuse me for a moment. My co-counsel has a much better memory than I do, is pointing something out to me. Well, there was discussion. This witness has given, there was an interview that was done with this witness on October 10th, 2007. And counsel, I'd direct your attention. There was talk about the computer, and it's bottom page 24 and the top of page 25. But I don't know what this witness was going to say. And I guess what we could do, Your Honor, is voir dire the witness on this outside the presence of the jury. And
well, let's start with, there was apparently some written document.
there was a statement provided, a transcript of an interview that was done with Mr. Dillard on October 10th, and that has been provided to defense counsel.
And I provided it to you.
What's that?
We have our.
I provided it to you, right? Well, if you have your own, I haven't received that statement.
Oh, is this, well, here's what I'm looking at. Is
It's
this what
the
you gave
same
me?
thing. No, this is what they gave us, and it's the same thing.
Oh, what
Page, but if there are any differences, I should have your transcript as well.
It's page 27 and 28.
In other words, this was supplied on some kind of an audio, either a tape
Right.
or a CD, and you made two separate transcriptions, the state's and the defense?
Apparently.
I do move for any transcripts that I don't have.
No, I don't think so. A transcript is merely what someone heard and wrote down. The audio recording is what has to be produced, not what somebody thought was on the audio recording.
I think to the extent that they rely ever on a transcript, and I think.
All right, and I was just going to say, I maybe he'll produce it. That's fine. I don't want to get bogged down on that. The bottom line, though, is if there's a feud about it, I don't want to get too involved with it, because it strikes me that what has to be produced, if they produce the audio, then it's after that, it's just a matter of how people hear it.
And that's what we did. But I don't have
Does
any
it refer
problem.
to this issue that is now being discussed by the witness?
The transcripts they're different transcripts, but they're the same conversation, Your Honor. And
No, but either way, does it refer to comments attributed to the accused during the discussion that the witness is indicating about usage of the internet.
It pertains to usage of the computer, but I don't know what the witness is going to say, Your Honor.
All right, so then,
Well,
he's claiming that he has no foreknowledge.
which is a little difficult for me to understand because my recollection is that the question is, did he say anything about the computer? And throughout this direct examination, to Mr. Jamboy's credit, he seems to know exactly what's going to be coming, which is what I expect. And he certainly seems to anticipate some particular answer about the computer. So that's why I object, because it seems to be calling for something specific that I haven't been advised of.
There was reference to the computer in this previous interview. Your Honor, I don't have that world's greatest memory, as you know, and I don't, although I anticipate the general line of this witness's testimony, as you know, he's not reading this from a script. And this isn't scripted out. You just don't know what a witness is going to say. So I would not presume to suggest that I know what Aaron Dillard is going to say on the witness stand.
Right, is it your representation that you do not know what he's going to say and that you haven't previously discussed it with him?
No, I've not talked to him at all.
Or anyone under your control?
I mean,
whose conduct is imputed to you?
That's true.
All right. Did you have anything further?
Well, the one portion of this transcript in which there's mention of a computer is discussion of using, of there being software in which you can either work from home or the office or vice versa. But there's no timing. There's no timing on that, and I don't think it's relevant.
There's no timing on that.
No timing as to if there's a claim that it says, but he also knows about software that he can be in his office and use his home computer to do stuff. There's no indication of that there was a statement that any such thing was ever used prior to December 3rd, 1998. It doesn't have any relevance.
Your objection was based upon a lack of notice, and I'm not hearing anything that would cause me to embrace your objection.
If it goes beyond that, then I still have the same notice objection.
If it goes beyond the software?
Beyond this.
The bottom line is all that the district attorney is obliged, now correct me if I'm wrong, all that the district attorney is obliged to disclose to you is a summary of any oral statement attributed to the accused, which the district attorney plans to offer at trial. And so it would have to be something of which he or someone under his control had knowledge. Now, where am I going wrong?
Well,
Just a minute, let him answer if he wants.
Maybe we can resolve this.
All right, you can resolve it.
I'm not trying to trick anybody or pull any surprises. I'm willing to have the witness talk about this outside the presence of the jury so that we can allay Mr. Alvey's concerns that the witness is going to have some cataclysmic thing to say that hasn't been disclosed to him. Let's find out what the witness has to say, because I don't know what he's going to say.
Well, that means we have to hear it twice if it's.
That's true.
And I would rather not do that, but I suppose it's your trial. Go ahead and ask some questions, but I don't want to go too deep.
Is anyone else getting the same vibe that I am, that the jury is literally sitting here? Did I miss this? Did they remove the jury? I thought they removed the jury, but with this last comment, now I'm a little confused. Is the jury sitting here listening to this argument? What do you guys think? Did I miss something here? That's dangerous. If the jury is in there, that's dangerous. Something's wrong with that. So there's a little bit longer left in this portion. There's still like more videos that we got to click on to finish Dillard's testimony. There's a few videos, but I don't know. Did I miss something? Let me know if I missed something, but it sounded like the jury was here.
Into this because, go ahead.
What were you going to say for the objection?
I think it was talking about the defense. I think, is that what we were talking about? Is it what he was saying to what he was going to do to defend what you were saying against him? I
Yeah,
believe
no.
that's where we were.
I'll ask the reporter to read the last
About the
question.
internet.
Yeah, I know, but I mean, there was a couple of things about the internet, actually.
Well, tell us everything.
The first one is, in the meeting I actually had with you guys, I spoke to you and said, well, check the computer about to see if he had software that said he could remote access to log in from work and actually use his own desktop.
Okay, that's what you said.
That's what I was going to say about that. And also, we were talking about the hits on the internet when he was there, saying that about the hits, he was going to say that, well, Julie could have done it, that kind of thing. That's all I was going to add.
That was the defense, that Julie could have done it.
Yeah, that Julie, that he said he had one piece of information that he said that proved Julie could have done it. That's what he had told me.
Okay, and we'll go into that when the jury comes back, if the court allows. I mean, and let's remember this, it's 12 minutes to 12, and this jury's made it very clear. They've got pizza coming at noon, and they do not want to be delayed.
The last thing that I would do would be to delay them on their pizza. All right. Are we ready to go?
Yeah.
All right, the objection's over. Ask the jury to come in.
There we go. So I guess they were removed. Okay. That makes me feel a little bit better.
Please be seated.
All right, the objection's been overruled. Go ahead.
So, and I forgot what the last question was, which just goes to show what an impoverished memory I have, but I'd request the reporter read it back to the witness.
Question, well, did he tell you anything else about the defense?
Yes.
Answer, just, I broached the internet subject with him and I found out, I was asking him, what's with the internet, because this came up throughout the conversations too.
And then you were interrupted, so could you please continue with that answer?
I was going to say that as far as we were talking about his defense on the hits on the internet, as far as reference to poison and things like that, he was saying that you could go to any site and then there would be other links that just pop up. Like you could have went to a poison site 10 times and it would show because there was so many pages connected to it that there was this many poison sites.
Did he tell you anything else about the internet history or his defense?
He told me as far as that he had one occasion that he could prove that Julie was on the internet, because I think this came up at the same time. I was asking him, how can you prove like she was self-medicating herself? He says, well, I had asked him about, you were branching off the internet site, but
however you have to answer the question,
Okay, yeah, because the conversation was about, I asked him, well, did she go buy all the Benadryl, and do you have receipts that she signed that she bought the Benadryl with the debit card or anything? Because I was asking him about all that stuff because he was saying his defense to me. And he said he had one piece of information about the computer sites that proves she was the one on the computer.
Well, did he tell you what it was?
He wouldn't tell me what that was, but he said that to me.
Was this before or after he told you that he killed her?
This was after.
So he told you he killed her, but he wouldn't tell you what his defense was in that regard?
Not as far as the internet sites, but he was telling me everything, the points about the pictures of the antifreeze and, just simple things, but he did not tell me the actual occasion that he could prove that she was on the internet.
Did he tell you anything else about his defense that you can remember as you're sitting here now?
I talked about so many things. I don't know if I missed anything or not.
Okay. Well, is there anything else that you can remember about what Mr. Jensen told you that you haven't told the jury already?
Not that I recall. I don't remember everything we already talked about. I don't know if I broached every subject or not. So. And
you said, and Your Honor noticed that it's 6 minutes to 12, and I understand that there's an important deadline that we can't miss. And the next area that we're going into with this witness may take another 25 minutes.
Let's break it to a point, and let me ask you be ready to go again if everything works out all right at about 1 o'clock. Is that right?
Maybe 1:15, Your Honor?
Well, I was thinking 1 o'clock, actually.
Well, Your Honor, I'm just thinking they're wearing Packer garb and they're eating pizza and they may want to spend some more time than.
I'll let them vote.
Okay.
How many want to start? 1 versus 1:15? 1 o'clock? All right. I won't even ask you. All right, 1 o'clock.
Thank you, Aaron.
Oh, I'm over here talking to myself. I didn't even have my mic on, like an idiot. I'm over here talking to myself, guys. Here's what I said. We make mistakes here, people. We're not that bright sometimes. It's Sunday morning. I haven't had enough coffee, clearly. Here's what I said. Let me try to think back. I sound like the DA right now, Jamboy. I sound like him. I don't have a good memory. What did I say? Something like welcome to the stream if you guys are just tuning in, blah, 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 all that stuff. Share it out, like, subscribe, share, do all that fun jazz. If you're just tuning in to Facebook or YouTube, what we're doing, because we are live streaming the Mark Jensen Antifreeze murder trial, we're giving you guys some archived footage of what happened in the 2008 trial. So a lot of questions are being asked on a lot of different streams. Nobody's getting answers. Because they're not over here, unfortunately. So throughout our coverage of this trial, we've been giving you guys a lot of background, a lot of case history, a lot of details. We're talking about history of Paxil and Ambien. We're talking about the letter from the grave from Julie Jensen. We're talking about why Jensen was able to get a retrial, right? The confrontation clause under the Sixth Amendment was changed in 2004. We went through a very detailed thing about that. A website. I'm not going to repeat the website because I don't want to get banned on these platforms, but they referenced the website during the trial. Basically, it's, how to unalive somebody. The website is real, and we pulled it up. We didn't show it because, again, we're trying to not get banned, but we kind of read what the detail of the site said, which has a lot of spooky similarities to what Jensen is being accused of. So if you're on Facebook, share this out. All right. Like and follow the page. If you're on YouTube, subscribe, hit the bell for all notifications so you know when we go live and you know when we upload new content. YouTubers, go and follow the Facebook page. Facebook, go and follow the YouTube page. We have a lot of really cool, juicy, exclusive content about a lot of things, especially about Kenosha riots in 2020. I was there. We have the most exclusive video footage over on our YouTube channel for that. Body cam videos, video from inside of the Bearcats, a lot of stuff. Check out our website. Never.Stop.Voices.com. We have a lot of articles up there. We get a little naughty on this platform. We do say cursey words, especially in the morning, coffee and naughty words. So here we go with part 2 of this. This is a great time, guys, to be asking your questions because the trial is not live. They're not going to be here Monday, so we're going to play some more archive footage. Today, we're going to marathon stream all these Jailhouse Snitches. Monday, we're going to stream the pathologist, Michael Chambly, because he got destroyed by the defense team. So we're going to play you guys the original footage of that. I know a lot of you are interested in the mistress, Kelly Labonte. We are going to play her testimony as well. So you guys are interested in that. We're gonna see what Kelly has to say. If you like what we're doing here, check out the pinned comments and links that come through in the chat. Great ways to support the platform. All right, here we go, guys. Thanks for tuning in.
Thank you, Your Honor. Mr. Dillard, you said the morning after Mr. Jensen made these disclosures to you, then got moved back to an institution.
That's correct.
Which prison did you get sent to?
Dodge Correctional.
Now, did you ever write out your recollections of the things that Mark Jensen had told you?
To my lawyer, yes.
And was your purpose in that letter to recount every single thing that Mark Jensen had told you, or just enough to give her an idea what had happened?
Just enough to give an idea what had happened.
And what was your purpose in writing the letter to your attorney?
Just to get the communication started with you.
Your Honor, request that this document be marked as an exhibit. This is, you've seen this one. Let's put it right in here. So, thank you. How much time elapsed? Well, strike that. Where were you when you wrote this letter to your lawyer?
DCI.
You were back at the prison system?
Yes.
And what day was it, or how many days was it that you were back there before you wrote this letter?
I would say it was within a week.
So at the time you wrote the letter, matters are still fresh in your mind?
Yes.
Now, I want you to go back to the point in the conversation between yourself and Mr. Jensen, where he was first talking to you about what he'd actually said to Ed Klug.
About Ed Klug or to Ed Klug? Oh.
What he said, when he was first telling you what he'd actually said to Ed Klug. Did he ever tell you what he'd actually said to Ed Klug?
He never told me exactly what he said to Ed Klug.
Did he ever tell you that did he confirm with you that he had actually spoken with Ed Klug?
Yes, he did.
Tell us what he told you about when he spoke with Ed Klug.
Just he was going, I mean, there wasn't a whole lot he told me, he said. I mean, I read the transcripts and got everything from that of what their conversations were. As far as Ed Klug goes, he just, at the part when he said when the discussion about killing her came up, that's when he said he messed up and told Klug that stuff.
So tell me everything you can remember about what he said to you about how he messed up.
Oh, he just said that he messed up because he tried poisoning Julie before he left for his convention, and that he said he was talking to Klug about how to kill your wife, things like that.
Did he ever tell you why he was talking to Ed Klug about how to kill your wife?
Just from the most part that they were drunk and they were talking and just wife bashing.
Did he ever tell you anything about trying to poison his wife at the time or shortly before the time he'd spoken with Ed Klug?
Objection, ask and answer. You just said this. Christine.
Well, I'm going to ask you, I'm going to show you this letter that you wrote. I'm going to show you this letter and ask you if you can identify it. Just read it to yourself. Don't read it out loud.
Objection. Same.
Sustained, you said? I didn't hear what you said. Okay. Well, do you recall writing to, telling your lawyer, or in this letter, do you recall telling her?
Objection, yourself. Sustained.
Well, if I'm not allowed to let him look at it,
Is his memory exhausted on the subject?
is there anything else you can remember about the conversation that occurred between you and Mark Jensen regarding the circumstances of his conversation about Ed Klug and his conversation with Ed Klug?
You know, I don't know. I mean, I don't remember everything that I said because it's so long ago.
At the time that you wrote this letter to your attorney, were matters fresher in your mind at that time?
Yes.
If I were to show you the letter, might that refresh your recollection?
Yes.
Now you're on request that I be permitted to show the witness the letter and have him read it to himself.
That portion is still object. I don't think it's proper refreshment.
I don't understand why you would think that, but, and the objections overruled.
Just start reading to yourself right there.
I remember
No,
this
just
from the first.
just read it, and just read it, all of it, and after you're done reading it, then let me know.
Okay.
Now, does that refresh your recollection any further as to what Mark Jensen told you about about the circumstances surrounding his conversation with Ed Klug?
Yes.
Okay. Tell us what else he said to you about his conversations with Ed Klug.
He just said that he had screwed up in telling me that, and that he, well, basically said that he said that, I'm just trying to remember what I wrote there. I know what I wrote, but I'm just getting confused in my mind.
I don't want you to remember, if what you wrote here refreshes your recollection as to what he told you about Ed Klug, then I want you to tell the jury. If it doesn't refresh your recollection, then let me know that.
Well, it refreshes my recollection. It's just that what I had written there was in regards to what we had already discussed earlier about how he screwed up when he said he was talking about how to kill his wife and those things. I mean,
did he tell you? Did he indicate to you why he felt that he had made these statements to Ed Klug?
Can I read that again? I'm sorry.
I object. He read it. His memory obviously wasn't refreshed. It's improper to have him regurgitate what's in the statement. It's whether he...
But he can't recite what he reads in the statement. And in fact, that was one of his prior answers. He was testifying as to what he wrote, which is hearsay. However,
I think I've laid the foundation for recorded recollection.
If it refreshes his recollection, he may read what he wrote.
Well, Your Honor, I think also as a recorded recollection, he can read what he wrote. If it doesn't refresh his recollection, then it's a recorded recollection.
All right.
And I believe I've laid the foundation for that.
All right.
And it hasn't apparently refreshed his recollection, so I request that he now be permitted to read to the jury what is contained in this last paragraph.
Objection, it is hearsay, and it remains hearsay.
Okay. Hold on a second. Let me just look at the rules.
Now let's break it down.
I'd ask that the document be removed from the witness.
Yeah, just turn it over for a second.
Yeah.
Oh, that won't do it because it's got writing on both sides, so I'll just take it anyway. Thank you.
It's not a...
What is everybody's thoughts about Jam Boy in the 2008 trial versus modern day trial? What do you guys think? I don't like Jam Boy in 2008. He's like those cringy lawyers that you saw back then. I don't like him. It's kind of irritating. Where I do like him now in the modern day trial, he is a snippy little prosecutor. I think he's very arrogant in the 2008 trial. I think he's still a little arrogant in this trial too.
The objections overruled.
So let me read that for you. So directing your attention to the paragraph that begins with the words, he said,
Yes.
Could you please read what you've written there out loud to the jury?
He said he wishes he hadn't opened his stupid mouth around his coworkers about him wanting to kill his wife. That's what's fucking him now. This was at that conference 1 month before. He said he got drunk and stupid because he was feeling guilty because he tried to poison her before he left for the trip. He said when he got home from the trip, she had thrown up all over the carpet in the house and was lucky she didn't die, and then chuckled. Said he
Judge, I
would.
object because he's testified to most of this before. It's improper. It's not.
This part strikes me that this has already been testified to.
There was never any discussion about, or any statement about the defendant chuckling as he's describing his wife vomiting all over the floor.
Go ahead.
Okay, that was my misunderstanding of what you were asking because I thought.
No,
Okay.
you didn't misunderstand it. Just pick up where you left off and keep reading. Please.
Okay, she said he wouldn't have really been, he said he would have really been screwed then. He said he would ask her to pick up medicine for him from the doctors as well
No,
as.
we won't go there yet because
Okay.
that's beyond what I was asking about, but thank you.
Oh.
Okay. Now, did Mr. Jensen ever make any statement to you about asking his wife to pick up medication for him?
Yes.
And what did he tell you about that?
He said that he would actually have her pick up the Literal for him because it was his medication for his esophagus problem. We had talked about.
Did he indicate to you why he would have his wife pick up the medication for him?
I don't recall exactly what was said, but I think it was a reference to just, her picking it up. And we discussed that in how, when we were playing devil's advocate, how to prove it. And that's when it came up about the debit card receipts, or did she sign for the medication and things like that.
Okay. When he described to you leaving his wife on the day of December 3rd and running some errands, did he ever disclose to you how he expected to find her when he came back?
I'm gonna pause this here just real quick. Something I've noticed throughout the testimony so far of Aaron Dillard, Jamboy is just drinking tea like crazy. He's got no note questions in front of him. He, like I said, he's just very cocky, very arrogant, and he's just nonstop drinking tea. It's just some stupid little detail I noticed. It just kind of made me chuckle.
No, he didn't disclose to me. He didn't say she should be dead.
Did he describe to you any expectations he had concerning how he'd find her when he got back?
He never disclosed it, but I'm sure he was feeling she'd be dead by then.
Well, when he, I don't need to put a question on that. Now, you indicated that you still have a case pending in Racine, is that correct?
That is correct.
Have you been charged in that offense?
Yes, I have.
And what were you charged with?
Theft by contractor and home improvement fraud.
And do you know what they're alleging that you did?
Yes.
What are they alleging that you did?
That I took a deposit and didn't start or finish the job done, the work to be done.
And did you take a deposit?
Yes, I did.
And at the time you took the
Oh,
deposit?
excuse me. I'm sorry. I didn't take a deposit. I'm confused at what you're asking me. That's what they're accusing me of, taking a deposit and not doing the work done.
Did you collect any money from this person?
Yes, I did.
And was that to be a deposit for some work that you were to do?
No, it was not.
What was the money that you collected from this person?
That was money I borrowed.
And how much money was it?
$6,200.
And when did you borrow that money from her?
November 2nd.
And when you borrowed the money from her, did you tell her when you would pay her back by?
Yes, I did.
And when did you say you'd pay it back by?
December 17th, I believe.
And what were you going to do with this money?
Spend it.
On what?
Well, I actually gambled with it.
Did you have a gambling problem?
Yeah.
You did?
Yes, I did.
Do you consider yourself a gambling addict or not?
Yes.
So where'd you gamble this money away?
Vegas.
So you got this woman to lend you $6,200.
Mm-hmm.
And Did you tell her that when you were borrowing the money from her that you were going to use it to go gamble in Las Vegas?
I didn't give her a reason.
You just asked her if she'd lend you the money.
Yes, I did.
And what sort of things did you say to her to get her to lend you the money?
I just asked her if she'd borrow it to me. I said I needed money and asked her if I could borrow it.
Did you ever tell her how you were going to pay it back?
No.
Did you have any idea how you were going to pay it back?
I had plans, yes.
But when she asked for the money to be repaid, you didn't have the money to pay her.
She asked me on November 3rd and actually went to my family's house and demanded that they paid on November 3rd.
And they didn't have the money to pay her, did they?
Why would they? It was my debt.
And you didn't have the money to pay her on November 3rd either, did you?
I was expecting it by December 17th about our agreement.
And how were you planning on getting the money by December 17th?
My wife's 401 or winning.
So you were going to ask your wife to cash in her portion of her 401 to pay back the money that you'd borrowed?
Yes.
And then gambled away?
Yes.
By the way, is there a condition of your probation that you're not to gamble?
Now there is.
Did you ever repay her the $6,200 that you owe her?
No, I did not. We're in court proceedings for that now.
Did Mark Jensen ever show you any other document aside from Ed Klug's, the transcript of Ed Klug's testimony?
He never showed me any documents.
Oh, you never saw Ed Klug's transcript?
I mean, besides Ed Klug's statement, you said other than. He never showed me any.
That means you can answer the question, sir.
Oh, okay. He never showed me any other documents besides the Klug statement.
Did you ever see any documents of his besides the documents that he showed you?
No.
Did you ever go snooping in his cell for
Never.
his documents?
Never.
Did you ever see any other inmate go snooping in his cell for his documents?
Never.
Did you ever see any other inmate go snooping in anybody else's cell for anybody else's documents while you were there? Oh, I apologize, Your Honor.
Let me pause real quick. So some things, I'm not sure if I may have fast forwarded a couple minutes into the first portion of this testimony when we started the stream, but some conditions that Dillard had, like you're hearing him kind of talk about his conditions, but he wasn't allowed to carry more than $100 worth of cash on him. That was a condition of his extended supervision. He wasn't allowed to carry any credit cards on him. There was a lot of things that he was not allowed to carry on his person while he was on extended supervision. His testimony, in exchange for his testimony, he got a 4.5-year prison sentence, just gone. And then he was on extended supervision and just immediately released from prison in exchange for this testimony.
Did you ever read any newspaper articles about the Jensen homicide prosecution?
Yes.
Did you read about those? Did you read those articles before or after you wrote this letter to your attorney?
Oh, I wrote some of them before I even went to Kenosha County.
You read some of them before?
Yeah, I read some of them before I even went to Kenosha County Jail and met Jensen.
So you knew who Mark Jensen was when you got to Kenosha?
Yes.
See, this is an important detail. When you talked about this just a little bit ago, a lot of these witnesses, right? A lot of them didn't come forward with testimony until nearly a decade later. Certain testimonies that they told earlier ended up changing nearly a decade later. We're hearing now that Aaron Dillard read a lot of news articles about Jensen, which would have had some details about this entire case. And that's a big concern when it comes to these witnesses is, especially with testimony that is coming where they're like, oh, I didn't recall this back in 98, 99, but yeah, I recalled it 10 years later. And that's a big thing on whether or not that's going to make these witnesses credible. And we've seen the defense team for Jensen really attacking the credibility of these witnesses and focusing in on what they remembered conveniently 10 years later.
But did you know him by sight?
No.
Did Mr. Jensen ever explain to you why he went to the doctor's office to get Ambien for his wife?
He said she was very depressed. That's in the beginning what he was telling me. We never recapped on that conversation.
Well, was that about the Paxil or about the Ambien?
Oh, about the Ambien. Sorry, I made a mistake about the Paxil. The Ambien, he said that she was, because she wouldn't sleep and she was acting all giddy and stuff, and that he wanted her to sleep through everything.
He wanted her to sleep through everything?
Yeah.
Did he explain to you what he meant by everything?
No, he didn't. He just said he wanted her to sleep because if she was complaining, it might make it worse.
He said it might make it worse?
Sustained.
Well, I'm trying to understand what it was he told you about the Ambien. So did he say anything else about the Ambien?
Nothing else about the Ambien. He just said he went to the doctor the day after the Paxil incident because he needed something to calm her down because she was worried about the Paxil, the side effects of the Paxil. Because of what they researched online.
Thank you, Mr. Dillard. I don't have any further questions of you.
Mr. Welby. Can I give that to you? Did I already give you that? It's Judge Barry's case? No.
All right, while we're waiting for Craig Albee to come up and do his cross. Oh, here we go, commercials. We gotta jump off these commercials. While we're waiting, make sure you guys like the stream, share it out. What do you guys think so far? We're gonna play some other Jailhouse Snitch testimony. If we have time, we'll get to Kelly Labonte. That's Mark Jensen's mistress, who he did later marry and took custody of the Jensen boys. So if we have time today, we'll play that. If not, we'll play that tomorrow after we're done with the pathologist testimony, Michael Chambly, who I thought got destroyed by the defense in the modern day trial. I think Jensen's defense team now is doing a way better job than than Craig Albee did back in 2008. They're going for the jugular with every witness.
I'm sorry. Yeah,
no problem.
Yeah, a lot of questionable rulings by Judge Bruce Schroeder. You guys will remember that name. He was the judge that presided over the Kyle Rittenhouse trial.
You were picked up on May 31st, 2007 by the police, right?
correct.
You testified that the reason you were being revoked is because you're doing a construction job you were not supposed to be doing, and you had a cell phone that you weren't supposed to possess, right?
As well as many other violations, yes.
You didn't tell us about all those other violations on direct examination, did you?
Objection, Your Honor. Counsel's mischaracterizing the witness's testimony, and he's arguing with the witness.
Oh,
So, excuse me, can you repeat the question?
On direct examination, you were asked, sir, what were you revoked for? And those are the two things you told us, right?
And I believe I said that with other violations.
On May 31st, 2007, you were pulled over in a vehicle, right?
Correct?
You had a suspended registration, right?
Yes.
Police pulled you over and you said your name was Michael Kaiser, right?
That's correct.
And then you found out that the vehicle registration was suspended because of parking tickets, right?
Correct. Yes.
And you blame that on your brother, Aaron Dillard, right?
Well, I blamed it on myself if I said it was Aaron Dillard.
But you were saying you were Michael Kaiser, weren't you?
Yes.
That's what you were saying, right?
Yes.
So you weren't blaming it on the person who was in the car stopped by police, were you?
Correct.
And then the police figured out that it was you, right?
Yes.
And then what did you do?
I went to jail.
You started crying, right?
I don't recall that.
You don't recall crying and telling the police that you didn't want to go back to prison?
Well, I told them that I didn't want to go back. Why?
And you were crying, right?
I don't recall that. No, if they say I was, please, then I was.
You don't remember crying in your car on May 31st, 2007 because you had to go back to prison?
I was crying in my car? No, I was not.
Well, where were you crying?
I don't recall crying, but I wasn't in my car crying.
Can you tell me where you were doing your crying,
No,
Mr.?
I just said I couldn't recall. I'm sorry.
And that's because one of your violations was that you had absconded from probation back in October, right?
Correct.
You hadn't reported to your agent once since October 9th, 2006, correct?
Correct.
I was dying over here. Craig Albee comes right out the gate with flying bitch baby.
Thank you. Did you need this back?
I'm glad I wasn't taking a sip of my coffee. I would have spit it all over the computer and ruined the stream.
And Mr. Dillard, in June 2007, there were 17 violations that they charged you with during your probation, right?
Correct.
And there were others that they determined you had committed that they didn't even bother to charge. Fair to say?
I wouldn't be able to say.
You operated a computer, right?
I was violated for that, yes.
You violated by possessing a computer, right?
Yes.
You violated by obtaining self-employed side jobs for Lori Brown and Cassandra Ivy without permission, right?
Correct.
You accepted cash and kept money provided for contractual home improvement work from Lori Brown and Cassandra Ivy, right? Right?
I said correct.
And violation number 6, you stole money from Lori Brown and Cassandra Ivy by failing to complete contractual home improvement work, correct?
Not correct.
So Lori Brown is lying when she says that you contracted for work and you didn't complete it?
Objection, Your Honor. Calls for one witness to comment on the credibility of another person.
Well,
Let me just do it a different
well,
way.
I want to be clear about this. Is this a charge where he's charged with one violation for entering into a contract and a separate violation for entering into the same contract? One for just entering into the contract at all and the second one for doing so in an effort to steal the money?
He has a violation for obtaining self-employed side jobs. He has a violation for accepting cash and keeping the money for contractual home improvement. And he has a violation for stealing the money from Lori Brown.
Is it 3 charges arising out of one transaction?
Well, I'll be asking him about it, I guess.
Well, I just
The answer
wanted.
is yes, Your Honor. That's what it is.
Well, I don't know. The witness has to testify, but I think
For those of you not from Kenosha, so this is how crazy Kenosha County is. If you are on probation in Kenosha, they do not want to let you off. They want to keep you in the system. And like you're hearing right now from once, and like probation conditions are psychotic, especially in Kenosha. But from one situation, the probation is violating them on 3 different charges, basically, over one thing. That's how crazy Kenosha is. They stack up the charges against you. They violate you on a bajillion things over one situation. They're psychotic.
The problem with reading off the charges is that you're reading what someone else alleges as opposed to his individual conduct.
I don't know what let me just go. You stole money from these people, right?
No.
Now, Lori Brown was a lawyer, right?
I believe she was an office manager, but she was a lawyer in the past, I believe.
She had a law degree, right?
Possibly, I'm not sure.
You met her on the internet?
Yes, I did.
You told her your name was Aaron Galvin, right?
That is incorrect. She had wrote Aaron Galvin on a contract.
She wrote out Aaron Galvin on your contract?
Mm-hmm.
That's because she thought your name was Aaron Galvin, fair to say?
Okay.
You told her that you had a multi-million-dollar roofing company?
No.
You told her that you were negotiating the purchase of a large asphalt crushing machine?
That's incorrect.
You had a conversation in front of her about purchasing the large asphalt crushing machine?
Not correct.
You told her you were pursuing large state contracts for asphalt, correct?
Not correct.
She gave you money, correct?
Yes, she gave me money.
She gave you money to do a roof at her house,
Correct.
right? You didn't complete that work?
That is false.
You didn't pay Badger Supply for the roofing materials?
I paid Badger Supply for the roofing materials.
Every material? There's not a lien on her house?
Nope.
Did you pay the temporary employees?
No.
And she owes that money?
I'm not aware of that.
OSHA had to come out to the site because of your shoddy work?
I don't believe that's the reason why they came. Actually, we passed all OSHA inspections. It wasn't about shoddy work. OSHA is a safety inspector, not shoddy workmanship expert.
You told her that your wife and son were carjacked and killed in Lithuania, right?
Never had a conversation like that in my life.
You told her that while you were in prison in Lithuania for avenging the death of your son and your wife, that they were chanting "Free the American" outside the prison because they loved you so much.
That's incorrect.
So if Lori Brown says any of those things, she is lying.
Yes.
And Cassandra Ivy, you've been charged in that case, right?
Correct.
You've been charged with stealing her $6,200?
Yes.
You lied to her by saying you were bonded?
I've never said I was bonded.
She had to pay $2,600 to someone else to fix damage you caused?
I'm not aware of that.
And you said that your claim is you only lent her the money. Is that right?
I never said I lent her anything. I'm sorry.
I'm sorry. You only borrowed the money.
Correct.
And you said now it's being worked out in court proceedings.
For the theft by contractor, I was charged for that because she claims that I contracted to do some kitchen work.
Well, what court proceeding do you need to give this woman her money back?
I'm assuming it's going to be a civil litigation if I owe her any money.
Why would she have to litigate you paying her back her $6,200?
I have no problem paying her back. It's just that she went to my parents' house. We had a contracted with a payment due date of December 17th. On November 3rd, she went to my family's house and demanded the money. So I believe she violated the contract by demanding payment early.
So you think because she went to your parents' house looking for the money, you don't owe her $6,200, Mr. Dillard?
I believe I do owe her the money.
You think that was a violation of her responsibilities to you by asking for her money back from your family when you didn't pay it?
I wasn't even due to pay that payment back until December 17th. Why should I pay it back before the due date just because she demanded it?
Your claim is that you had no contract with this woman at all to do her, or let me not say contract. You didn't agree to do any work at her home?
I agreed to do her concrete.
And you didn't complete that work, right?
No, I believe I completed it.
You've been charged in Racine County for theft by contractor in that case, right?
Correct.
You're facing 6 years on that charge, right?
Correct.
And you're charged with home improvement fraud, right?
Correct.
You're looking at a year for that, correct?
Correct.
And the prosecutors have said that they're going to recommend no time on that charge, right?
Correct. If I were to take it to trial or take a plea.
And they're also you were charged with obstructing for your identification of yourself as Michael Kaiser in this other case, right?
Correct.
And you're facing 9 months for that?
Correct.
And they're also going to recommend no time in that case?
That's wrong. There was no recommendation made on that case.
Well, in the Racine case, you've had proceedings postponed until after this trial so you can get a deal, right?
That's not correct. I think that they were just waiting to see the outcome or just to let me finish this first.
That's right. You're waiting to get your deal, correct?
No, that's not correct. I haven't even decided if I'm going to take it to trial yet.
One of your requirements on probation is that you give a statement about alleged misconduct, correct?
Correct.
You refused to give a statement about Cassandra Ivy?
I was violated for that too, yes.
Right, that was yet another one of your violations?
Mhm.
Another thing that was reported in the last year while you were absconded is that you cheated a Dennis Ritt out of some money, correct?
Correct.
And you told him that you had a Russian cell phone contract? Correct?
Actually, I told him I had a telecommunications company in Lithuania.
You don't, do you?
I did, and it still exists. It's just under new ownership.
You told him that you own the distribution rights for cell phones in Russia and you go there approximately every 2 weeks.
It's not correct.
So Mr. Ritt also is lying.
If that's what he said, then yes, he is.
You convinced him to lend you some money?
In a poker game, yes.
You convinced him to lend you some money?
Yes,
You didn't pay him back?
correct.
What y'all watching? Whatever you like.
All right. Thanks for tuning in, everybody. Nothing I can do about these commercials. They're, 20 to 30 seconds long. So I gotta stop the screen share. We've been having some random networks trying to file false claims against us. We just won an appeal. Somebody claimed that some network claimed that we showed a basketball game on a stream during the Jensen trial, which we never did. We just won that. So now we gotta be careful with these commercials.
When you were arrested, you had a Quest card belonging to Celia Rubenstein?
Correct.
Or was it your Quest card?
You just said it was Cecilia Rubenstein's Crest card.
Sorry, it wasn't your Quest card?
No, it was not my
You
Quest.
weren't supposed to have it as a condition of your probation?
I didn't know that at the time. I mean, I wasn't supposed to have possession of credit cards or debit cards.
You didn't know that?
As a Quest card, no, I didn't think it. I did my grandmother's grocery shopping, my wife's grandmother, so.
Oh, you also.
So for those of you that don't know, the Quest card, I think it's called something different now, but that's basically the food stamp card that we have here in Wisconsin. That's what that is. So apparently probation violated him for having a food stamp card. I'm telling you, this is how absolutely psychotic Kenosha is. They just want to whack you over the head for literally everything.
Also had her Visa card.
Yes,
So that was a violation, right?
that was a violation.
And you also wrote check out to a closed bank account, correct?
That was to Dennis Ritt.
Didn't get an answer.
Yes.
That was to Dennis Ritt?
Correct.
You knew it wasn't good?
Correct.
And one thing you were asked about during your interview with the prosecutors here, all your crimes, you say are victimless crimes, is that right?
Well, there's a victim. I mean, somebody paid the money out to me.
You were present at your sentencing in the Kenosha case, the 0-0 case?
Correct.
And did you agree with Ms. Gabrielle's statement there that your crimes have always been crimes of property forgery and misappropriation, never crimes of harm against a person, physical harm or emotional harm?
If that's the way the law reads it, it's a property crime.
How is this witness supposed to know that? He's being asked to
You're
comment.
being asked to comment on a statement made by Attorney Gabrielle.
Would you agree? Well, you were resentenced in, I guess, is in 00 CF 1181, right?
Correct.
For violating your probation, right?
Correct.
And the prosecutor came in and asked that you not be given any time, right?
They made a recommendation of having my extended supervision reinstated.
They asked that you not be given any additional custody time, right?
I think they made a recommendation of 155 days in prison.
That would be time you'd already served,
Correct.
right?
Yes.
So they asked for no additional time for you, right?
Correct.
Despite your extensive record, right?
Correct.
Despite the pending allegations against you, correct?
Correct.
And to justify that, they told the judge that your crimes did not involve emotional harm to anyone.
I don't know what they did to justify it.
Your Honor, I object again to this witness.
I have to say, you're asking him that doesn't affect the credibility of this witness, what someone else said. Whether he got some kind of a very beneficial deal or not.
But as part of his bargain, this is the extent that they went to and that we're entitled to present.
If that was agreed to, if he knew that that was going to be the representation that was going to be made, yes.
Well, I think it's also not just because I'm not bound by just what people say is the deal. I can also go into how far people go in trying to accomplish it.
Your Honor, may counsel approach?
No.
Your Honor, it seems that counsel is suggesting that somehow Ms. Gabrielle did something inappropriate in a courtroom regarding Mr. Dillard's record. It's inappropriate for a prosecutor to misstate.
And I tell you what, I don't want to get into any further discussion on it. I am going to sustain the objection because you're being allowed to examine him about his truthfulness or lack thereof and under the rule that you're proceeding, and to ask him to comment on the statements of others is not appropriate.
Judge, and just so it's clear, I'm also proceeding under 90609 because the whole thing was opened up.
Well, it's a close question. Go ahead. You may have the answer.
Your Honor, may counsel approach? I object to this line of questioning when this witness is being asked to comment on what it is that Ms. Gabrielle said in a courtroom.
I know that. And the objection is overruled.
Ms. Gabrielle told the court that she thought it was appropriate that you get no additional time in prison because you had never committed crimes of emotional harm. True? Do you recall that?
I don't recall her using those words. I don't recall it.
Do you agree that you haven't committed crimes that have caused emotional harm to anyone?
Sure.
Sure that you have committed crimes of emotional harm or you have not?
Well, I don't know if it caused them emotional harm. I mean, my crimes are generated at businesses. I bounce checks at like Mike's Foods. So I bounced them to the business. I don't know who's behind it. So I never met the people and I've never heard anything from them.
Okay, so your belief is you haven't caused emotional harm?
Correct.
During your recorded statement with the prosecutors, you characterized yourself as a woman victimizer. I have that right?
Yes.
And you have some bitterness against women that cause you to want to victimize them.
Did you say I have or I had?
You have.
No, I don't have anymore.
On what date did your bitterness towards women that caused you to want to victimize them end?
Yeah, I can't recall an exact date.
But in August 2006, for example, you were working to meet Lori Brown over the internet, right?
Correct.
You're sending her emails, right?
Correct.
To set up a meeting, correct?
Correct.
And then you obtained money from her, right?
I obtained a contract to do her roof and got paid for doing her roof.
And that work caused her additional bills to pay for the temporary workers, right?
I'm not aware of that.
You haven't paid the temporary workers.
That's correct.
And you understand that in construction, there can be a lien then on the person's.
I understand. To my belief, a lien can be filed on the home if the homeowner knowingly knows anything that is being not paid or worked out. I'm not sure exactly how the law works, but I'm familiar with it a little bit. So I had no idea that she would be held responsible because she didn't even know I was using temporary employees.
So who are the women that you have victimized because of your bitterness?
Oh, let's see. Well, I could say Deborah Spears. That's pretty much it, I believe.
That's it? She's the only one?
That I victimized like that, yes.
Well, during your statement with prosecutors, you said there were two women.
Oh,
right?
I'm sorry if I don't remember the other one. I don't remember it.
Well, what about Deborah Spears? You were charged for stealing her debit card numbers to pay for a cell phone bill, right?
That is correct.
You were convicted of that, right?
Of misuse of a credit card.
Because she had allowed you to use her credit card on one occasion, correct?
That is correct, and I paid her for that.
Well, then you used it without her permission on another occasion and did not pay her back, right?
No money was taken from her.
Answer the question which was asked.
Can you repeat the question so I can hear it explicitly?
Could I have that read back, please?
Question, well, then you used it without her permission on another occasion and did not pay her back, right?
That is not correct. There was no money to be paid back.
Brothers, these are the cases that shape the American justice system.
Sorry, I had to step away for a second. All right, for those just tuning in, thanks. So we are playing some old footage from the 2008 trial. We're going to be playing some Jailhouse Snitches. We're going to play another Jailhouse Snitch who testified in the 2008 trial about Jensen supposedly concocting a plan to kidnap Ed Klug, who we heard testify on Friday. We're going to hear that. And if, there's several others, we may today, we may show, because I know a lot of you are curious about this, but Kelly Labonte, so that's Jensen's mistress, who he married while Jensen was in jail for all of this. Labonte took custody of the kids, the two boys, the Jensen boys, and then later, after he was sentenced to life in prison without parole in the 2008 trial, she did end up divorcing him. The oldest Jensen boy is on the state's witness list this time around. They were too young to testify in the 2008 trial. So we're going to play some other Jailhouse Snitches after we're done here with Dillard. Let me know, though, after we're done with Dillard, type in the comments. after we're done with Dillard, because I know so many of you are curious to hear Kelly Labante's testimony. I'm sure she's going to testify in today's version of this trial. Do you want to hear her testimony next, or do you want to stay on the theme of the Jailhouse Snitches and play Labante's testimony Monday morning, since they're not going to be in court? We do plan on playing the 2008 testimony of the pathologist, Michael Chambly, because the defense destroyed him in the modern version of this trial. So, you know, we found out a lot of things about the pathologist, that he wasn't looking at critical pieces of investigative evidence when he was making determinations. Testified in the 2008 trial about antifreeze, and then we find out the guy doesn't know anything about antifreeze, and he regrets testifying to that. He was a key witness in 2008. We are going to play his 2008 testimony tomorrow morning, since there is no court because of the holiday. And my plan was to play Kelly Labonte, but let me know in the comments if you want to hear Kelly Labante's testimony after Dillard, or if you want to continue with Jailhouse Snitches. Here we go.
Well, there was an unauthorized $500 withdrawal from her checking account, right?
That is correct.
Because you used her debit card numbers to pay your cell phone bill, right?
That is correct.
And then you lied to Detective, do you know how to say that? Oss? Is that who interviewed you?
I believe it would be Aussie.
Detective Aussie interviewed you, and you denied borrowing any money from Miss Spears, right?
That is correct.
And that wasn't true, was it?
No, I never borrowed any money from Miss Spears.
But when you used your debit card to pay for your cell phone, that wasn't borrowing?
I stole. That's what you had said.
Well, the first time you told me you borrowed, right?
Oh, the first time I didn't. Yeah, I guess you could say I borrowed it, because I gave her the cash in hand and she punched her credit card numbers into my phone at the same exact time.
Okay, so you acknowledge that you stole it?
For the second transaction, that's what you're saying, is I stole the $500 by using her credit card without her permission. Is that?
Yes.
Okay, that's what is implied, yes, that I stole the second time.
Mm-hmm. And you did, right?
And yes, I did. I'll say yes, I used her credit card to pay my cell phone bill.
Without her permission?
Correct.
That's called stealing, right?
I just said that.
Well, you told Detective Aussie that the cell phone bill payment was an accident.
It was, but I pled guilty to it. It was. I mean, the numbers were programmed into the phone when I hit 111 to pay the bill using my wife's credit card. It overwrote her credit card at the time. So it was unknowingly I used her phone. I used her credit card because the cell phone company programmed her credit card over my wife's credit card number.
So you're telling us that that your cell phone had her debit card number in your phone?
No, the service had it programmed. The actual phone company, when you call and use, #66 to pay your bill, you enter your credit card number in there. The service stores the credit card as a payment, and it overwrote my wife. So when you program, like if you were to pay your bill today with one, you could just press 111 and pay your bill every month without entering a credit card number.
And what you did when you were in jail is you called your wife, Nadia, right?
That's correct.
And you told her to just say it was her that did it, right?
Yes.
Because you knew it was stealing the whole time and that it wasn't a mistake, right?
No, that's not correct.
And you also had Nadia call Deborah Spears, right?
Objection, Your Honor, to the conjunction. The witness denied the previous question, and counsel's using the conjunctive.
You also had Nadia call Deborah Spears.
Yes.
I object to the also, because again, it's a conjunctive form. The witness denied the last question. He said no in response to the last question.
Rephrase the question.
In addition to punching in her number and stealing her money, you also had your wife call Deborah Spears from the jail when you were in the jail, right?
Yes.
The reason you had her call was to try to put pressure on Deborah Spears to drop the charges, right?
That's incorrect. I don't think it was pressure.
You told Deborah Spears that either she could drop the charges and let you out and maybe she'd see the money, or she could continue with the charges and she'd never see her money.
I believe the words were, if I've got to sit in jail, I'm not going to pay you back.
You told her that she holds the strings like a puppet, right?
Yeah, she does. She did.
Because you wanted her to drop legitimate charges that you had stolen money from her, right?
I believe they weren't legitimate. I believe it was an accident that turned into something because of my history.
You also borrowed thousands of dollars from Ms. Spears, right?
I testified that wasn't correct.
Today?
Yes, earlier I just said that.
You didn't borrow thousands of dollars from Ms. Spears?
No, I did not.
You told her your name was Kyle Rezick, right?
When I met her in a bar, yes, I did.
Is it okay to give a wrong name because it's in a bar?
Well, I was on probation and I lied because I didn't want anybody knowing who I was. Kenosha's a small city. I say I'm on air in Dillard, they call the PO and I get violated and put in prison.
The other problem is if you're trying to date women.
Let me stop this here. This is, so again, for those of you not familiar with Kenosha and how things work in Kenosha, or even the state of Wisconsin in general, okay? So he just mentioned something about, like, if something is said to probation, right, like they'll, you know, they revoke him, they do all these things. Here's the craziest thing about Kenosha, okay? We have physically watched this happen. We've seen this happen in a number of cases when it comes to people that, you know, have committed a crime. They're sentenced, they have probation or parole or whatever. In the state of Wisconsin, and this happens in a few other states, you can, so let's say you're on probation, okay? And then somebody puts an allegation on you, right? If the allegation sounds believable, okay, probation will put a PO hold on you. You'll get picked up by law enforcement. You get sent to jail, and you're on a PO hold, okay? Because of the allegation, and you had police contact, it is a way that they can then revocate you, and you end up going and serving your jail time or prison time, literally due to police contact. Now, let's say you actually didn't do what you're being accused of, the allegation, okay? And you're like, fuck that, I'm taking this to trial. I didn't do this, right? You have proof that you're wherever, you have receipts, there's video of you somewhere else, absolute proof that you've done absolutely nothing wrong. And you're like, I'm taking this to trial. And you win at trial that somebody lied, they made an allegation, it was untrue, and you're now proven innocent. Probation can still revocate you, even though you were innocent of a lie that somebody told on you. That's what's crazy. Here's another thing. Quick little story. So former friend of mine, he's not anymore because he was one of the original people that doxed my address, and it led to a lot of militia showing up to various addresses that I was bouncing from. But this individual, he was charged with like some misdemeanor battery. So he gets jumped by several people, charged with misdemeanor battery because he kind of beat the shit out of these guys. And he gets charged, he's sentenced to some jail time, has probation, and ends up, screwing up, does some other things throughout his probation time, whatever. And probation kept revocating him, and he was actually sent to prison off of a misdemeanor crime. That is absolutely unheard of. But this is how crazy Kenosha is. So just giving you guys a little background on Kenosha. And remember, during this time frame, these 90s, 2000s, Kenosha was extremely, extremely corrupt.
Women, they look you up on CCAP and see you're a criminal. That's a problem too, right?
Possibly. I don't know if every woman does it.
But that's one of your concerns, right?
Not at the time. Now it is, now that I'm aware of CCAP.
Well, you were trying to victimize this woman. That's what you said, right?
Yeah.
And when you were trying to victimize her, you didn't want her to find out you're a criminal by looking at CCAP before you had the chance to victimize her, right?
Oh, that's not correct. I told her right away who I was, what my real name was when I started dating her.
Mr. Dillard, the fact is you were taking a shower and she looked in your wallet and then discovered you were Aaron Dillard, right?
That I don't believe at all.
You don't believe?
No, she didn't. I told her who I was. I think I said that earlier.
You told Deborah Spears that you were very wealthy, right?
No,
You drove her to Milwaukee and pointed out a yacht that you said was yours, right?
that's not correct either.
You told her you had a yacht?
No,
Told her you had an expensive condo?
no,
You told her that your wife had been a doctor in Lithuania and that she and your son had been killed.
that's not correct.
You told her that you had a lucrative telecommunications business in Lithuania, didn't you?
That's correct.
And you told her that your assets were frozen in that company, right?
Actually, I sold that company at that time.
You told her that your assets were frozen in that company, true?
That's not correct.
You told her it was a lucrative company?
It made money.
And you told her that you couldn't get access to your money, right?
That's not correct.
You did that, you told her that assets were frozen and that's why you needed to borrow money from her, even though you were supposedly a wealthy man, true?
And that obviously is not correct.
You don't believe Deborah Spears was emotionally harmed by your actions?
If she's still emotionally about the $500 that I supposedly took from her, which was never taken, then I don't know what else to say.
What about the thousands of dollars you borrowed from
I
her?
believe I testified I didn't borrow any money.
Are you aware of Deborah Spears having filed bankruptcy as a result of your actions?
I have no contact with her as far as conditions of my probation.
How many women did you meet over the internet that you later borrowed money from or did business with?
I'm Vinny Politan. Welcome.
All right. So far, we've got a lot of votes to play Kelly Labante's testimony after this. So keep voting in the chat on Facebook and YouTube. Be sure to share the streams out, like and follow the Facebook page, subscribe on our YouTube channel if you haven't already. A lot of content up there. Still have some time left here on Aaron Dillard. But keep voting in the chat on Facebook and YouTube. Do you want to stick with the theme of Jailhouse Snitches today and play Labonte tomorrow, or do you want to play Labonte right after Aaron Dillard?
Who are those three?
I think it was Wendy Inu, or no, sorry, maybe two. Wendy and Shannon Panko.
Well, Deborah Spears you met in a bar. What about Cassandra Ivey?
No, I met her on a job site.
Lori Brown?
I met her on, Lori Brown. That was the third one.
And you'd post your personal on Yahoo or some other sites too?
At that time, yeah.
Pardon me?
At that time, I did.
And you lied in those personals, right?
Explain that.
So you lied about yourself, right?
No, I don't believe so.
All right. You didn't say, for example, that your education was postgraduate?
I don't know if I never clicked the link that said anything about that.
So you think if your personal says that's just the site's problem? It's not something you would have?
Well, I could have, but I don't recall it. It's just a profile. It takes 3 minutes to fill it out. You just click buttons and it's up. If it popped up that way, I never really reviewed it.
So Wendy Is it Wendy Reamer?
It could be.
You met her on the internet?
Yes.
Told her your name was Kyle Rezick?
I don't recall. I could have.
You frequently use that alias to conceal your identity?
Twice I did. If I used it with Wendy.
You told her you played college football?
No.
You told her you were dying of a rare bone disease, right?
No. No.
You told her that you were flying to Europe for special treatment?
Never.
Told her that you had a business in Lithuania?
Yes.
Told her you had a mansion in Kenosha?
No.
That you bought your parents a home next door to the mansion?
That's not true. She picked me up at my parents' house.
In fact, your mom is the one who told her who you really were, right?
No.
You claim to be a medical and surgical equipment seller?
Yes.
And you'd done research to be able to make that claim?
Yes.
You claim to work for the CIA and the FBI?
Never.
And Shannon Pankow, you told her you were Kyle Rezick, right?
That I don't know if I did or not. I met her at the same time as the other ones, so.
As you've told so many people you're Kyle Rezick, you can't remember who you told?
No, I thought it was only two.
You told her you were a special agent of the Lithuanian government?
I did not.
You told her.
Go ahead, sorry.
You told her that you couldn't fly to Las Vegas because of your position in the Lithuanian government?
No.
You told her you had military clearance?
No.
You borrowed money from Ms. Pankow, right?
Yes.
And you told her you needed to borrow money because you had lots of money, but it was tied up in your retirement, correct?
Not correct.
And you paid her back from your wife's grandmother's retirement plan, right?
That's not correct.
You told her that you were hung from chains and tortured in Lithuania?
Never. Never.
You told her that your son was carjacked and killed in Lithuania?
Not correct.
And you told her kids that you'd be taking them for helicopter rides, right?
Actually, we did. We were discussing going for helicopter rides.
In your helicopter?
No, we were in Vegas together, and we went to one of those places where you could go for helicopter rides. I mean, that's what we did.
And so if Shannon Pankow says those things, other than the helicopter rides, for instance, that you told her that your son was killed in Lithuania, that would be a lie?
Yes.
If Deborah Spears said that you indicated your wife and son were killed in Lithuania, that would be a lie?
Yes.
Did you tell her your wife was killed in Lithuania?
No.
At any rate, you had 17 separate violations,
Sounds about right.
right?
Yes.
Sir, defendants exhibit 135. That's a violation revocation summary from Department of Corrections of Wisconsin, probation and parole. Correct?
Correct.
And that's something that your agent came to you with on or about June 21st, 2007?
No, that's not correct.
When did she give you this document?
I believe I received this document, yes.
You just don't think it was June 21st?
I'm pretty positive it wasn't June 21st.
at some point, your agent came to you and told you what the revocation time would be, right?
Yes, what she was recommending. They can't set the time, but they can make a recommendation.
Right, and you refused to sign it, right?
Yes.
And you said, this is a joke?
I said that because there's a 2005 case on there that I was being revoked on. It was a misdemeanor, and I felt that I did that time. I served that extended supervision, and I told them to take it back and bring it without that case number on there.
So you said your response was, this is a joke?
Yes.
I move defendant's exhibit 135.
No objection.
Proceed.
Mr. Dillard, you were revoked on 3 cases, is that right?
No, I was revoked on 2, but somehow a third one got thrown in there. I signed revocation papers for an 01 case and an 00 case, never an 05 case. So I never had a hearing, and I never signed a waiver on an 05 case.
All right. So you're saying it was only on 00 CF 1181 and 02 CF 1286, right?
That is correct.
All right. And on the 1181, her recommendation was 2 years, 11 months, and 21 days?
Yes.
And on 02 CF 1286, you're looking at 4 years, 6 months?
Excuse me?
4 years, 6 months?
The recommendation, I signed my waiver was for 3 years recommendation.
Her initial recommendation was 4 years, 6 months?
That was not her initial recommendation. Her initial recommendation when I signed my revocation waiver was for 2 years, 11 months on the 81 case, and on the 86 case, 3 years recommendation.
Is this what you were indicating that she raised it to? 4 years, 6 months?
She raised it to 4 years when I got into the court. I saw the revocation packet that she turned into the judge or to the courts, and then it was on there as that.
And sir, the second to last page, that's the recommendation in this document is 4 years, 6 months, correct?
In that page, yes, it is.
And that was her recommendation for the court?
Yes, it was. Yes.
And then you were facing 6 years on the new Racine case?
Yes.
That'd be an 07 Racine, right? 6 years. Actually, it's 7 years, isn't it? Because there's 2 counts.
Yeah, there's a 9 month in there, I think. I believe the home improvement fraud counts 9 months. Or whichever one, home improvement fraud, they're in 9 months.
Home improvement, 1 year?
Is it 1 year or 9 months? I don't know the statute, so I don't know what it carries.
It just refreshes recollection. I'll just show you the criminal complaint. Does that refresh your recollection as to how long it is?
Well, I got to consider it says that.
I'm over.
All right, so I was trying to type some answers there. So we were getting questions asked about sentencing and all of that, and so Dillard, just for clarification, so Dillard was released from custody due to his cooperation in testifying in this case. He was facing 4.5 years. They commuted that sentence due to this testimony. As far as Mark Jensen, so Mark Jensen was arrested. Let me pause. Mark Jensen was arrested in 2002 for the murder of Julie Jensen. Remember, she died in 1998, December of 98. He was finally arrested in 2002. He was originally held on a $500,000 bond, which he couldn't post. In 2007, at a bond forfeiture hearing, they, due to testimony from these people who now all of a sudden conveniently start remembering conversations, they forfeited his bond, and he had a no bond. The trial then went the following year in 2008 due to the retrial and this letter from the grave not being allowed and some other things not being allowed because of a 2004 confrontation clause that changed with an iconic case with the Supreme Court. We've talked about it in length here. I think it was Crawford v. Washington, something like that. And there was a lot of hearsay stuff with that confrontation clause. So after this got kicked around to multiple courts and appeal courts and all these things, it was said, look, he either needs to be released or you're going to have to retry him. And obviously the state decided to retry him, which meant he had to have another bond hearing. Jensen is currently on a $1.2 million bond to now. So is Dillard the one selling the drugs? I don't remember. I got to look back. There's so many people now, and we've given out so many details. I think it was Dillard. Correct me if I'm wrong, chat. I got to look back at my notes. I have so many details. But there's big arguments about one of the jailhouse snitches. I want to say it was Dillard, that supposedly bought or sold drugs to the DA, Jamboy. So there was some gap in Jamboy's, transitioning from different counties and things. I think it was Jamboy supposedly sold cocaine to Dillard. And we heard a lot about that in the pretrial things. There was some other sketchy shit that Jamboy did where he wrote to a federal judge about the trial and all of these things. So, just a lot of questionable stuff throughout this entire case. The history of this case, there's a lot of questionable things, that are going on. So a lot of weird loophole things, seems like some corruption, a lot of discrepancies. Witnesses not recalling any conversations about anything until almost a decade later. You got a pathologist that's not reviewing critical investigative reports, falsely testifies in 2008. There's things like that. The letter from the grave is kind of interesting. It's not in this trial, but there's some questionable things about that as well. So just interesting. What do you guys think so far? Type in the chat if you were on the jury, and let's pretend that with the details that we're giving, right? So we live stream the trial every day of court. We live stream, so make sure you guys are here. But we're playing archived footage too, which the current jury is not going to have access to. But if you were on the jury and you had access to all the details that we're giving you guys here on Never Stop Media, where do you guys sit right now? Type in the chat. 1, if you think he's guilty. 2, if you're not sure yet. Here we go.
Yes, 1 year.
So extra 1 year, and then Waukesha. That's 9 months, right?
Sure.
For obstructing?
Yes.
For lying to the officer?
Correct.
All right. So you're facing on the revocations, the recommendation from your agent was about 7 years and 5 months, right?
That's incorrect.
Is that not the recommendation?
If you're doing the math and running a consecutive to this, but I was only facing 4 years, 6 months, because it's run concurrent.
Well, the judge had the authority to make them consecutive, right?
don't know if I was revocated. I don't know what the statute says exactly, but my belief is that if you revocated once and they ran everything concurrent, that the next one runs concurrent too. They can't remake it and put it consecutive, can they?
Well, if you're being sentenced, you were going back to court for sentencing, right?
Correct.
And the judge had the freedom to sentence you to whatever was appropriate, right?
Yes.
And whoever sentenced you second could say this is consecutive to the first sentence, right?
I don't know if that's by law they can do that because DOC would run my sentence regardless consecutive or concurrent, excuse me.
You're facing at least the 4 years, 6 months?
Yes.
Plus 7 years in Racine?
Yes.
Plus 9 months in Waukesha?
Correct.
And the recommendation you're getting is time served, right?
No.
That's the recommendation from the district attorney's office, right?
You're making a mistake. Waukesha, I'm still facing 9 months.
And those proceedings have been postponed until after this trial as well, right?
Yeah, but for reasons that I haven't been able to retain an attorney yet.
The last time you appeared off the record, you talked to the district attorney and told her about your testimony in the Mark Jensen case.
I said I needed time, I told her.
Right, because of the Mark Jensen case.
Yes.
Right? And she agreed to allow you to postpone it so you could come in and try to get credit for this case, correct?
No, that's absolutely not correct.
You're facing over 10 years' time, and what you're getting is a time served, right?
No.
You're not facing... I'm just even going by what you're willing to acknowledge, sir. 4 years, 6 months plus 7 years. What's that?
That is 10 years or 11 years, 6 months.
Right. Over 10 years, right?
That is correct if you want, yes.
And you recognize that a judge will take into consideration what your agent has to say, right?
Of course.
That agent's been monitoring you, right?
Of course.
And you've been sentenced a number of times, correct?
Of course.
You know that the judge considers your character, right?
Of course.
Considers how serious the offense is.
Mm-hmm.
Yes?
Yes.
Considers how well you've done if you've been out on probation or parole before, right?
Correct.
He considers whether there's a danger to the community, right?
Correct.
And the recommendation of the probation agent, right?
What do you mean by that? And what is that question?
Your agent's recommendation for time and also what that agent has to say about who you are, right?
I still don't understand what you're saying. I mean, you're making a statement to me, but you're not making a question, I don't think. What is the question?
You know this kind of report goes to the judge, right?
Yes, of course.
And the probation officer provides information to the judge about you, right?
Correct.
And the judge considers that information,
Correct.
right? To do with Defendant's Exhibit 135. And what the probation officer had to say about you to the judge is, I'm going at the bottom of that page, it's not numbered, it's 4 from the back. And the heading is offender is in need of correctional treatment, which can be most effectively be provided if he is confined. You see that?
Yes, I do.
It says, it is obvious that Mr. Dillard is in need of serious CGIP. What's that? You know?
It's cognitive thinking.
Serious cognitive thinking, but his criminal behavior is well beyond the need of cognitive thinking. His repetitive, deviant thinking is just in plain need of confinement. Even though prisons are normally used for rehabilitative purposes, Mr. Dillard is in desperate need of incarceration. According to the department's client management classification casework control method, incarceration should serve as behavior control and not in terms of punishment. It is at the suggestion of this document that persons with criminal behavior of this caliber show no guilt or remorse. Their goal in life is to be a successful criminal. They are motivated by the power they feel to manipulate others, sometimes for material gain. Per the limit-setting classification, a person becomes excited when running games on others. With this having been said, it is obvious that Mr. Dillard fits these characteristics. Given these facts, it is believed that Mr. Dillard will just view incarceration as paying the price for, quote, doing business, close quote, as cited in the casework control classification. Despite the grim assumption, Mr. Dillard's scamming schemes are a drain on society, and in a perfect world, it would be nice if Mr. Dillard were incarcerated until he repaid all of his debts, which interestingly was the initial purpose of jail back in the 18th century. That's what your probation officer had to say about you, right?
Yeah.
And that's why she thought you should get the maximum time available for confinement.
I believe somewhere there was a typo, but the 3 years I believe they recommended. They recommended 3 years. I think that was 4.6 was a typo somewhere. I've got
That document in front of you says 4 years, 6 months, right?
Yes, but I believe it's a typo. I got the handwritten one that says 3 years.
And then the other 7 on Racine, right?
What about the other 7 on Racine?
That's what you're potentially facing there, right?
Potentially.
And you know that that judge can consider what kind of person you are, right?
Yes, of course.
You testified on direct that your probation previously had been revoked, correct?
Correct.
And you said that that was because you had done a construction job that you should not have done, right?
Correct. Well, plus other violations.
That's not what you testified to on direct, is it, sir?
I believe it is.
Counsel's arguing with the witness, and the witness's testimony on direct was done right in front of the jury. They've got a better recollection apparently than Mr. Albee does, hopefully.
I object to that speaking objection.
If the testimony was not that way on direct examination, then the witness can so state the objections are ruled.
Show you what's been marked as Defendant's Exhibit 136.
Would you like this one back? Sure. Thank you.
And that's the decision of the administrative law judge revoking your probation, correct?
That is correct.
And you were revoked on 15 separate grounds, correct?
Correct.
You were revoked for being in an establishment that sells alcohol.
Objection, Your Honor, this has already gone into the witnesses.
You're allowed to question him about specific instances of conduct, not about what somebody else said or did.
Fair enough. You're aware that a judge sentencing you could also take into consideration the viewpoints of an administrative law judge, correct?
Correct.
You had a hearing in that case at which you testified, correct?
That is correct.
Objection to hearing in what case? What hearing?
An administrative revocation.
You had a probation revocation hearing before an administrative law judge, right?
Correct.
And you testified in that case, correct?
Yes. No, I didn't. I don't believe I did. No, yes, I did. Yes, I did testify in that case.
And you lied in that testimony, right?
I don't believe I lied in that testimony, no.
You understand that a judge can consider what the administrative law judge had to say, correct?
I've already answered that, yes.
And if you could go to page 3, halfway down the page. And the administrative law judge found the following.
Objection, Your Honor. His name.
Mr. Dillard, do you know who the first American citizen to be extradited to Lithuania was?
Of course.
That was you, right?
Yes.
And in
Little
Lithuania,
history lesson there. I didn't know that. That's interesting.
You're committing fraud against Lithuanian citizens, correct?
That is correct.
For example, you obtained $2,500 from a Kostas Algirdis Kurlis.
I believe so.
And that was for his daughter to get a 10-year visa to the United States, right?
That is correct.
And you made friends with them, right?
Correct.
You met them in a cafe, correct? You were very polite and serious, right?
Correct.
You told them that your parents lived in Chicago and that they were very wealthy.
I told them that they lived in Wisconsin. I've always claimed that I live from Wisconsin.
So you deny telling them that they lived in Chicago?
Correct.
Did you tell them that your parents were very wealthy?
My parents had a little bit of money.
Did you tell them?
No, I never told them they were very wealthy.
Did you say they were wealthy?
According to, in their standard, they probably were rich. So I guess, yes.
That wasn't the question.
No, I never said they were wealthy. I never come out and said they were wealthy.
And you said you had helped Lithuanians receive USA visas, right?
That's correct.
You convinced them that you were very reliable, right?
Correct.
And you got the $2,500?
Correct.
They were very excited about the daughter going to the United States?
Correct.
You had no intention of producing a visa?
The intentions were in the beginning real, but then everything fell through and then I just took the money. Well, as long as with the other ones.
You just kept on taking the money and taking the money, right?
Yes.
Even though you were producing no visas?
Yes, I did.
And Mr. Kurlis' son was a doctor, right?
Yes.
And you stayed at these people's house, right?
Because it's, yes, I did at one night.
They invited you over to dinner and you stayed at their house.
Yes.
Right? You were their friend.
Yes.
And then you got the $2,500 and didn't produce the visa.
Correct.
Right? And their son, you told him that you had a BMW distribution deal, right?
I think you're mistaken.
Did you tell somebody you had a BMW distribution deal?
Never.
Did you obtain money from his son?
To buy a BMW, yes, we did. We bought a BMW together.
Do you deny that you offered the doctor's son a profitable business to buy new cars in Europe and export them to the United States where your brother would sell them and money would be transferred to your account?
I think the wording you're using is misrepresented. I think it was more, we'll buy a car together and we'll sell it and split the profit.
And you obtained money from him as well, right?
And I bought the car and sold it.
And you never gave him any money?
There was no profit. The car started on fire.
Well, you took his money and you didn't give him back any money, right?
Hold on, my understanding how business works is if there's no profit to be split, you don't get any.
Or if you borrow money and you don't have it to pay back, that's just tough luck for the person who lent it.
That was me being a bad person.
And the Kurlises, you stopped calling them because they wanted their visa or their money back, right?
Correct.
And what you did is you had some woman call them, right?
Not that I recall.
You had some woman call them and identify herself as your maid, right?
No.
You had some woman call and say that you were in the hospital, that you'd been hit by a drunk driver, right?
Actually, I was hit by a drunk driver in
Answer the
Lithuania.
question which was asked.
What was the question asked?
You have that read back.
You had some woman call and say that you were in the hospital, that you'd been hit by a drunk driver, right?
No.
And then you called a week after that acting as though you could hardly speak, correct?
I don't remember. I could have called them.
To try to sell them some phony story that you were unable to respond to them, right?
No.
You continually promised that you'd produce that visa, right?
Or the money, yes.
You never did, right?
Correct.
You did this on 7 different occasions to 7 different people?
Could have been 7, yes.
Well, that's how many you were charged with. Actually, was it more than that?
No.
And you'd meet these people in cafes often?
Yes.
You'd become their friends?
Not really. Sometimes, sometimes not.
They thought you were their friends, right?
I don't know what they thought.
And you had to do research so you'd be able to sell this phony con to them, right?
Excuse me?
You had to do research to be able to sell this phony con to them, right?
No.
You just knew all about visas sufficiently that you could convince Lithuanian people that you had the authority and power to give them one?
They were looking to buy illegal immigration visas. And I came up with a story I could sell them to them.
And where did you get your information about how to do that?
I can get them and that's it. I don't know anymore. How do you research crime? I mean, I'm not familiar with that.
In Fond du Lac, in 2002, you had a woman named Julie Frieda rent a car for you,
Yes.
right? Your truck?
Truck.
And then you took off with that truck and didn't return it?
Correct. I returned it in Vegas.
Well, long after it was supposed to be returned, right?
Correct.
And you lied to her about when you were going to return that truck, true?
Correct.
In 2003, in Racine, you took $8,600 from an Erica Knudsen.
I'm sorry, from where?
From an Erica Knudsen, Knudsen, right?
You're mistaken. No, I did not.
Erica Knudsen gave you and your brother, Michael Kaiser, $8,600, right?
It's not correct.
Did you ever have any dealings with Erica Knudsen, Mr. Dillard?
I never had any dealings with Erica Knudsen.
Did you drop off shingle samples there?
Yes, as a representative of KMM Construction. I didn't. I just dropped off shingle samples and left them on the porch.
So you were dealing with her?
If that's what I didn't talk to her. I dealt with her house then because I left them on her front porch. I never talked to her.
And you returned to her house to pick up those shingle samples, right?
Left on the same front porch.
And you stated at that time that you would start the contract on June 14th, 2002, right?
Not correct.
And you and your brother received $8,600.
No, you're wrong.
You were charged with that, weren't you?
I was never charged with that.
Mr. Dillard, have you ever run a company called Aaron Construction?
Never.
Are you familiar with the company called Aaron Construction?
Never. Don't know.
You've never heard of it?
Never heard of it.
Now, you promised to begin telling the truth when you started dealing with these prosecutors, right?
Yes.
Thank you.
Mr. Dillard, I show you what's been marked as Defendant's Exhibit 137. In count one, were you charged with theft by contractor for stealing from the Knutsons?
According to this document, it says that I was charged with it. I don't remember that because I've never been convicted of that crime, nor have I. It could have been dismissed and read into another. No, it wasn't even dismissed and read in. It could have been just dismissed because my brother was going through a lot of theft by contractors at the time. And I was involved being his brother and working for him. So as far as that case goes, I have no idea about it. I was never convicted of that crime, nor went to court for that crime.
Now, you were also charged for theft by contractor with Donald Zarowski,
Correct.
right?
That I took a plea as dismissed and read in to my forgery case that I'm on. I think it was the 02 or 01 case.
So you obtained money from Mr. Zarowski and then did absolutely no work on his house, right?
No, that is wrong. That's where I brought the compressor to do the job on that I caught the forgery for. Because my brother went to jail for taking the initial deposit, and then I had to try to fix it and do the job. He gave me $3,000. I bought the shingles, and then I couldn't afford to pay the labor and the compressor. I bounced a check for the compressor, and then never finished the job.
You bounced a check for the compressor?
I forged a check for the compressor. Excuse me, my mistake on the terminology.
You created a whole new check for an entity that didn't exist, right?
Correct.
And you didn't identify yourself as Aaron Dillard, right?
No, I don't know what I wrote on the check. As far as Zarowski, I did.
You created an entire fake name and printed up fake checks, right?
Yes, that's
And then
correct.
you went and got this compressor, right?
That is correct.
And with Mr. Zarowski, you tore off a portion of his roof, delivered a couple of bundles of shingles, and then you disappeared from their job site and was never heard from again.
That's correct. That's incorrect.
So Mr. Zarowski said that he's a liar.
I would ask him actually what he says. Sorry.
Objection, because counsel's expecting this.
And you haven't had prior dealings with Aaron Construction?
No, none that I know of.
You don't even know who they are?
Aaron Construction?
Yeah. I'll show you what's been marked as Defendant's Exhibit 138. You had a recorded interview with these prosecutors, right?
That is correct.
The one where you said you'd start telling the truth, right?
That's correct.
And they wanted to know what you planned to do when you got out of jail with this good deal you were getting, right?
They asked me what I plan to do.
Right. And Mr. Jamboy said, so when you get out, your wife will be able to support you until you find a job, right?
That's correct.
And you said, yes.
Objection, Your Honor. This is hearsay unless there's some prior inconsistent statement. If he wants to ask,
there is.
Has this witness been asked on this witness stand?
I've already done that, actually.
Yes, yeah.
Mr. Jamboy says, so when you get out, she'll be able to support you, meaning your wife, until you find a job. And you, Mr. Dillard, said, yes, of course. And I have actually jobs lined up with Aaron Construction or with Sundance Vacations.
Oh, I could have meant AT Construction. I'm sorry if I made a mistake. It's the whole situation with that. You had a lot going through your mind. I said my own name possibly, but I don't know of I worked for an AT Construction before, and I was planning on applying with them again. So I'm sorry if I made a mistake on saying the wrong word. It was just a
So that was just the wrong word.
I said probably my name, just being situation is very stressful. So your mind gets a little faster.
I see.
And if I had time to think about that question, I probably would have answered it AT Construction instead of Aaron Construction.
And so it was just that one slip of the.
I believe so, yes.
Okay. Who's Sundance Vacations?
Sundance is a company my wife used to work for.
And then a few lines later, Mr. Dillard.
Yes.
Mr. Jamboy says, what about the construction job? After you talk about Sundance Vacations for a while. And he says, what about the construction job?
Yeah.
And you say, Aaron Construction is a concrete company. They do a lot of brickwork, mortar work, and I'm a mason. So anytime I want a job, he told me I could feel free to call.
Well, that's real. I mean, if it's AT Construction, that's what the construction company was, the brick company. I made the mistake and I kept saying Aaron, probably just associated. I'm sorry, I made a mistake in the wording of the word I used. Sorry. I don't know what to say. It's AT Construction.
Do you have a job with them right now?
No, I don't. It's kind of hard to get a job right now.
I have actually jobs lined up with Aaron Construction or with Sundance Vacations.
Okay.
You didn't have a job lined up?
I had a job lined up with, I'm not allowed to do construction work. It's conditions of my rules.
Answer the question. Did you have a job lined up?
I had a job lined up.
And twice is Aaron Construction an entity that you don't know?
I don't know of Aaron Construction.
And you also committed theft by contractor against Timothy Franklin, right?
Incorrect.
Timothy Franklin paid $10,000 to your brother?
Of course.
Right?
Yes, he did.
And you came to his house to show him samples of siding, right?
Yes.
And no work was done on that house, right?
None that I know of.
And you never returned Mr. Franklin's money?
I had no responsibility to return anything to Mr. Franklin. I was not the contractor doing the job. I worked for the contracting company that did the job.
Let's take a recess, usual, and don't talk about the case during the break. Okay.
All right, so we're gonna keep going. There's still testimony from Aaron Dillard. They've separated it out in multiple videos. So if you guys are just tuning in, I see on Facebook some people are thanking people for tagging them in the stream. That's awesome, guys. Keep sharing this out. Keep tagging people. We want to try to get as many people over here so you guys get some full background on this case. A lot of you guys were unfamiliar with the case. A lot of you have never seen the 2008 footage. So, this is a great platform here to get a lot of details. We have multiple streams up on, there's more information up on our YouTube channel. We did a stream several hours long talking about full background of this case, a lot of details that are not going to be coming into this case. We talked about Paxil, Ambien, side effects of that, when the FDA, approved that drug, and then changes that were made in 2005, 2011, due to the dosage amounts that were really messing people up in this era, late 90s, early 2000s, things like that. We talked about the letter from the grave. We went through that in detail, the original criminal complaint, witnesses. We went in full detail. A lot of people are like, I don't understand why he's got a new trial. This doesn't make sense. We went in full detail on the Sixth Amendment confrontation clause that changed in 2004 from an iconic United States Supreme Court case.
We read all of that in full detail. So check out our YouTube channel, Never.Stop.Voices. There's a lot of information. You can go to the playlist for Mark Jensen trial. We even separated out witness testimony for you guys, so you don't have to sit and watch 9 hours of streams. If there's a specific witness you want to see, we isolated those and put those up separate. So a lot of detail. Thanks for tuning in, everybody. We appreciate you. Make sure you guys, follow the Facebook page, NSM News Updates. Subscribe to the YouTube channel, Never Stop Voices. There's tons of content up there. We have a lot of exclusive content. If you guys aren't familiar with us, so we're Never Stop Media. We're an independent investigative journalist company based in Southeast Wisconsin. So I'm from Kenosha. This is why we're, so heavy on this. We know a lot of details about this case. Is a great opportunity for you guys to be able to, ask questions and get those questions answered instead of going to, watch these streams on lamestream media. And there's so much misinformation and disinformation and speculation, and you're never getting your questions answered. We're trying to get all of that stuff answered for you. We did take a poll. So we were going to, continue with, because there's multiple jailhouse snitches that jumped on this case in 2008. So we were going to stick with that theme today of playing Jailhouse Snitch, 2008 testimony. But a lot of you guys are very interested to see the mistress, Kelly Labonte, and what she testified to. I'm going to sneeze. I got this Yankee candle in my background that's really screwing up my sinuses right now. Oof. I love these candles, but they really mess with my allergies. So a lot of you guys are curious about Kelly Labonte's testimony. So type in the chat, if you haven't voted already, if you're new here, type in the chat number 1 after we're done with Dillard if you want to see Kelly Labonte, or type in the number 2 if you want to stick with the theme of Jailhouse Snitches. We are planning on going live tomorrow. We're going to play the 2008 pathologist, Michael Chambly, because he got absolutely destroyed on cross-examination in the modern day trial. And I was originally planning on playing Kelly Labonte tomorrow as well. We'll be live at 8:30 because there's no trial tomorrow because of the holiday. But if we get votes today, enough of them, we'll play Kelly Labonte right after Dillard. And if there's still time, we'll go back to some Jailhouse Snitches. I do plan on being live for at least 8 hours today. We are 3 hours and 42 minutes into the stream, so we'll play as much of that as we can. And then tomorrow at 8:30, we'll be live again. So let me get to part 3 of Aaron Dillard. What do you guys think of Dillard so far? Do you think he's credible? Defense is really coming at him. And that's kind of a first that we've seen Craig Albee go hard at these witnesses. We're used to that in the modern day version of this trial. Jensen's defense team is going for the jugular with every single witness. What do you guys think? Do you still think that Dillard is credible? Or do you think now maybe we're starting to question it a little bit? Curious to see what chat thinks. Sorry, my allergies. These candles, I love these candles, especially this one, this midnight summer, whatever it's called. This one bothers my allergies like crazy. This is a man candle. I love the way it smells, but it just kills me. God. All right, there's a commercial that's being played on this archived footage, so we're not playing the commercials because we got to be careful with that. So as soon as these commercials are like 20 or 30 seconds. As soon as they're done. Oh my God. Sorry guys. I'm literally dying. I'm going to have to blow this candle out and open a window. Holy Christ. All right, here we go.
All right, go ahead, Mr. Albee.
We try to wrap up this area fairly soon, Mr. Dillard, but do you remember another victim in Lithuania named Jonas Kleizas?
His daughter, yes, is Jurata Kleizas.
Well, you met with Mr. Kleizas himself, right?
Yes.
After meeting with his daughter?
Correct.
And his daughter wanted a work visa to come to the United States, right?
And she wanted a legal work visa to come to the United States.
So it's hard for Lithuanians to get a visa to come to the United States, right?
Well, it's easy actually if you're upstanding. It's easy if you've got a job and you have a little bit of money, because then they know you're going to return.
So these people kind of deserved what they had coming to them, huh?
No, I would never say that. That's the wrong way to put it. They were just looking for an alternative way to get to America the wrong way.
And you met with Mr. Kleizas, right?
Yes.
You presented yourself as a very polite person, right?
Correct.
Presented yourself as very sincere, correct?
Yes.
Much in the way you're doing today, right?
Yeah. Yes.
Mr. Kleizas, after meeting with you, was sufficiently impressed that he asked about getting a visa for his son, too.
His son was already in America illegally.
What was the question?
Yes. Then yes.
And so then he said he wanted to purchase a visa for both his daughter and his son, correct?
Correct.
And he gave you $4,450 for on one occasion, right?
I don't recall the exact figures.
Does that sound about right?
Sure.
And $4,900 on another occasion.
Possible.
And the second time he was $200 short, right?
I don't remember that.
You don't remember being a nice guy and saying, forget about the $200?
No, I don't remember that.
You told him that you knew people in the embassy that could help?
Yes.
That was a lie?
Yes.
You had them give you their passports, right?
Yes.
And then you didn't produce any visas, right?
Correct.
You had no way of producing any visas, right?
Correct.
You called yourself in your recorded statement with Mr. Jamboys and Ms. Gabrielle, you said you were a middleman.
Mm-hmm.
Yes.
Yes, to answer yes.
Yes.
But this was your con game, wasn't it?
Not entirely. There were other people involved.
You were the one who dealt with the people, right?
Yes.
You're the one who took their money.
Correct.
You're the one who did not produce any visas for them, right?
I believe I've said that. Yes.
His daughter, after not getting the visas for several months, reported you to the police, right?
Correct.
You made arrangements to meet with Mr. Kleizas, right?
Yes.
You begged for just a little bit more time so that you could get some money together?
Sure. Yes, I did.
And really, you were just begging for some time so you could flee, right?
Not correct.
Did you end up in a Latvian prison then too?
Yes, after I was indicted.
Because you were in Latvia when they issued the charges, right?
Not correct.
How'd you end up in the Latvian prison?
I ended up in Latvia. I was released. I was charged and let go, and I left the country. I didn't understand that I wasn't allowed to leave Lithuania. And I went to Latvia, and I was arrested in Latvia by Interpol. I believe if you got the transcripts from the court proceedings, you'll see that a document was never translated to me, nor did I sign off on, that said I couldn't leave the country. That was ruled in court.
That was someone else's fault.
Excuse me?
That was someone else's fault?
Is there fault to be put on anybody? If I don't know, there's nothing I can do. If I didn't know I wasn't supposed to leave the country,
Mr. Dillard, there's no question on the floor.
Oh, I thought there was.
So you'd agree that the judge in sentencing you could consider what kind of man you are, right?
I believe I've said yes to that already.
You would agree that you're a liar?
Sure. Was.
You've been convicted 8 times
Possibly, it sounds about right.
in the United States.
I don't know if the number, I thought that was including Lithuania.
You thought that included Lithuania?
I believe that's what I just said.
Well, you have 5 convictions in Lithuania alone, don't you?
I think it was read into one conviction, so that I count that as one because everything was read together. I don't think there was 5 individual case numbers, it was one. So that's 5 counts of one case, I believe.
Don't you have 8 convictions here?
Excuse me?
Don't you have 8 convictions in the United
I
States?
think I just said I thought it was 7 and then, or 6, and then with this one 7. I'm not sure exactly how many convictions I have. Can you tell me? So I know.
You'll acknowledge your convict many times over?
Yes.
Well, here's the easel.
Con man?
Convict, yes, convict.
And a con man, right?
Sure.
Here's the easel.
You're a thief?
Sure, was a thief, yes.
Something funny, Mr. Dillard?
I could just say I'm a criminal. I mean, I don't know what this is about. I mean, I was.
Anything else you'd like me to add?
Yeah, no, you're doing good.
Do you have any remorse for any of those activities?
Absolutely.
And now this is all in the past.
Absolutely.
Was it in the past when you wrote to Judge Fisher? He's one of the judges who sentenced you, right?
Correct.
In a letter from June 2003.
Objection, Your Honor, it's irrelevant. It's hearsay and it's irrelevant.
Do you recall writing to Judge Fisher, "This is my first time in the system, and I will tell you I have learned my lesson, and I will not fail on probation. I have made some terrible mistakes, and I hope you believe me when I say that I won't do it again. Please take this letter as a respect for you and your court, and please consider what I am asking. Thank you. Sincerely, Aaron Dillard." Did you write that letter?
Yes, I did.
Man, that was funny. That was a funny exchange. Saw Dillard get irritated there. Craig Albee says, "Is there anything else you want me to add to this list?" That kind of made me laugh. I don't understand. Why can't you just write criminal? What's with these other words? Hilarious. Here we go. Man.
After revocation in 00CF 1181, you told Judge Milosauskas, page 11.
Oh, there you go. Look at that. He went in front of Milosauskas.
Line
Hang on.
2.
Let me pause
I just want to get this behind me. I want to pay the restitution.
Let me pause this. So Milosauskas is not the only dinosaur on this. This is a new detail. We didn't know this. So this is crazy. So we're getting new details from these cases, this 2008 footage. So Aaron Dillard is the first United States citizen to be extradited to Lithuania. So there's some, U.S. history for you. That was crazy. That was an interesting, cool little deet that we got from this. Now we're hearing that Dillard went in front of Judge Anthony Milosauskas, who is presiding over the Jensen case now. Man, interesting. The details that are coming out. Only here on Never Stop Media are you getting this kind of coverage.
And be done. And I don't want to be in this situation ever again in my life.
I still never want to be in this situation again.
Did you ever pay that restitution?
I am working on it.
How much were you supposed to pay?
There's no fixed amount. I mean, I know I owe about, in restitution with extradition costs and everything else involved, I believe I owe about $11,000, $12,000.
How much did you pay?
I'm not sure.
$100?
More than that, I believe.
Less than 500?
I believe it could be more, could be less, around there. I'd say around $500.
This case is 00. That means it was filed in 2000?
Yes, it does.
And you've put together maybe $500 on this case and all your other cases since then?
I was convicted in 2004 or 3, I believe it was, when I actually got convicted of the case. So it's only been 3 years, and I've been in prison for 1.5 years of it at least. So I've actually only had this ordered for how long? I mean, 3 years and 1.5 years, maybe 2 years I've been in prison of it. So I've got about a year to pay on it, and getting a job after being in prison is kind of difficult. And I've been paying what I can. My goal is to pay that restitution.
Now, when you took that money from Cassandra Ivey, you didn't apply that to the restitution, did you?
I was hoping to win.
Just like today, huh?
I don't know what I have to win today. Do I have anything to win? I don't think this is winning anything.
When you're told that you must tell the truth, it's Mr. Jamboys who decides what the truth is, right?
No.
It's Mr. Jamboys who has to be satisfied with your testimony, true?
I don't believe that. I don't believe that. The offer they made was to tell the truth, and they would make a recommendation. I am telling the truth. I believe it's for them to tell me if I'm telling the truth. I mean, the truth is what it is.
You understand that if we over here believe you're not telling the truth.
And that's your job to believe I believe.
We can't pull any strings like Mr. Jamboys, right? You know that.
Okay.
You know yourself pretty well?
Still, does anybody? I don't know. I mean, I'm trying to know myself. That's kind of complicated with any issues that you could have. I mean, who really knows themselves internally? I don't even think, I don't know myself. I guess I don't know myself all that well, and I'm still learning.
Do you have an opinion as to your own character for honesty?
Sure.
And it's that you're not an honest person.
You're making my opinion now. I guess my opinion of myself is that I'm trying to be a good person now. I've been through a lot in my life, and I've done a lot of bad things. And I guess I was a bad person at one time in my life. That's my opinion. But bad people sometimes can be good people. Just got to figure yourself out.
And so, as of May 31st, this all changed? When you were crying with the police, not wanting to go back to prison?
Was I crying with the police? I'm just wondering, because I thought I said that. I don't recall that, and I'm just making sure. The fact of me changing, there's a lot of things that changed my life. My mom died while I was in prison. There's a lot of things. I almost lost my wife. And there are things I never want to have to experience again. I never got to say goodbye. Things change.
Well, just like when you told Judge Fisher that you made some terrible mistakes.
I did.
And you hope he believes you when you say you won't do it again, right?
I asked him to.
And he shouldn't have believed you at that time, should he?
I think he should have believed in my intentions, and that's what I asked him to do. I made mistakes, and I did it again.
Mr. Dillard, it's fair to say that it's easier to tell a lie when you mix some truth in with your lie.
I don't think that's easy anymore.
Let's talk about your experience with lying. You found that to be the case, right?
Excuse me?
You have found that to be the case, that you can...
No, I haven't found that to be the case.
You think it's easier just to lie 100%?
I think it's easier to tell the truth because I bet you the outcome is a lot better. So what I do and what I think sometimes are two different things. It's a choice. You have a choice to lie or you have a choice to tell the truth.
When you were lying to Deborah Spears.
Can I ask when I lied to Judge Deborah Spears?
Mr. Dillard,
I don't know.
You lied to Deborah Spears, right?
Oh, yes, I did about her name. That's correct. My name. Yes, I did in the bar. Sorry. I'm thinking of your
Mr.
implications
Dillard.
about borrowing money and things like that.
Mr. Dillard.
Yes, sir.
You need to wait for questions.
Okay. Sorry.
When you came into the Kenosha County Jail on August 14th, you knew all about Mark Jensen's case, right?
No.
Did you know anything about it?
Yes.
You had read about it, right?
Yes.
You read about it in the Kenosha News, right?
Correct.
You received the Kenosha News in prison?
No.
You'd seen the case on TV, right? No?
No.
You'd seen Mr. Jensen's picture, right?
No.
I'm sorry, I couldn't hear you.
No.
Now,
let me pause it there. Did you guys catch the inconsistent statement? Earlier in his testimony, he said that he was aware of who Mark Jensen was prior to entering the Kenosha County Detention Center. He said he had read newspaper clippings. He said that. Did anybody else catch that? Now he's saying he's not aware.
you met with these prosecutors and gave a statement, right?
Yes.
Call that? And it, bottom of page 7, top of page 8. When you came in, you said, we just started talking and they said who he was. And I'm like, oh, you're a pretty popular guy lately because he was in the newspaper and I saw his picture.
I said that I don't remember saying I saw his picture. I'm sorry. I didn't see his picture.
What's the truth though?
I didn't see his picture in the paper. I don't remember seeing his picture.
But you told these prosecutors you saw his picture.
Yeah, I could have at the time. I with everything that's going on, I don't believe I believe I did say that, but I don't know for sure of the incidents. I don't have the article in front of me, but I don't remember seeing his picture in the newspaper because the papers we get are all edited and censored and everything's ripped apart in them.
That is true.
Opinion that
is true.
The
Let me
prisoner
pause
of the
for a
jail
second.
doesn't want you.
So jails do that. They do rip pages out. They will, black out certain articles. They do that in jail systems, and Kenosha definitely does that.
Did you see any photographs of Mark Jensen?
No, I believe that there's a lot of things in the paper, and sometimes there's things on back pages that want to be taken out. It could be anything.
Mr. Dillard, you told these prosecutors you saw his picture, right?
I don't remember if I did or not. It's been how long? I could have, but I don't recall it.
So you have a hard time remembering whether you said that in October, right?
All right, we got a commercial. We got to be careful showing some of these commercials because of these songs and certain footages. So, man, I don't know. What do you guys think? Type a 1 if you think Dillard is credible, or type a 2 if you are not sure about this guy. There's some things that I'm like, I don't know, man. It probably could have happened. There's some things I'm like, I don't know. This guy's full of shit. Full of shit. He's definitely got me laughing. Some of the chat over on Facebook is dying over here. And Dillard's getting irritated. Can't you just call me a criminal? What's with the other words? Somebody on YouTube asked if Dillard was in Dodge Correctional right now. I'm not sure. I haven't looked into Dillard's background as of late. So all you little internet super sleuths, if you guys want to go investigate that, Give us the answer.
I don't believe it was before that. That's what I'm getting at. Is it the question of, did I see it before or after?
Well, I will read it again. Bottom of page 7, top of page 8. Well, when Mark came out, this is right when you get there. When Mark came out, it was just basically general conversation. Hey, how's it going? Things like that. And then we started talking and they said who he was. And I'm like, oh, you're a pretty popular guy lately, because he was in the newspaper and I saw his picture. I was like, oh, you're a pretty popular guy lately. And he goes, yeah, and like blew it off a little bit. And then we just started talking from there. So that's how we met and introduced.
Okay, so maybe the picture said I said it, but I don't remember seeing this picture in the paper. I've seen it in the paper since then and since prior to giving the statement. So I don't know if I misworded it and said I seen him in the paper. I'm sorry.
But you had read about his case before that.
Yes, I have. I read about the Klug thing.
Mr. Dillard?
Yes, I'm answering the question.
The first day you were in the first full day that you were in that jail, 2 inmates beat up another inmate?
The first full day?
Yes.
So that'd be the second day, that'd be 14th, 15th?
Yes. Is that right?
Yeah.
You were only there 2 full days, fair to say?
2 full days.
As to when?
When you were in the Kenosha County Jail, during this time when you talked about being with Mark Jensen, you were in the Kenosha County Jail 2 full days, right?
Plus some additional time, yes.
2 full days, right?
No, what do you mean by 2 full days? I was there for 48 plus about 20 hours, so that's over 2 full days.
You mean all day on the 15th and all day on the 16th, right?
I was there in addition to 2 other days. Partial days.
Partial days and 2 full days.
Yes.
And so on one of those 2 full days, 2 inmates beat another inmate, right?
Yes, that's correct.
Michael Clark was beaten, right?
I don't know his name.
And there was a fight over food, true?
I think there was a little bit more depth to that than just being food. Yes, but the food was involved in that fight.
They were trying to take 2 inmates were trying to take Michael Clark's food, right?
Yes.
And they beat him with a sock full of dominoes, correct?
That's correct.
And everybody in that pod saw that, right?
I can't verify what everybody else saw, but I saw it clearly.
Okay, Mr. Jensen saw it?
Sure, if he says so.
Did you see, what do you recall about that? Was Mr. Jensen there?
He was in the cell block, yeah. I mean, but what do you want me to answer to what he saw?
Just asking what you remember, Mr. Dillard.
I remember sitting eating my lunch watching the guy get beat up.
You didn't intervene, right?
You know what? Me intervening in jail is just going to catch me a charge. You can't do that. You're not allowed to.
That's right. You're not allowed to intervene, right?
That's correct.
You're not allowed to report that to the guards, right?
If asked.
And when the guard came and Mr. Clark started telling the guard that he had just been beaten and he was bleeding, one of the inmates attacked him again, right?
Yes.
Right in front of the guard.
Yes.
Yeah, I want the record to be clear on something, though. When you say you're not allowed to report that, I think you're answering to 2 sovereigns there. You're not allowed to intervene as a jail rule, is that correct?
Well, is that correct? Yes, I believe so.
And not allowed to intervene is an unwritten rule among the prisoners, is that right?
You could go as far to say.
That's not an official rule of the jail.
Correct. I mean, it's both. I believe they tell you if anything happens, just go away. Don't involve yourself in it.
But there's no rule that you're not supposed to report something.
No, there's no rule written on that.
Go ahead.
From your jail experience, you'd be fearful.
All right, let's pause here because we want to answer this question. Chad has a question. Is he currently locked up? So his testimony right here is kind of interesting. You know, definitely keep your head down, keep to yourself, keep your mouth shut when you're in jail, because you will catch a beating. So it does look like he is currently in Dodge Correctional. He has an open case September 7th, 2022 for resisting or obstructing an officer. It's a Class A misdemeanor.
Parties to appear remotely via Zoom, February 20th, 2023. He's got a court hearing. That's one case. Let's look at another case here. So it'll be interesting. Is he going to appear on Zoom for the Jensen trial? We're going to see some more boring ass recorded video. Filing date 8/9/22. Jesus Christ, this guy. He has a burglary to a building or dwelling with a repeater enhancement, because he's obviously got a background. So Wisconsin attaches enhancements of repeaters. That's a Class F felony. Darlene, do you want to go to the courthouse and get us the copies of the criminal complaints on these? I'm not in Kenosha anymore. I might be able to go to Milwaukee because we can see this shit there. I might be able to go there. Hey, listen, if you guys want the criminal complaints, that's going to cost us some money. So if you guys want these, hit those donation links. That'll help us pay for this shit. We'll get the criminal complaints so we can read that stuff off to you. So he has a hearing for this February 20th, 2023 for that too. And then the third one. So these are out of Waukesha. Waukesha has been in the news, obviously, because of Darrell Brooks, the guy that drove his vehicle through the Waukesha parade, and Judge Jennifer Doro, who, made national fame over that case. We wrote an article about Doro, if you guys want to check that out on the website, primarily about her campaign manager being kind of a scumbag. And it does kind of expose some stuff that Doro has not been truthful about. And we broke some news Friday that Judge Doro's campaign manager is under police investigation. Let's see. The third crime here, it's got 2 counts. Fraud against financial institution, value exceeds $10,000 but does not exceed $100,000. That is a Class G felony. And he has a second charge, fraud against financial institution, value exceeds $500, does not exceed $10,000. Same court day. Crazy. So there's your answer. So Dillard is in custody right now in Dodge for this shit. Holy God. That was a great question on YouTube. So, and then Darlene gave us the answer. We just looked it up. There you go, folks. He's over here testifying about how he's, trying to be a good person, and he is not. This is where I think we can continue to judge people, right? I think it's wrong if somebody does a crime, dependent upon the crime, obviously, if they're chomos and shit, fuck them. But if somebody does a crime, and they fucked up and they're trying to get their shit together, is it fair to judge people? But if they continue with the same negative actions and behaviors, then I think we can judge them appropriately. Man, here we go. Craig Albee, crushing this guy. This dude, Dillard, I'm going to tell you right now, Jensen's current defense team is going to mop the floor with this guy, especially because he has all of these current things and he has not tried to turn his life around. I cannot wait for the modern day questioning of this guy.
To report that, true?
Yeah, I suppose you would, yes.
Mr. Jensen showed you the transcript of Mr. Klug's testimony?
Yes, he did.
You read it?
Yes, I did.
Several times, right?
Once.
And then you went through it with Mr. Jensen and you talked about certain portions of it, true?
Again, Your Honor, I object to counsel using the conjunctive after a witness has denied or corrected the answer to the previous question. Rephrase your question.
You read it once and then you went through it some more with Mr. Jensen as you went through specific parts, right?
I don't recall that. I don't recall us seeing it a second time. I believe we discussed it, but we never actually had the documents out and went over them.
And most of your information about Mr. Klug came just from reading the transcript, right?
That's where all my information came from, besides what Mark told me.
Well, you recall during your recorded interview with these prosecutors that you kept referring to him as Mr. Klug, as in rhymes with jug?
Yes.
And that's because you hadn't heard Mark say his name so much as you had read it and thought his name was Klug rather than Klug.
Mark said his name plenty of times, but I still know how many times have I made a mistake in here? I still know it's Klug and I still say Klug. It's just the way it comes out for me. I read it as I read it. I say it as I read it.
Did you take notes while you were in the jail?
Not that, no.
Not that what?
Not that I recall taking any notes. I might have taken notes about other things, about my case, about things like that.
So you were taking notes while you were in the jail, in the Kenosha County Jail during mid-August 2007?
Sure, because I was going for sentencing, yeah. Yeah, I was taking notes.
And you took notes about Mr. Klug's transcript?
Is that what you, no, I did not. I don't know why you're saying that.
You deny taking any notes?
That I believe, yes.
It was a week later before you wrote to your attorney, right?
Yes.
And in that time, you're saying you didn't keep any notes regarding the conversation that you had with Mr. Jensen?
The ones I wrote to my lawyer.
Well, you wrote a letter a week later. I'm asking you if you had notes that you compiled prior to that time.
No, I don't believe so.
You just remembered everything in that letter off the top of your head, all those details?
Well, I may have written a letter and then wrote 2 copies of it to make sure I worded everything right. So if you call those notes, I don't know.
Were you writing a letter to your lawyer while you were in the jail?
No, while I was in prison.
I'm asking you when you first put pen to paper and took notes, Mr. Dillard.
I don't recall.
Notes about what? Oh, this is already testified. Evident from the record, the objections over.
Notes on Klug's testimony? No, I don't recall ever taking any notes on his testimony.
Notes about anything that occurred with Mark Jensen? Anything about Mark Jensen's case? Let's put it that way. When's the first time you took any notes about Mark Jensen's case?
I don't recall ever taking any notes about Mark Jensen's case.
When's the first time you ever put pen to paper regarding Mark Jensen's case?
I believe it was in prison.
A week later?
Mm-hmm.
Is that it? You have to answer.
Yes, sorry, yes.
So it's a week later and you had nothing to refresh your recollection up to that time?
Just my memory.
You remembered all those details without any notes?
I believe so.
Man. The sound is really loud on that commercial in my ears. That just blew my eardrums out. All right. Welcome to the stream, everybody. If you're just tuning in, we're playing some old archived footage from the 2008 trial. We have Jailhouse Snitch Aaron Dillard up on the stand. From the votes, it looks like we were going to stick to the topic of jailhouse snitches because there are quite a few of them that testified in 2008. And from the votes, I think we're going to play Kelly Labante's testimony. Hang on, we just had a glitch on the footage here. What the shit? The commercial froze on me. Hang on, guys. Sorry. For some reason, that commercial froze on me. Let me get back to
testimony. Now I got to find the spot. Damn it. All right. Well, while I'm finding the spot, this is a great time for you guys to ask questions. What questions do you guys have? Sorry, for some reason, technology sucks. For some reason, the commercial froze and wouldn't play. I did post in chat on both things the article we wrote on Doro. If you guys are interested, the article does not talk about the current investigation that the campaign manager is under. It's still a developing story. We're the only media company that has released that information. We'll release more of it shortly. We do know what it is about, but we haven't publicly said that yet. But we will release more of that later. Sorry, chat. I got to find the right spot here. Sorry, this froze on us. I don't know why it did that. That is irritating. We were having a good stream up until that point. If you guys are new to the platform, so we are an independent investigative journalism company located in Southeast Wisconsin. If you're not following the Facebook page, that is NSM News Updates. If you're not following YouTube, that is Never.Stop.Voices. Chat, refresh my memory. Are we on the third video or are we still on the second video? Who remembers? Who's been here? Are we on the third video of Dillard's testimony? Want to make sure I get the right. Yeah, it's the third. I thought so. Fuck me. Sorry. We do use naughty words here, so feel free. Get crazy. Part 3. Shit, I wish I would have looked at the timestamp, but I'll find it. We'll get there, chat. Bear with me. We'll get there. You guys were talking about Brooks. That was a crazy trial. For those of you that don't know, a little update about Brooks. So he did, they didn't file the appeal officially, but he filed his intent, and he does have an attorney. It's a public defender, so let's not be bashing the attorney. They don't have a choice. They get appointed this stuff. He does have a public defender to represent him for a possible appeal. The public defender is going through all of the trial notes on that, the transcripts, which, Jesus, God almighty, there's 20,000 pages of transcripts. So he's going through all of that to see if there is any appealable offenses from the Brooks trial. Now, one of the biggest concerns is that, while Darrell Brooks was found competent from a insanity stance to stand trial, there is question on his competence on whether to represent himself. And we reported that. We reported that first here on Never Stop. We said that might be a thing, and that is what is happening. So we do have an article up on, I'll share that with you guys too in the chat here. We did write an article specific about Darrell Brooks and his sentencing, what he got, all of that. And kind of some history surrounding the initial incident when he drove the car through. And for those of you that are not from Wisconsin, the ramifications that we all had to suffer out here in Wisconsin because of that. If you guys remember, this incident happened
Here we go. So I found the spot, chat. So that incident happened 2 days after the Kyle Rittenhouse verdict. And there was a lot of bullshit that went around that this was a hate crime. This was intentional. It was retaliation for the Rittenhouse verdict. That was rhetoric that the right had put out there. That has been debunked multiple times, even by law enforcement. Don't buy into that bullshit because it's not true. Despite his rap, despite some of his posts on Facebook, we're well aware of what that shit said. We get it. We've seen it. We've talked about it. You know, if we're going to go by what he says in his rap, right, then we got to convict all rappers. Okay. It was not an intentional attack towards the white community. You know, it's definitely intentional continuing to drive your car to a fucking parade. But it was not a hate crime. So here's the article on that. If you guys want to read that. Okay. So a lot about the sentencing, things like that. But it talks about a lot of stuff that happened here in Wisconsin, and Waukesha in general, with a lot of white nationalist activity, a big spike in that activity from those types of people and groups. And if you're not from Wisconsin, a lot of you are unaware of what happened. So here we go. Here's the notes thing.
Mr. Jensen?
The ones I wrote to my lawyer.
Well, you wrote a letter a week later. I'm asking you if you had notes that you compiled prior to that time.
No, I don't believe so.
You just remembered everything in that letter off the top of your head, all those details?
Well, I may have written a letter and then wrote 2 copies of it to make sure I worded everything right. So if you call those notes, I don't know.
Were you writing a letter to your lawyer while you were in the jail?
No, while I was in prison.
I'm asking you when you first put pen to paper and took notes, Mr. Dillard.
I don't recall.
Notes about what? Oh, this is already testified. From the record, the objections order.
Notes on Klug's testimony? No, I don't recall ever taking any notes on his testimony.
Notes about anything that occurred with Mark Jensen? Anything about Mark Jensen's case? Let's put it that way. When's the first time you took any notes about Mark Jensen's case?
I don't recall ever taking any notes about Mark Jensen's case.
When's the first time you ever put pen to paper regarding Mark Jensen's case?
I believe it was in prison.
A week later?
Mm-hmm.
Is that you have to answer?
Yes, sorry, yes.
So it's a week later and you had nothing to refresh your recollection up to that time?
Just my memory.
You remembered all those details without any notes?
I believe so.
Come be a part of.
Man, nobody cares about Disney. All right, let's hope this footage doesn't glitch out this time. I think this is about where we were when it glitched the last time. Maybe there's something in the footage. Okay, here we go. It works. Thank God.
Denied his guilt, right?
Yes.
He explained to you all the things that the prosecution had wrong that supported his innocence, right?
He explained how they were wrong.
And that's what you'd expect anybody who is accused of a crime they didn't commit to act, right?
In jail, you expect everybody to act like that because everybody's innocent.
It's just like you're innocent in that Racine County case you're facing right now, Mr. Dillard.
Absolutely.
Mr. Jensen explained all the reasons why he felt he'd be acquitted in this case, right?
I'm sure he didn't give me all the reasons he thought, but yeah, he gave me plenty.
And for instance, one thing you mentioned is that the prosecutor at the previous hearing had tried to claim that Benadryl had been mixed with antifreeze, right?
Yeah, he claimed that. That's what he said.
Mr. Jensen told you that they were saying that there was liquid Benadryl mixed with antifreeze, right?
Yes.
And he said, that's foolish because there was no Benadryl in the house, right?
He said there was only gel caps in the house.
Right, so it couldn't be mixed with antifreeze because they were gel caps.
Correct.
Right. That seems a reasonable enough response to the claim of mixing Benadryl, liquid Benadryl and antifreeze, right?
If in your eyes, I don't know what's reasonable. No, I mean, sure, if there's none in the house, I would suppose him saying that it would take 2 gallons of, or whatever amount of Benadryl plus antifreeze, the way he made it sound, she'd be full of Benadryl.
He told you that the police had been claiming that there was no antifreeze in the house,
Yes.
right? And that the prosecution thought that that was significant, right?
Correct.
They told you that there actually was antifreeze in the house and that they had not done a thorough enough search to find it, correct?
He said that they had taken pictures of the house and that he found it in the pictures.
And so he'd be able to show that the prosecution made a mistake in that area, correct?
That's what he said to me, correct?
He told you that his wife had suffered from depression, right?
That's correct.
He said that because of her depression, she had committed suicide, right?
That's correct.
He said that she had been self-medicating with various antidepressants, right?
That's correct.
He said that the doctor had prescribed Paxil, right?
Correct.
He said that Mr. Klug could not be trusted because he was an attention getter, right?
That's correct.
And he said Mr. Klug was a liar, right?
That's correct.
He told you concerns about his wife's treatment of their children, right?
Correct.
He told you that the prosecution or the prosecution's expert had lost a bunch of papers, right?
That's what he told me.
You had read that in the newspaper as well, right?
I don't recall reading that.
You may have or may not have.
I don't think so, but no, I would say that I didn't read that.
And to you, that sounded potentially significant too, right?
Yes.
He told you that his wife, after taking the antidepressant prescribed by the doctor, the Paxil, had become seemed to have become a little bit like intoxicated.
Yes.
He told you that he couldn't explain why that would happen, right?
Yes.
And then he and his wife, therefore, had looked up Paxil on the internet to try to figure out what was wrong.
Correct.
Right? And because he couldn't figure out what was wrong, he told you that he went to the doctor the next day, right?
That's correct.
And that the doctor had prescribed Ambien to see if that would make his wife feel better or sleep more, right?
Yeah, I think we're drifting into 2 conversations though, because I don't think he told me about the Ambien and why he got the Ambien in the first place. He just said that they gave him Ambien.
Well, as I understand it, you spent the entire day of August 15th and part of the evening on August 14th talking with Mr. Jensen about his case, right?
Yes.
And during that entire period of time, the 14th and the 15th, Mr. Jensen repeatedly told you that he had not killed his wife, right?
Correct.
And he told you the basis for his defense is what you're telling us, right?
I believe that was the last day. Yeah, he did. He did.
And that included the fact that the doctor had prescribed various things for his wife, right?
Yes.
Including Ambien on the day before she died, right?
Correct. Well, yes.
He explained what happened on that day that Mrs. Jensen passed away.
Yes, I testified to that already.
Right, and he said that he told the kids that they'd take her to the hospital when he got home from work if she wasn't better.
Yes.
And he told you that his wife had insisted that he not take her to the hospital, correct?
No, I don't remember ever testifying to that.
Well, I'm not asking you if you remember testifying to something or not. I'm asking you whether that was said to you that you recall.
And can you repeat the question then?
Sure. Mr. Jensen. Actually, if I could have that last question right there.
A prior question was, and he told you that his wife had insisted that he not take her to the hospital. Correct answer. I don't remember ever testifying to that question. I'm not asking if you remember testifying to something or not. Answer all question. I'm asking whether that was said to you that you recall.
No, I don't recall that being said to me.
May have been said and you don't recall now, 4 months later, 5 months later.
I don't believe it was said to me.
You reviewed other documents in Mr. Jensen's possession?
I actually testified that I did not.
And again, I don't want to ask what you testified to. I'm asking you, did you review other documents?
No, I did not.
Did Mr. Jensen have other documents?
None that I'm aware of.
So your view is that all he had was Mr. Kluge's transcript?
That's what I believe. I don't know what he had. I don't know.
You were in a cell, right?
Never.
Never in a cell?
Not that I believe. No, you know what? Sorry. I may have stepped in his doorway, right in the cell between the two cage bars, but if that call that in his room. But that's when he was in there and I would talk through the door because you stand right in the doorway. So.
You were taken out early in the morning of August 17th?
I believe, yes.
You got there on the late afternoon of the 14th, is that right?
That was correct.
You stayed all day the 15th, all day the 16th, and then like 4 in the morning or something, they rousted you and took you out on the 17th.
Sure, yes.
And when you left transcripts in Mr. Jensen's bars of his cell, right?
No, I didn't.
Do you recall now whether you took notes?
No, I don't recall.
It's your claim that all day on the 16th, Mark Jensen changed his mind and just confessed these events to you.
Yes.
Your testimony is you spent the entire day talking about that with Mark Jensen?
My testimony was for about 6-7 hours throughout the course of the day, and that was my testimony.
So when were you doing this on that day? From when to when?
Exact times, I don't know, but the fight occurred, was it the 15th or the 16th? What day are we talking about, the 16th?
The 16th.
Oh, yeah, for the majority of the day. I'm not sure the exact hours. But as many hours.
What else happened that day? Anything else?
On the 16th?
No.
Nothing that I can recall as far as events. I mean, we watched TV, we took showers, things like that, ate dinners, ate meals.
Any conversation with any other inmates?
Dion Hardison, maybe a couple of the other ones.
How many times did you talk to Dion Hardison?
I'd say maybe 3-4 times.
Where were all your conversations with Mark Jensen on the 16th?
For the majority in the back of the day room.
Didn't you go to court on August 16th?
I'm not sure. If I did go to court, it probably for 2 hours, an hour.
Did you go to court on August 16th, Mr. Dillard?
I believe so.
Let me pause that right there real quick. I'm not believing that statement. If you're locked up, you're incarcerated, and you have a court date, you're not fucking gone for an hour or 2 hours. You are gone all day long. All day. And then you got to come back from court. You got to sit in a holding cell for hours. and then you get transferred back up to your pod. You're not gone for an hour or two. It's ridiculous. I don't believe that. So what they're trying to do, he's trying to be like, you weren't even here on this day because you had court. That's probably where he's going.
We're there for a sentencing, right?
Correct.
And you had that postponed?
Yes.
When you wrote do you have the letter? Mark's letter to his lawyer?
Yes, sir. Right here.
State's Exhibit 134, the letter you wrote to your lawyer. You told her you had some very important information in the Mark Jensen murder trial, right?
Yes, I believe I wrote that.
You felt that it needed no explanation as to what the case was, right?
Yes.
You figured she would just know what it was, right?
Yes.
Just like you had known when you came into the jail, you knew what the case was about, right?
Well, everybody knows what the case is about. Yes, I would say everybody knows what the case is about.
A lot of inmates were talking about the case.
Yes.
And you knew it was very high profile, right?
Yes.
You knew it was the kind of case for which you could get lots of credit, right?
If he talked, yes.
You knew you were facing several years in prison?
Yes.
And this was sort of your get out of jail free card, right?
I don't use it as that, but it helped me get out of jail.
You'd be in prison right now if you hadn't come up with this.
Potentially,
story, right?
Potentially I could have been.
Almost certainly you would have been, given what the probation officer was recommending, right?
That's a recommendation. Considering my crimes the first time, the judge gave me a year. I don't know if he'd give me more the second time.
Well, you don't think you'd consider all those probation violations?
I think he considered that the first time he sentenced me, and he only gave me a year.
You don't think it would matter to a sentencing judge that you continue to commit violations and new crimes?
I've never been revoked twice on the same case, so I don't know what they would think or what they would do. I can only base my opinion on what I got the first time for the same violations.
Now, you were very excited when you wrote this letter to your lawyer, Ms. Rosenke, right?
I don't believe I was excited. I believe that I expressed my emotion through, I don't want to be the jailhouse snitch.
Well, in this 7-page letter, you used like 25 exclamation points, right?
I always write like that.
All right. I don't know what's up with the air in courtrooms, but there's always someone hacking up along in the gallery. That is true. Jamboy was saying at the beginning of this testimony that he was sick over the weekend. So I guess they're just coming back. It's probably a Monday. So we know he's sick. He's recovering. He's been drinking a lot of tea, which has been cracking me up a bit. But yeah, there's always people that are just dying in court. It's crazy.
In this letter, is you took the information that Mark Jensen had given you on August 15th, denying his guilt in this case, right?
I don't know what you're asking me. I mean, I took what information that he denied it. I recall the letter saying that he professed his guilt to me. And he did that on the 16th, isn't that correct?
I don't, I'm not here to answer the questions in here.
I'm just making, I'm sorry.
You took Mark's story, denying everything, and you use those facts. Those are included in this statement, right?
It's incorrect.
You haven't included those? That, talking about things like taking his wife to the doctor, right?
Can you repeat the question so I can understand the question? Because I believe the question you asked me wasn't the question you're asking now.
But you included in this letter information that Mark Jensen gave you when he was protesting his innocence to you, right?
No.
Well, for instance, he says he took his wife to a doctor, right?
I think you're taking, can I answer this question like I want, or?
Tell the truth.
Okay, I think you're taking this question and you're reading into it the fact that we had conversations and then implying he didn't profess guilt, that I'm trying to tell what he said he did do and reading it like that. He told me he did these things and I wrote them and he said it two different ways. First time he said he did and second time he said he did. So the information I put in that letter is the facts that he said he did. I didn't use a negative one and make it a positive. I used a positive and kept it a positive.
You, on September 21st, you met, well, on September 21st, you were given a typewritten statement, right?
I don't recall the exact date.
You met with prosecutors and talked with them in mid-September, right?
Yes.
And then after you met with them, they typed up a statement for you, true?
That's true.
And they typed it up and then you approved it, right?
I don't know if I ever approved it or signed it or anything of the sort. Mr. Dillard, you've seen Defendant's Exhibit 139, haven't you? No, I've seen. Would you like this one back? Yes, I've seen this one.
And was this statement prepared in the manner I suggested, that you spoke with prosecutors and then they typed it up and then you reviewed it and said, yes, that's my statement, that's accurate?
I don't believe that's correct how I received it, no.
All right, tell me how the statement was prepared.
I gave a statement and then I was sent a copy of the statement.
Were you ever asked if it was accurate?
I believe when I talked to them, they asked me if I'm telling the truth and I said yes.
Well, you understand that you could give a statement to somebody and they could write it down and they could make some errors, right?
I understand that completely.
Okay. So did you read this for accuracy?
Not at the, I mean, I didn't receive it at the time I gave the statement. I received it, say 4 weeks later, 3 weeks later, I received a copy of it. So as far as accuracy, I don't even think I can remember what it says now to say if it's accurate or not accurate.
What's the last time you looked at this statement, Mr. Dillard?
Oh, that I read that? A month ago, maybe.
You're telling me you don't have one of these in your possession that you've read?
I do have one in my possession, but I don't recall everything that's said in it.
You're telling me you haven't read it in the last month?
That is correct.
You didn't go over this with Mr. Jamboys and Ms. Gabrielle at all?
In the last month? No.
Did you go over this with your lawyer?
No.
You haven't reviewed this statement?
I have reviewed it, but I don't recall what it says.
I'm asking you, have you reviewed it in the last month?
I don't believe I have.
Have you reviewed the letter that you wrote to Ms. Rosenke?
The letter that I wrote? Yes, I have.
You reviewed that before testifying today, right?
That's not correct.
When's the last time you reviewed that letter?
Oh, God. I think about 3 weeks ago, maybe.
It's your testimony that you haven't reviewed any statements for at least 3 weeks.
Yeah, I believe that's correct.
Did you ever review any transcripts of your recorded statement?
I asked for a copy. I haven't reviewed them.
So everything you're testifying to, you remember all those details, not having looked at any notes or anything else?
Excuse me, can you repeat that?
Have you looked at anything to refresh your recollection in the last 3 weeks?
No.
Give you back Defendant's Exhibit 139. We begin at line 5, Mr. Dillard. says at first Mark denied everything, right?
Mm-hmm.
He said,
Yes or no, please?
Yes, sorry.
he said that this was all bullshit, meaning this guy who would come out of the woodwork, right?
Yes.
DA had nothing on him, that they lost all the papers from the tox reports, correct?
Yes.
This is not inconsistent with the witness's testimony. How is this not hearsay?
Sustained.
Well, Judge, I need to, I think, get into this to show how his story was developed.
Let's take a very short break. Please don't talk about the case during the break.
Please, all right.
This is a very crazy part of this trial.
In the world.
I don't remember them bringing this up with Michael Chambly when he testified that they lost the original pathology reports. That is insane to me. That is absolutely insane. So that kind of begs to question, what did the original reports say compared to the new reports? And again, for those of you that are not from Kenosha, during this kind of time frame, this era of history, Kenosha was very, very corrupt. They're still corrupt. They lie about a lot of shit out there. We've written a lot of articles about that. But they were way more corrupt during this time. And to lose these critical documents, and then there's new documents, it really begs to question, was anything changed? It's really interesting to me. But I don't remember them bringing this up during Chambly's testimony. That might have been super crucial. Maybe it'll come out later on in the current trial.
Bottom line is this one-page statement is basically all exculpatory, and then it adds a handful of negative facts. And it's my belief he constructed this out of both materials in Mr. Jensen's cell and from conversations with Mr. Jensen, and then was able to use the materials to make additions to this kind of statement. And so I want to go through with how he obtained this information and had it put in a statement.
I don't understand what counsel is talking about, Your Honor. The fact of the matter is, this is a hearsay statement, and it's not inconsistent with the witness's testimony. Now, if it were inconsistent, then it's a prior inconsistent statement.
We don't need to talk about what could be. The bottom line is what you're asking me to do is allow you to go through a hearsay statement to show how it was assembled, but it's still a hearsay statement.
I'm not offering for the truth.
Well, then it's irrelevant.
No, it's because it's how he constructed it.
Well, how he constructed it is how he came up with a story. The creation of the hearsay statement is merely a written memorialization of the account. So it's the creation of the account that you're questioning, not the creation of the hearsay document.
But I need the details of how he created it. I mean, where did you get this information? And you inserted this.
Which you can ask him without reference to the written statement.
And well, he already has asked this witness extensive questions about where he got the information and asked him about newspaper articles and so forth. But I don't understand how that has anything to do with his witness statement. This is a hearsay document, and it's not inconsistent, as near as I can tell, in any way with the witness's testimony.
Well, I can also, I think I can even introduce it as a script, because the notion that he hasn't reviewed any of these things in the last 3 weeks, I think is.
You know, you're really asking way too much of me, Mr. Albee, when you ask me to assume that a witness is a liar in making an evidentiary ruling, which you do when you say these things.
No, I'm assuming that I have a good faith basis for that argument. I of course don't. I'm not asking the court to be a fact finder, but I think I would need this as a predicate to make that, because the jury hasn't seen this, so they can't draw that inference right now until I present.
Why should they see it?
So that they can draw the inference that he's lying when he says that he hasn't reviewed any documents, because his testimony so closely tracks this statement.
Now, this is a first. You're saying to me that the proof that the witness is lying is that his testimony is just too consistent with what he said in the past.
Yeah, it's memorized.
That is certain. That's certainly, I can't rule that out, but it's also possible that his story is consistent with his past statements because it's the truth. And it's not for me to decide, it's for the jury. And I understand you have a right to try to show that he's not being honest, but.
Your Honor, if counsel wants to introduce this document into evidence, I have no objection to that. Now, show it to the jury, let them read it. Let them see how this witness's testimony is completely consistent.
You want to accept that? And don't be surprised if it ends up there.
Yes, and also don't be surprised if the letter that he wrote to his lawyer previous to that is then being offered as a prior consistent statement, being offered to rebut an inference of recent fabrication.
It's not recent fabrication.
No, I will not hear argument on an objection that cannot even yet be voiced. So if you want to take him at his offer and put this into evidence, then we'll have to deal with what comes up after.
Understanding this will come up after.
Well, I'm understanding nothing.
Well, Your Honor, I will only agree to this document coming in, that this statement.
Has this got a number, by the way, so that the record will reflect what we're talking about?
Yep, it is marked. It's in
what
front
is it, number what?
D135?
139.
D139. Are you going to accept the stipulation to offer it into evidence?
Not yet, no.
And the stipulation, Your Honor, is it can come into evidence, understanding that D140 is going to be the letter that he wrote to his lawyer.
Well, I'm not going to.
As a prior consistent
I'm not going to
statement.
Conditionally admit something. Either we'll have to, each paper will come in on its own merits.
Well, in that case, Your Honor, this is a hearsay document. The state objects to it being introduced into evidence. And furthermore, unless counsel is going to be examining the witness about a prior inconsistent statement in D139, I object to any further cross-examination on it.
I think the bottom line is I think the document's hearsay. All right. We ask the jurors to come back in, please.
Look at these guys. This is so funny to me. Jamboy objected like crazy that this is hearsay, right? And then he backpedals and says, you know what? Screw it. Let the document come in after I just argued for 10 minutes that it's a hearsay statement. And he goes, let it come in. Let it come in. Let him show it to the jury, which is what Albie was basically arguing. And when Jamboy calls his bluff and says, put it in then, let's see what happens. Albie goes, yeah, I don't know if I want to do that. And Jamboy fires back with, because what I'm going to do then is bring this lawyer statement in. And all this is going to show is that his statements are consistent. So Jamboy called his bluff. That's so funny how they backpedal like this. But I have said on previous streams that statements are very consistent. It seems, and we know that lawyers sit and they coach their clients and witnesses and all of these things. We know this happens. But I've made mention that these statements seem way too rehearsed. And
While in the Kenosha County Jail, you had an opportunity to review a transcribed interview that took place between Detective Ratsberg and Mark Jensen, right?
That's correct. Oh, hold on a second. Did you say transcript between Klug?
No.
Oh, I was thought.
Mark Jensen and Detective Ratsberg.
Oh, no. Only Mark Klug or Klug.
You deny having read that transcript?
Correct.
you deny having read anything in that transcript where Detective Rathberg was talking about Julie's body being rolled over?
No, I never read anything like that or talked about it.
Do you not deny reading anything in that transcript about?
Objection. I object. The witness has said he didn't read anything in the transcript, and now counsel's just trying to introduce statements that are not inflammatory otherwise.
I'm going to bear with it briefly. Go ahead. In light of the fact that it's cross-examination, go ahead.
Do you deny reading anything in that transcript about Detective Rathberg accusing Mr. Jensen of pushing Mrs. Jensen's face in the pillow?
I never read a transcript of that.
Do you deny reading anything regarding Detective Rathberg's claims during an interrogation of Mark Jensen?
Yes.
An accident.
Right. Once again, nothing we can do about the commercials. It's archives footage. Thanks for tuning in today, guys. We are watching 2008 archived footage from Aaron Dillard's testimony. He is expected to testify in the new trial. Earlier, we put out some information that Dillard is currently incarcerated for multiple crimes.
About his concerns about Julie's treatment of the children.
He said that he was upset with it. He said that she was crazy, and he was angry because of the fact that, like I said, she'd have one kid would come home from work, and one would be naked in one room, and one would be the naked in the other room.
What were the circumstances under which Mr. Jensen said he came home and found one child naked in one room and one child naked in a different room?
The circumstances, I'm guessing time, day, and things like that, or what do you mean?
Whatever you know about the circumstances in which that took place.
He said it was later at night when he came home that happened. As far as anything else in regards to that subject, he just said she would do things like that a lot.
Did he say why the children were naked?
No.
Did he say why he came home later at night?
No.
Did he say why the children weren't in bed if it was later at night?
He did not.
What else did he say about Julie Jensen's treatment of the kids?
He said, let me think. That's the major one. Then he said something about something happened at a restaurant. She would snap at him like a couple occasions. She would yell at him in the restaurant, cause scenes, and then they would try to go out with friends and they'd cause scenes.
And none of those things about the kids support a confession that killed his wife, right?
I don't believe so.
He told you that she was taking medications for depression, right?
That is correct.
What did he say about his wife's depression?
Just said she was crazy, that she was nuts, that she was always never here nor there. She was just wild, I guess is what he said.
You were aware that the prosecution was accusing Mr. Jensen of killing his wife with antifreeze, right?
Yes.
That was well known, correct?
I believe so.
Did you read newspaper accounts of the hearings in August?
The only newspaper article I got to see was basically the Klug articles, because I really didn't get to see any newspapers prior to any of this, because I was in more solitary kind of thing.
So you knew about that even coming in about Mr. Klug, right?
Yeah, that's why I believe why I made the comment of him being pretty popular.
And in Mr. Klug's transcript, is there some discussion about this time in November when Mr. Jensen couldn't reach his wife when he was calling?
Yeah, I believe that the statements, Klug's testimony said that he was trying to call his wife and that he would repeatedly call her.
And Mark told you that he had been trying to call his wife and that she wouldn't answer the phone, right?
Objection to the form of the question, Your Honor. When he says he, is he referring to Ed Klug or is he referring to Mark Jensen? Which person and
It's
which
fine.
one?
I'll re-ask it. It's okay. Mark Jensen told you that when he was in St. Louis, Mark Jensen had called his wife repeatedly and she didn't answer the phone, right?
I don't remember if he said that or not. No, because I think the conversation we had about her only pertains to her throwing up all over the house.
While he was in St. Louis.
Yes.
He came home and found that she had vomited on the carpet.
That's correct.
He said he called the carpet cleaners to have that cleaned up.
Yeah.
And did he say that when you claim he confessed, did he say that was antifreeze?
He didn't say how that happened.
He told you that this was a sign of his wife's depression, correct?
I don't believe that's how that got introduced.
How did it get introduced, Mr. Dillard?
I believe that got introduced as far as the point of when, I believe that's when he was telling me that he screwed up and poisoned her before she left. That's how I found out about the throwing up all over the carpet.
Well, wasn't that part of your discussions about Mr. Klug because it was in the Klug transcript?
About him poisoning her before?
No, about there being an episode in St. Louis where she had gotten sick, when Mark was in St. Louis when Julie had gotten sick.
I don't remember that being in the Klug testimony. I don't remember if it was there or not.
And to sell your story to the prosecutor, all you really needed to do was add the part about antifreeze being mixed with juice, first of all, right?
No.
Objection, calls for speculation as to what this witness would be needed to sell his story.
Well, you wanted to get credit for this case, right?
I wanted to get a recommendation. I don't know what kind of credit you mean. What kind of credit?
When you wrote your lawyer, Mr. Dillard, you wanted some consideration for making statements against Mark Jensen, right?
Yes, I wanted to be safe.
Mr. Dillard, you wanted to not spend time in prison is why you wrote your lawyer, right?
That's not correct. I don't want to be the jailhouse snitch in prison.
The reason you became what you call a jailhouse snitch is because you wanted credit for saying things about Mr. Jensen, right?
I wanted my safety protected to be, I wanted my safety to be enforced to give information. I did not want to be in prison being the one that snitched on somebody.
Were you trying to get some release from prison or some other consideration in respect to your imprisonment through making statements against the accused?
Yes.
In fact, you wrote your lawyer in paragraph 2 of Exhibit S-134, Mrs. Rosenke, I would like to know if you can work a deal with the DA in my cases for the information I have in this case, exclamation point. I would like to know if I can get my record cleaned up and can get out of jail, or at least be released and have my supervision reinstated, but up in Milwaukee at minimum.
Yes, that's correct.
Right? And then you go on to say, I'd refuse to testify if I were in jail, right?
That is correct. I told you I do not want to be the jailhouse snitch in prison.
Right. But the first thing you asked her is, do I get consideration for this?
Objection, Your Honor. Under the doctrine of completeness, I believe the remainder of the witnesses.
That's for cross-examination. I'm not done with my examination.
Yeah, I've got here.
Right, first and foremost, you wanted to do this to get yourself out of jail, right?
Yes.
And then in addition, you were saying, I refuse to testify if I were to be in jail, as I will have fear for my well-being, right?
Absolutely.
Right. But that also gives you a little bit of leverage to insist that you be let out of jail, right?
Leverage. I don't know. I'm not sure, but I think I read in the paper an article that somebody actually did threaten my life. So if I was in prison, I believe it's a well-founded
objection.
Fear.
Move the strike.
I
guess the objection. I move to strike his volunteered answered it.
Objection, Your Honor. I believe that the answer was responsive to the question that was posed to the witness.
Well, I'm going to order it stricken for a variety of reasons, one of which is that he read it in the paper, and that is not of the caliber necessary for it to be received in the court, at least on the point in which he appears to have, on the point for which he appears to have offered it. So disregard it entirely. Go ahead.
When you say, I refuse to testify if I were to be in jail, that's trying to get leverage against the prosecutor, that either they let you out of jail or you won't tell your story.
It's not correct.
You are now willing to acknowledge that number one was getting you out, right?
Yes.
Let me give you exhibit 130, 134. And you have 139 in front of you.
Yes, 134.
It's the, no, it's the letter.
This?
Yeah. Get my copies.
Real.
All right, here we go. You guys missed my sarcastic comment. My mic was muted. So a little bit longer here on this video. There's one more video. I'm not sure how long it is. And then we will get to the Kelly Labonte testimony, since that seemed to have won the poll on what you guys wanted to watch next. So we will get to that, and I'm sure that will take up the remainder of our stream for the day, but we'll see. If there's time, we'll play more stuff. Make sure you guys like and share the streams out, everybody. Please share this out. If you like what we're doing here, the content we provide, hit those donation links. We really appreciate it.
As I understand it, it's your claim that Mr. Jensen told you that Julie Jensen was sleeping on her back and her breathing had improved. Is that right?
I'm not sure if it was her back or side. I don't know what I said.
Well, I'm asking, excuse me, I'm not asking you to read those right now. I'm asking you what you recall.
I believe she was laying on her side.
She was laying on her side initially?
Yeah, I believe she was laying on her side.
And was she turned from her side to some other position?
To her face, to her stomach.
And so it's your understanding that Mr. Jensen told you that she was turned so that she was flat on her stomach, right?
Yes.
Is that what Mr. Jensen told you?
Yes.
And that while she was on her stomach, she had her face in the pillow, correct?
Yes.
Well, is that what he told you or not?
Well, he told me he pressed her face into the pillow.
Okay, but initially he turned her and she was on her stomach with her face in the pillow, right?
I would have to assume it was in the pillow. He didn't specifically say her face was in the pillow.
Well, if you look at Exhibit 134, is it 134, the letter to your lawyer?
Mm-hmm.
The page 5, bottom of page 5. And where the beginning of the last sentence there, it says, so he rolled her. Do you see where I am?
Yeah, I think I do.
So he says, so he rolled her over on her face with her face in her pillow. He thought that would make it hard for her to breathe. He left her for a bit and came back and she was still alive, right?
Hold on, I was actually down a little farther when I said that she was sleeping and he rolled her over a bit and she did not wake up. So there's two parts where it says those words. Where's the first part you were talking about again?
I'm talking about the sentence that the first 4 words of the sentence are at the end of that page.
The end of page 5.
Yes. So he rolled her. You see that?
And he rolled her, or
so he rolled her. The last 4 words of the page.
Oh, so he rolled her. Okay.
Over on her face with her face in her pillow. Did I have that correct?
So he rolled her over on her face with her face in the pillow. Yes.
Correct. So that happened first, is what he told you, according to your letter.
Objection, Your Honor. Under the doctrine of completeness, I request that the preceding sentence be read.
Judge, the doctrine of completeness doesn't apply in this, and I don't have to do it in the order that Mr. Jamboys would like.
Your Honor, just a minute.
And Judge, the reason I'm reading this is because initially he said he didn't recall.
Jamboy can clean this up on cross.
Mr. Jensen saying that he rolled her over on her face.
It's true. Let's see how Schroeder rules on
the
this.
point where he said he pushed her.
I know that because of a thing that I went through where we had to prove completeness.
Read the whole
person that was lying against me.
Is that
Mr. Dillard?
Yes.
Starting with the prior sentence. Said she was sleeping on her back and he rolled her over a bit and she did not wake up. So he rolled her over on her face with her face in her pillow. He thought that would make it hard for her to breathe. He left her for a bit and came back and she was still alive. Did I have that right?
Yes, that's what it says here.
Is that what you remember or not?
Now that I recall the statement, that's how it happened.
It says, then he got up on top of her and pushed her head, and then you have in parentheses neck, into the pillow and sat on her back so she could not breathe and she died and you went to work. Is that how you remember it?
Yes.
And it's your recollection that what Mr. Jensen told you is that she was turned onto her stomach, her face was in the pillow, and he sat on her back. Did I have that right?
Yes.
Now, the defendant's exhibit 139, the typewritten statement.
Yeah.
That was typed up by the district attorney's office, right?
That's correct.
Based on information that you provided them, correct?
I believe so, yes.
If you go to the second paragraph, Mr. Dillard, and let's go to the last 3 sentences. It's beginning with he said that he then rolled her. You see that?
Yes.
And in this version, it says he said that he then rolled her from her back onto her side, correct?
Yeah, but this, yes, it does say that.
And he sat on her back, right?
That's what it says here, yes.
How could he sit on her back if she's on her side?
I don't believe I ever signed this statement, and I don't believe that I had a chance to say if it was all accurate or not. I think I testified that earlier, that I had no knowledge. I've had knowledge of what was said at that meeting, but I didn't review the statement with them and approve it and say that it was what it was.
Okay, let's go to the next sentence.
Okay.
He pushed on her lungs and her head until she stopped breathing.
Mm-hmm.
Yes?
Yes,
I read
sir.
that right?
Yes, sir.
And your first statement doesn't include anything about pushing on lungs. That's another discrepancy, right?
Well,
This other statement is not his.
Well,
it appears, according to what he's claiming, it's a summarization prepared by someone else.
I know the court might find it hard to believe. I have a point that I'll be getting to momentarily. That's important.
Well, go ahead.
The lungs you did not say in your first statement, correct?
This is a statement, like I said, that was typed up by somebody else. I believe I said he pushed on her back and that restricted her lungs.
Well,
or the ability for her to breathe.
Right. Your recollection, what Mr. Jensen said, is that he pushed on her back. right?
No, he sat on her back. I think he pushed on her neck.
Okay. Not pushed on her lungs, he pushed on her neck while sitting on her back.
Yeah, I think him sitting pushed on her lungs.
Okay.
Um,
Let me see if this reflects the differences in the statement.
Show the judge I object. And did you want to hear the grounds for the objection, Your Honor?
Yeah.
Shit, I'm constantly have a tendency to talk with the mic off. Now I gotta pause it. Damn it. I was trying to go through. Well, never mind. Anyway, under the doctrine of completeness, under Rule 106 of the Federal Rules of Evidence, when an incomplete writing or recorded statement is introduced in a trial by one party, the adverse party may require the introduction of any other parts or any other writing or recorded statement which ought, in fairness, to be considered contemporaneously with the writing or recorded statement originally introduced. This doctrine of completeness is to ensure the jury views the incomplete statement in its full context. This additional evidence is called explanatory evidence, and its purpose is to qualify, explain, or put the original piece of introduced evidence in context. Additionally, otherwise inadmissible evidence, such as hearsay, can be admissible under this rule if it is necessary to correct any confusion or wrongful impression created by the admission of the original evidence.
Well, I think that the issue I just raised a moment ago is the concern that I have.
I don't recall precisely.
He denies approval of the, I don't have the exhibit number, is it 135 or 139? 139 is the.
Well, this is what, it could be what the DA says, the district attorney's office says was said, because they typed.
You know what? I think I'm going to ask you to step out for a minute. Please don't talk about the case.
What do you guys think? You know, you guys watch trials a lot. Schroeder is like the one judge who just constantly interrupts to clarify questions, to ask his own questions. He's not the finder of fact when there's a jury. And Schroeder does this shit a lot. What do you guys think about that? Do you think that's proper? I mean, it almost sounds like practicing law from the bench. I could be wrong. I'm obviously not an attorney. But that just seems super questionable to me. I don't like that. I've never seen a judge interrupt so much like that with his own questions, clarifying things, and I don't know, man. He did that a lot during the Rittenhouse trial too. He does that through all his trials. But what do you guys think about that? As like the audience watching this,
Impeach him with a statement that he is denied is his own.
Know that I'm impeaching him on this. Let's say I find it curious that his statement has been modified to reflect the theory that's being promoted by the prosecution that's consistent with their photographs. The photographs are not consistent with what Mr. Dillard had to say. But then when the DA has a chance to type up his statement, she's now on her side and there's pushing on the lungs. That's curious in the sense that there's they are aware of what the autopsy report and the photographs show, and now there's been a change in how it's been typed up. That's, I think, problematic and relevant and open for me to argue to the jury after putting in the differences between the statements.
And he just very cautiously accused the DA
first
of
of all,
corruption.
I believe that the letter that Mr. Dillard wrote to his attorney precisely supports the description of this murder from Dr. Chambliss's perspective. I think it fits it to a T. And neither Ms. Gabrielle, who typed up this exhibit, was it D-134, the typewritten statement? I forgot which was which, but is this D-134 or D-139? Okay, D-139 is a statement that Ms. Gabrielle typed up after we had interviewed Mr. Dillard in the county jail with his attorney present. So his attorney is available to, I suppose, to testify about the circumstances surrounding the statement. It was a summary of a brief interview that we had with Mr. Dillard in the presence of his attorney to get a more thorough understanding of what it was he was saying. And at the time and this document, the typewritten statement is dated September 21st, 2007, and neither Ms. Gabrielle nor I had an opportunity to listen to the cross-examination of Dr. Chambliss and compare it to the photographs and compare it to the autopsy protocol, which is something that I did during the cross-examination of Dr. Chambliss. And it wasn't until after the cross-examination of Dr. Chambliss that I presented Dr. Chambliss for the first time with these photographs that he'd never seen before, and for the first time asked him to consider those in relation to what Mr. Dillard had told us. So on September 21st, 2007, neither Ms. Gabrielle nor I had any idea that Dr. Chambliss was going to be testifying about the cause of death in this case, and testifying in a manner which, as it turns out, very precisely corresponds to either one of these descriptions, either the one in D-134 or the one in D-139. But if it corresponds to any of them more particularly, I would say it corresponds more precisely to the letter, which is more detailed, than it does to the statement, which is a summary. Now, having said that, this witness has never affirmed that this statement accurately reflects in every detail his description of what occurred. I don't think there's anything here which is necessarily inconsistent in D1 in this typewritten statement, but the typewritten statement was clearly far more of a summary than the testimony that's been elicited here today. And actually, it wasn't even as detailed as the statement that this witness provided to his attorney, while these matters are still very fresh in his mind. So if counsel is, if the thesis here is that the DA's statement here more precisely corresponds to Dr. Chambliss's theory of the case than the letter, first of all, I think that's mistaken. And secondly, there's no way on September 21st that whoever typed that, when Mrs. Gabrielle typed this statement up, she would have any way of knowing what Dr. Chambliss was going to testify to about cause of death, since he had never offered us an opinion concerning cause of death.
Well, Judge, this is the third or fourth probably instance where now we find Mr. Jambois and Ms. Gabrielle as witnesses. It's a problem. I mean, we have a number of instances, for instance, with our police reports, for example, where Detective Ratsberg says something where the witness doesn't. I'll ask the witness about it, I'll ask Detective Ratsberg about it. And a lot of times, there probably are times when I want it to go one way, and there's probably times I could care less. It's going to impeach somebody. But the problem is, Ms. Gabrielle types this statement. I think I don't have to accept what Mr. Jambois says. I find it very curious, and it's all I'll say. I mean, they've had the autopsy protocol and the pictures for a long time. I find it curious that we have this lungs thing there that's added. I find it curious that it's the side instead of on her back, and that matches the pictures. And as this court will recall, when I was complaining about lacking notice of Dr. Shambles' suffocation testimony. I got a lot of, well, it's been obvious for a long time, and certainly since Aaron Dillard gave his statement, that this could be coming out, that it would be suffocation, because that's what Aaron Dillard said. And so, I take it that it would be reasonable that they reevaluated some of their evidence after learning about what Mr. Dillard said. They looked at this, and they thought, well, that could be close, but it's a little bit better here, and I find that curious, and I'm allowed to argue that curiousness to the jury. It doesn't smell right to me.
Well, Your Honor,
I have to tell you, I agree with Mr. Jamboys in his statement that the original letter by the witness to his lawyer is more in concord with what Dr. Chambliss's version is than is what was typed by the district attorney.
Well, then I'm the loser in this, and nobody should care.
But the point is that if I'm right about that, then your argument is deflated.
Well,
or either that, or Ms. Gabrielle thinks more like you than like me.
Ms. Gabrielle would, I'm sure, take offense to that, Your Honor.
Well, anyway, I'm not saying it. And the bottom line is that it is a statement that the witness has not adopted as his own, and you can't impeach him with it any more than you can impeach him with a statement that he made to a police officer that's not signed. You can call the officer, but you can't offer the hearsay document without presenting the officer on the stand.
So this is just another subject I have to call Ms. Gabrielle.
We've discussed that before, and I've stated if that's what has to be done, that's what has to be done. I have imposed no impediment to you about having Ms. Gabrielle testify.
If that's going to occur, though, Your Honor,
we have to take some measures. But
for one thing, it would be my interest. I would object to her testifying unless there's going to be an agreement that she's not going to be disqualified from the case, because I require her assistance.
Look, I'm not going to touch an issue that I don't have to. Why should I even waste the time to hear it now if it never presents itself? I'm telling you that because Ms. Gabrielle was a witness to statements made by other witnesses,
as was I,
the defense has a constitutional right to call her, or if push comes to shove, you, and the fact that you're prosecuting the case is not an impediment to that.
I understand it, Your Honor, but on the other hand, when considering that, let's consider the potential that there were other witnesses there, and one of those witnesses would be much less problematic. Like, for example,
we're not there. And now we're not even to push, much less shove. So let's not talk about it. But the bottom line at this moment is the objection is sustained. Ready for the jury?
Yes.
This was a big argument during the current prelim hearings. So you just that gives you guys a little context, a little background. So they were witness to some witness statements, which makes them liable to testify in these cases. So in the pretrial hearings, the Jensen defense current argued these things about calling them as witnesses. You just heard Schroeder say there's a constitutional right that says you can do this, and Milosauskas ruled against it. So that's interesting too, man. I don't know, guys. There's a lot of weird things that, like Albie says, it just smells wrong.
has been sustained. Go ahead, Mr. Alvey.
Mr. Dillard's Exhibit 139, that's the typewritten statement. Correct?
Yes.
Is there anything other than the portion I read about the legs and her back and her side that you find inaccurate?
Give me a second to read it. Everything seems pretty similar. It's just
Objection. I don't know. I thought that the question was to have him read it. If there's any questions concerning the document, I object to any questions concerning the document. It's a hearsay document, and
the objection's overruled.
Is there anything else in this statement besides what you noted regarding the rolling from the back onto her side and sitting on her back and pushing on her lines that you think is inaccurate?
the only thing I can say is just from reading it, just gives it like it happened. This conversation happened in a fast manner, and it all happened real quick. It's more drawn out than this. That's all.
But the facts therein are accurate?
Fairly, yes, I would say so.
I would move Exhibit 139.
objection is hearsay. It's consistent with his testimony.
If he's,
It's also irrelevant, Your Honor.
he's expressed a present adoption of the statement with
With some
reservations
exceptions
indicated.
And so let's say that he also read a newspaper article.
Just a minute.
It's just irrelevant.
Hold on a minute. I think we're going to break for the day, for the week. And we'll start again on Tuesday at 8:55. Win or lose. Is anybody going to the game?
8:55.
I knew I had a smart jury. Enjoy the weekend and the game.
Your Honor, I think you should remind the jury once again.
By all means, you've got plenty to talk about this weekend. There's the weather, there's the Packers, there's plenty of other things. Please do not talk about, listen to, watch, or read any account of the trial. Don't listen to anyone else. Again, if someone approaches you and knows the juror or some way finds out that you're a juror and wants to discuss the case, just cut them right off. Don't be afraid of being thought rude and say, yes, I'm a juror and I'm not allowed to talk about it. And we'll both be in big trouble if we do. And if they persist, then walk away. And any questions? Thank you.
Please all rise.
For starters, I'm having some I don't want to say second thoughts about what I said last time the jury was out of the room. Let's call them 1.5 thoughts. About which account is more concordant with Dr. Chambliss's testimony. So who wants to lead off?
This is how Schroeder keeps getting in trouble. He keeps interjecting
second thoughts are good.
during the trials.
Because the difference is that she's in the handwritten statement. I mean,
By the way, you can step down, sir. I'm sorry, go ahead.
Did we want Mr. Dillard to remain in the courtroom during this conversation?
I think not. That would probably be.
You're welcome to leave for the day and return on, what time do you want him back?
Tuesday at 8.
Or do you want him to remain in the building for the while?
No,
Tuesday at
8:30.
8:30.
Can I make one
Yeah,
statement?
he did, Jennifer.
As far as
Schroeder does this all the time.
I don't know what it says, so you know what I mean?
Well, all right, well, we'll take it from where we're at.
He does this all the time. This is the thing. So, like I'm from here, right? So like we see this guy all the time. You guys saw him if you watched the Rittenhouse trial, right? You saw him constantly interjecting. A lot of us were getting pissed off when, there was a point with Kyle where Binger was really going at him. And a lot of us were on the edge of our seats going, holy shit, Binger's about to draw something out of this kid. And and then Schroeder just interrupts, and he's interrupting the flow of the questioning. And that's why there was a lot of accusations that, Schroeder was on Rittenhouse's side, because it did disrupt the flow of the line of questioning from Binger. Because there was a point, man, Binger almost like hung this kid. So, Schroeder does this shit all the time, and he's constantly interrupting. He's constantly, again, I'm not a lawyer, but it to me, it sounds like practicing law from the bench. You're asking these clarifying questions. You're asking your own questions. I don't know, man. It's just weird shit. And then he says something in front of the goddamn jury and then contradicts what he said outside the presence of the jury. And it's almost like Schroeder influences jury's decisions. You know what I mean? And then he gets pissy when these cases go to, the appellate courts. I don't know, man. That's just my own personal. This guy irritates me. Anyway, once again, thanks for tuning in. Share the streams out, guys. If you like what we're doing here, make sure you follow all our social media, blah, 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 blah. There is one more video. We're obviously going to finish this because this is obviously an important argument. There's one more video, which, for Dillard, and I'm hoping that it gets through enough time so we can play the Kelly Labonte video. On Facebook, though, we're only allowed to stream for 8 hours. We're 5 hours and 40 minutes in. YouTube allows us to stream longer. So if we hit the 8-hour mark and Kelly Labonte is still on the stand, Facebook's going to get cut off. But please jump over to YouTube because we'll stay live over there.
Of course, what I find the difference is that in the original statement, Mr. Jensen supposedly says that she's on her stomach. That is, there's no photo of her on her stomach. There's no testimony that she was found on her stomach. And then it's the typewritten statement. Now it's changed to being on her side. We also now have the new information about pushing on the lungs, where there's some petechiae that's could be completely attributed to postmortem artifact, but Dr. Chambliss says could be consistent with suffocation. And so I think there are some new facts added in the written statement that enhance what was originally said. So I do, again, want to use it to bring up that fact. Also, the witness statement, like many police reports, I mean, I presume that, well, he's now said he's read it and it's accurate, with the exception of what he noted there. Should be admissible. I want to use it for comparison purposes because I intend to demonstrate in this trial how he constructed this statement, and I need something so the jury can understand that, something besides their memories on that.
Did you want to respond?
Well, and by all means, Your Honor, I encourage second and third and fourth thoughts about things. I want the court to make the correct decisions in this case. My objection to the use of this witness statement is that the witness, it's irrelevant. And the fact that the witness now reads it and says, well, yeah, that's pretty consistent, except for this one part, which, by the way, is the one part that is really at issue here. And he said that the previous statement that he gave in the letter was, I believe he's indicated that's the more accurate rendition of what occurred, that this was a summary. And he indicated that he's never signed this statement. He indicated that under oath, and there's no signature on this document. And now counsel asked him to read it. And the only thing that's changed between the court's earlier ruling and now is that counsel asked this witness to read this document on the witness stand. Well, let's say there was a newspaper article that had been released about Aaron Dillard's statement, and counsel gave him the newspaper article and said, is that accurate? And Mr. Dillard read the article and he said, yeah, that's pretty accurate, except for this one particular point here regarding, that insofar as there's a discrepancy between what's in what I'm just reading here and what's in the earlier statement that I wrote to my lawyer. Well, matters were fresher in my mind when I wrote it to the lawyer, and the thing in the statement to the lawyer is more detailed and it's more accurate. Does the Does the newspaper article come in? Just because a witness reads a...
And the reason I ask is because what is the definition of a hearsay statement? A hearsay statement is a statement made by a declarant other than while testifying on the witness stand as a witness. Now, if you bring a piece of paper that was drafted by someone else and on the witness stand while under oath, he acknowledges its accuracy, it seems to me it's no longer the declarant's out-of-court statement, but rather his in-court statement under oath.
Well, Your Honor, if that's the second thought that you had,
no,
that's wrong. Because the fact is, then you could say that about anything. Because let's face it,
what is the hearsay rule designed to keep out? Inaccuracies from off on the street. And this isn't an inaccuracy from out on the street. If right in court he says, no, it's accurate. It's his in-court statement under oath.
Judge.
It's not hearsay.
Judge.
You're not going to win this argument.
I understand, maybe not right at this moment, but I think if you've thought about it for 3 days, you'll realize you're wrong. Because the fact is, okay, then let's say that the defendant were to take the witness stand and testify under oath, and then Mr. Albee is permitted to present him every self-serving statement he's ever made before he got here. And the defendant reads this, oh yes, I told this person I was not guilty. Oh yes, I told this person I was not guilty. Oh yes, I told this person I'm not guilty.
No, there's a difference.
What is it?
He's adopting, these are statements of, well, let me think about it.
There's no difference, Your Honor. And
I think there is.
Well, your theory falls apart on that basis, because the fact is, it's an out-of-court statement, and the fact that he reads it in court and says, yeah, this is accurate, doesn't make it an in-court statement. It's still hearsay. And if your theory, which I know just came to you, and when you think about it, it's going to go away because it's not right. And it's an out-of-court statement that this witness made. Actually, this witness never even made it. It's an out-of-court document that somebody else prepared, and it's supposed to be a summary of a previous statement. It's an
what is the
out-of-court statement.
hearsay rule designed to prevent?
It's designed to prevent a waste of time by bringing in every single document or statement that a witness has previously stated and have them affirm it again in the witness stand. Okay. But really, we don't have to get into the theory underlying it, Your Honor, or the policy underlying it. We look right at the statute. We don't have to construe it.
No, that's when you make mistakes in evidence, is when you don't think through what the reason for the rule is.
Well, here,
you know what? I think that we may be arguing about something that's only tangential to the real issue here.
Okay, and what's the real issue then?
Well, if I could add two things. One, I really am not offering this for the truth so much as the matter that these are things he said. I'm not offering from the truth of the matter because again, I want to use this document to show how he constructed this accusation against Mr. Jensen.
Well, if I admit it, other than the portion that is
simply that he said it.
Pardon me?
Simply that he said it.
But he didn't say it. At no point, said, including on the witness stand just now, has he adopted the couple of sentences that are particularly to what we're haggling about.
Oh, no, but I want
the rest of it?
I want the whole thing here. Yeah, I want the whole thing. But the other thing, Judge, and I direct this to opposing counsel, and I'll check my notes, but my feeling is I have a recollection that I was told how this thing, it was consistent with how I was cross-examining Mr. Dillard. My recollection is I was told how this was completed, which is that there was either a meeting or a telephone call or something before September 21st, and then on September 21st, it was read to him over the phone, or there was some sort of confirmation immediately thereafter that, yeah, that's accurate. I mean, that's why I cross-examined him the way I did. And I'm not saying I was told that. I'm just saying that was in my head for some reason. And so I guess I could inquire as to how it was completed without, deciding who to call as witnesses.
Well, I didn't do this statement. Ms. Gabrielle did the statement, Your Honor. And I'll tell you all that I know. And
I'd be more interested in if Attorney Albee examined the witness about it.
And if do I understand you say that the witness may have said that he approved this statement over the phone?
No. My belief is that whenever I got this, or soon thereafter, I was having a conversation with the DA's office, somebody, either Mr. Jamboys or probably Ms. Gabrielle, about how this was compiled.
Okay.
And I'm just saying that when I was cross-examining Mr. Dillard, I started on the premise that I understood from prior conversations, which was, I thought that there's a meeting, this was typed up, and then he approved it in some fashion at that point, and then they sent it to me. And he says that's not what happened. Of course, I don't know.
No, here's what, and I don't know what happened, but I don't think, the witness was not asked if this statement was ever read to him over the phone. He said, I'd never seen this statement before, I never read it. I mean, I don't know if he was ever asked, did somebody read this statement to you over the phone? And I don't want to go any further down the pike of making Ms. Gabrielle a witness in this case, if that's something that can be avoided. If Mr. Dillard were to testify that this statement was read to him over the phone and he approved it, well, then that would be a different story. But that question I don't think was posed to him. He was asked if he indicated he's never signed the statement, and I think he's indicated he's never seen the statement. But I don't know that anybody has asked him if anybody read the statement to him over the phone. I know I never read the statement to him over the phone, and I can ask Ms. Gabrielle about that, but I'd prefer that we ask Mr. Dillard about it.
Well, we save a lot of time. Somebody told me something at one point, and it has slipped my memory as to exactly how this was compiled. And rather than ask Mr. Dillard and then be forced to call Ms. Gabrielle, it would seem to me to make more sense just to find out what the heck happened from your office's perspective.
What do you want to do?
I'd like to know what Angie had to say about it.
Did you read it? Ms. Gabrielle is telling me that she did read the letter to Mr. Dillard over the phone, Your Honor.
And did he indicate?
And Ms. Rosenke.
And did the defendant, or excuse me, did the witness indicate his approval of what it stated?
I believe he did, otherwise I wouldn't have sent that.
Well, if that's the representation, then I'm going to admit it.
Well, no, I still object to it. It's hearsay. It's a prior consistent statement.
Well, in some respects, it's inconsistent in the sense that they're not exactly the same.
And he's already acknowledged that.
But his acknowledging that they're inconsistent does not prevent the other party from showing that he's made inconsistent statements on the subject.
Well, I don't know that
Pardon me?
I don't consider these statements to be significantly inconsistent anyway.
And you know what? I think that's a fair argument to make to the jury, and they'll let them decide.
Okay.
But the question is whether I should let them have the right to make that decision. And my inclination, based upon what I've been told now, is that the answer is yes.
Okay. Well, Your Honor, and Ms. Gabrielle and I had not talked about that. So and I think it makes sense that she would read the statement to Mr. Dillard and his lawyer before sending it off to the defense counsel to make sure it's reasonably accurate.
So I'm going to leave it with the bias in favor of admission of the exhibit and permitted cross-examination starting on Tuesday.
Thank you, Your Honor.
All right.
That mark, that wall I have.
Pardon me? Did you have what? Oh, yeah.
I still object to that on other grounds.
Well, yeah, well, let's talk about that now instead of Monday or instead of Tuesday. Now, let me ask you, gentlemen, do I owe you anything in terms of any pending decision of any kind or do I owe you anything?
Judge, I have my motion to exclude recorded telephone conversations that I think the court has indicated that it's denying on a number of levels, but I'm not sure that everyone's been recited. Although as to more recent conversations, there was the additional ground of that I received 4 discs that contained many calls during the week before trial was scheduled to begin, is my recollection. And I don't have time to just listen to calls from Mark Jensen to his parents at various times, and I'm not told exactly what's there, and I don't have transcripts, and I don't have the resources to deal with those at this.
Well, is the state proposing to offer any of those?
No.
Okay.
No. If we're going to provide a statement or offer a statement of the defendant, and If we don't have a transcript, we'll provide him with a CD, which is what we would have.
He says he did get it, and he hasn't got time to listen.
But we're not seeking to offer any of those. I mean,
that was what I asked. So neither he nor I needs to worry about it. He doesn't need to worry about listening to it, and I don't need to decide whether there's any ground to a motion of any kind. So
that is correct.
Anything else that I owe you guys?
No, I don't know. I don't know where we are in various Dr. Long issues.
That one is still pending.
And
I'm waiting to hear from you, more information from you people. Anything else?
If we could approach for a moment, there's one thing.
Yeah.
Man, all right. Let me get to the rest of Aaron Dillard's. So that was part 4, according to what? Was it part 3? Let me see what this is. Man, what do you guys think? All right, so Darcy said she didn't watch the Rittenhouse trial. I'm surprised you didn't. Everybody watched that trial. But yeah, we have footage. It's a little cringy because we weren't able to stream the, the quality that we have here. A little bit of glitchiness to it. But we live streamed it. And then following the jury deliberation, we were out there live streaming. What are we on? We're on video 5. Are we on 5 now? Fuck, I'm losing track. I think they. Hang on, I'm trying to get the right video. This is rough, chat. There's, you guys kind of see, like, I mean, this obviously puts a lot of strain on us over here too. There's a lot that goes into this stuff, guys. If we can get we get to the Kelly Labonte stuff. So like even after this, when this stream ends, I go back and then we download the stream. We do this every day of the actual trial too, and then we edit each person's testimony. All that stuff takes hours. I've been working on that stuff all weekend. There's a lot of this on part 4. Sorry, I'm watching a bunch of shit obviously in the background because I'm trying to get the right goddamn video for you guys. I'm pretty sure we were on video 3, so the next one is video 4, right? Because we had the stream froze and then we had to go back and find the right thing, so we were on video 3. Video 4, there's so much repetitive shit though. There's so much. This video 4 seems like it's almost literally like a repeat. Let me look at video 5 real quick. We gotta make sure we got the right shit. I'm sorry, chat. My fault. Am I taking stretch breaks? No, and that's why I'm having a major issue with my left calf right now. I'm having a hard time walking. Sitting in this chair for 9 hours of court streaming and then hours after that editing goddamn video. You know, that's how we make like the little reels on Facebook and the TikToks and little clips on YouTube. Video 4 is a lot of same exact shit that we heard. But it's only a 55-minute long video, so I don't think we showed that. There was one thing in there that Dillard was testifying that he saw a newspaper article about threats made to him. So I don't know. Yeah, I don't know. Video 5's the same shit too. It's a lot of, I don't know. We'll play video 4. Let's see where we're at with it. You guys let me know. Because there's 5 videos in the archive footage for Aaron Dillard. I'm pretty sure we're on 4. I'm just going to start playing 4. Let's see where we're at, chat. Sorry. Man, and I'm out of coffee. Out of coffee, 1 cigarette left. Not stretching. That's where we're at. Trying to get through this testimony. You know, that's the thing too with this trial. Back in 2008, these testimonies were just goddamn hours and hours long, where they're much faster in the modern day trial.
Is basically all exculpatory, and then it adds a handful of negative facts. And it's my belief he constructed this out of both materials in Mr. Jensen's cell and from conversations with Mr. Jensen.
Well, maybe they're just having the same argument when they came back Monday. So let's just watch this and see where we're at.
Make additions to this kind of statement.
If it's too repetitive and you guys are getting bored, let me know.
How he obtained this information
and
had it put in the statement.
I think we got the gist anyway. But
I don't understand what counsel's talking about, Your Honor. The fact of the matter is, this is a hearsay statement, and it's not inconsistent with the witness's testimony. Now, if it were inconsistent, then it's a prior inconsistent
We
statement.
don't need to talk about what could be. The bottom line is what you're asking me to do is allow you to go through a hearsay statement to show how it was assembled, but it's still a hearsay statement.
I'm not offering for the truth.
Well, then
it's irrelevant.
No, it's because it's how he constructed it.
Well, how he constructed it is how he came up with a story. The creation of the hearsay statement is merely a written memorialization of the account. So it's the creation of the account that you're questioning, not the creation of the hearsay document.
But I need the details of how he created it. I mean, where did you get this information? And you inserted this.
Which you can ask him without reference to the written statement.
And well, he already has asked this witness extensive questions about where he got the information and asked him about newspaper articles and so forth. That I don't understand how that has anything to do with his witness statement. This is a hearsay document, and it's not inconsistent, as near as I can tell, in any way with the witness's testimony.
Well, I can also, I think I can even introduce it as a script, because the notion that he hasn't reviewed any of these things in the last 3 weeks, I think is.
You know, you're really asking way too much of me, Mr. Albee, when you ask me to assume that a witness is a liar in making an evidentiary ruling, which you do when you say these things.
No, I'm assuming that I have a good faith basis for that argument. I of course don't. I'm not asking the court to be a fact finder.
It's like, we're watching the same shit, right? Like we just heard all of this stuff, only like this is where this particular video starts, as if like this was a new day. There's 5 videos. So 4 and 5 should have been more testimony.
Witness is the proof that the witness is lying, and that his testimony is just too consistent with what he said in the past.
Yeah, it's memorized.
If it ends up,
I agree to this document.
The document's hearsay.
Or include.
You deny having read that transcript?
Correct.
You deny having read anything in that transcript?
Never read anything like that or talked about it.
Go ahead. And deny the fact that it's cross-examination. Go ahead.
Do you deny reading anything in that transcript about Detective Ratsburg accusing Mr. Jensen of pushing Mrs. Jensen's face in the pillow?
I never read a transcript of that.
Do you deny reading anything regarding Detective Ratsburg's claims during an interrogation of Mark Jensen?
Yes.
This is Scripps News.
Welcome to Morning Rush. We have a lot to get to.
See, but that part of the testimony seemed new. Slightly new. All right, we're gonna let this go a little bit longer, chat. Let's see. You guys let me know. It's hard to think that they have 2 other videos that are exactly the same from what we watched, but maybe.
About his concerns about Julie's treatment of the children.
He said that he was upset with it. He said that she was crazy, and he was angry because of the fact that, like I said, she'd have one kid would come home from work, and one would be naked in one room, and one would be, they cause scenes, I think.
You wanted to do this to get yourself out of jail, right?
This is all the same shit, chat. Let me, I don't know why. See, and then even 5 is the same shit.
When what's happening?
Stop this so I don't get in trouble. 5 is the same shit. I'll play you guys a little bit of 5. Tell me if I'm wrong. This is crazy. It's like the same. See, and then this is the start of
prosecutors. You said I have actually jobs lined up with Aaron Construction or with Sundance.
right?
Vacations,
He's
right.
questioning him about
Correct.
Aaron
But you
Construction
didn't have a
again.
job lined up.
Yes, I did. It's if I call them back and say, yes, I'm free now, I can start working.
It's the same shit. Fuck this. Fuck this. It's boring anyway. I think we got the idea anyway. These all sound like it's just repeats. That's kind of weird. Let me just do one more quick check and make sure there's not a part 6, somewhere else. With Aaron Dillard, and then we'll jump over to Kelly for you guys. Fuck, Kelly's got, I don't know, chat. Kelly Jensen has 1, 2, 3, 4, 5, 6 videos. That's a whole nother fucking long ass stream. I don't think we're gonna finish Kelly's stream in 2 hours. So I can end this stream so it's separate, and then we can start up a brand new stream with Kelly Jensen. Or we can end the stream and we can come back in a couple of hours and do Kelly. Kelly's shit is long. 6 fucking videos. What do you guys feel like doing? Where are you guys at? Some of you sound like you're watching the football game while kind of watching this. I don't really give a shit about football. That's just me. But I can end this stream. It's already 6 hours. I can end this stream, and then I can right away just start up a brand new stream with Kelly's whole entire trial day. It's probably going to be another long ass stream. I mean, I said we're going to marathon stream a lot of this stuff today. We'll marathon stream a lot of stuff tomorrow. You know what I mean? So, because they're not coming back to court until Tuesday anyway. So just trying to marathon stream as much of like 2008, kind of give you guys, some background on this 2008 trial. Plus, with some of these witnesses, we obviously haven't heard their testimony this time around. So, you little super sleuths can hear what they said in 2008 and then, start screaming at your screens when they testify now. So for those, what do you guys want to do? For those that are watching on YouTube and Facebook, since Kelly's is a whole nother stream, that's a whole nother stream. It has to be. It's got to be separate. There's no way we're going to cover it. So, I mean, we can finish this stream out with this other guy that I wanted to stream, Dave Thompson. That's a dude. He's gonna testify to this plot of kidnapping Ed Klug. Whatever gets you a stretch and gets you more smokes. Well, that all costs money. Let me just go on to Dave. So that's the thing too, guys. It takes a lot of time. It's a lot of work. There's a lot of bills that need to be paid for the company. We file open records requests, right? We have company insurance. We have the website. We have all these things, plus all these hours of streaming these things and clipping these videos so you guys have content to watch. We don't have corporate sponsors, so we don't get paid big money. A lot of people think we make like fuck you money on YouTube. We don't. That's not true. We're viewer based. This trial is expected to last 5 weeks. So, that means I'm not at a day job for 5 weeks. That's why, we put the donation links up there. If you guys like what we're doing, we don't require it, obviously. But it helps. You know what I mean? So let's get to Dave Jensen here. We'll have to start another stream. So I'm going to finish off with Dave, and then I'm just, we'll end the stream, and I'm going to restream. We'll start a brand new stream because I'm just gonna marathon this shit all day. Why not? Why not? My battery won't have a whole another 8. Yeah, I'm over here. I don't know if you guys can see. I'm over here with like portable battery chargers. I've got like my mouses are rechargeable and stuff. My keyboard, I'm over here like recharging shit. Recharging my phone because I'm watching the Facebook chat on my phone to make sure the video quality's good. I got the YouTube chat up on the other computer to make sure the quality's good there.
For the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth. So you got it. Yes, sir. Thank you. State your name, please.
David Thompson.
And you're residing in the temporarily in the Walworth jail, but you're a prisoner of the federal government. Is that right?
Yes.
Where are you presently?
All right, so I'm going to pause this. So I watched his testimony. His testimony is juicy, man. It's a lot of like WTF moments. But right now, this is where like we see in these trials where they talk about their background and how many, criminal charges they have. And that's what they have to testify to. Right. So we've seen this in other trials. Wait till you hear this dude's background. And like he just said, he's in the custody of the federal government. You're going to find out why.
Ozaukee County Jail.
Ozaukee County Jail?
Yes.
All right. Did you want to examine him about his record? Let me just tell you, sir. It is lawful for the attorneys, when someone is a witness, to question the person about the prior criminal history.
Okay.
Yeah, because ultimately the jury may be given an instruction about weighing the testimony of witnesses and comparing and considering the fact that someone's been convicted of a crime in the past, or in some instances about specific instances of conduct in the past that may be proper for the jury to consider. So that's why these questions will be asked now and will be asked when the jury comes in. You understand?
Okay. Yeah, no problem.
Okay. Go ahead.
I will say real quick, I went over this with somebody else and we're talking about like cost of and this is not just us, this is every live streamer that you guys watch, right? Every live streamer, this is what we deal with. A lot of people think we make fuck you money off of YouTube. We don't. So for day one of the trial, we got our analytics. So off YouTube, right? And we're transparent here. I don't mind showing you guys this. I plan on doing a stream because we've had a lot of questions about this the last couple of weeks about, people asking how much money we make and whatever. And I'm transparent. We tell you, just like if somebody happened to donate right now, I'd be like, hey, thanks for the donation. Whatever. Anyway, day one of streaming this trial, we made 60 cents off a fucking 9-hour stream on YouTube. And there wasn't a single donation that came in from viewers on Facebook or YouTube. We made 60 cents for 9 hours. That's less than 1 penny per hour of our time. And then we obviously spent more hours afterwards, clipping these video things for you guys. But that's every live streamer goes through that stuff. That's why they do the memberships, the donation links, Patreons, whatever other type of shit, right? That's what we have to do as content creators. It's crazy. And Facebook's even harder. And we don't even have enough followers on Facebook because we had to create a brand new page. So we're not even monetized on Facebook yet. So it's nuts. They are screwing content creators like crazy.
Also, what was his thinking?
We're about to create an OnlyFans over here. We might have to. Jesus. All right, here we go, guys.
I want to ask a new question first about this record that you have of 2007.
Yeah. That commission.
Yeah, Mr. Thompson, are you familiar, are you aware of any convictions this year out of Milwaukee County, or I'm sorry, the year 2007 out of Milwaukee County? Were you convicted of felony or misdemeanor offenses in the year 2007 in Milwaukee County?
Yes, I received a 4-month sentence for a misdemeanor conviction. I had one sentence dismissed.
Okay, so you had one, you were sentenced to 4 months in the county jail?
For a house correction, county time, yeah.
Okay, and that was a misdemeanor theft conviction?
Yes.
In 2007, correct?
Yes, April of 2000. I got sentenced on it in October of 2000.
And then do you recall a previous conviction for operating
a vehicle without owner's consent. Let's see.
92.
Let me get to it here. November 17th of 1986.
Oh, 86, yes.
So you were convicted of operating a vehicle without owner's consent, November 17th, 1986.
Yes.
And then you recall being convicted on July 24th, 1992 on 2 offenses, operating a vehicle without owner's consent and party the crime of armed robbery.
Yes.
And then you were convicted in 2003 of 2 counts of two misdemeanor counts, 1 obstructing an officer, 1 possession of drug paraphernalia.
Yes.
And then you were convicted in 2007 of 1 misdemeanor theft count.
Yes.
Now, are there any other felony or misdemeanor offenses that you can recall as an adult?
No, that should be.
That's
it.
your recollection?
Yeah.
So that would be a total of 6 felony or 6 adult convictions as either misdemeanors or felonies.
Yes.
And you're presently being held on bank robbery charges by the federal government?
Yes.
And have you pled to any of those charges, been convicted of those charges yet?
Yes, I pled to them.
And how many charges have you pled to?
2.
And when did you plead to those charges?
December 20th.
Of 2007?
Yes.
And that was in federal court?
Yes.
And you're awaiting sentencing on those charges?
Yes, I am.
Okay, so I would propose then, Your Honor, that if Mr. Thompson's asked the question, have you been convicted of a crime? The answer would be yes. And if he's asked how many times, the answer would be 8.
Well, I'm not going to tell him what his answer should be. He has to tell the truth.
I understand, but if he
the
answers...
question is whether he's subject to impeachment. And you're proposing that if he answers yes and 8, or a greater number, that he's not subject to impeachment.
That is correct.
I'm under the prior conviction of crime statute.
Yes, sir.
Mr. Alving?
Can make some inquiries.
You may.
Mr. Thompson, you're charged with arson to a building in the late 80s, right?
Got dismissed.
Charged with battery in the late 80s?
Got dismissed.
Any other misdemeanor convictions in the late 80s?
I think a theft from like 87 or 88.
You had a misdemeanor theft?
Yeah. I think I did like 30 days house correction time for.
Anything else you remember?
The rest would be juvenile.
I'd ask that the number be 9.
You weren't a juvenile when you were convicted of the misdemeanor offense of theft? You were an adult?
I was an adult.
Okay, well then I'd say 9.
All right. Anything else? Or will we bring the jury in? Hearing nothing.
No, Your Honor, I'm sorry, there's nothing else from the state. Oh, you're still trying to hook up the laptop?
The whole system has to be brought down.
Is that going to affect my computer again? Because I'm in the middle of preparing an art.
What are you guys playing?
Oh, just microphones? All right, well, do whatever needs to be done.
Conversation of him with him and then.
I'm sorry. Say again?
Mr. Thompson is going to testify that it was Mr. Jensen that got on the phone to speak with Mr. Thompson's fiance. And the purpose of this conversation is that it's in furtherance of this plan that the two of them had hatched about abducting and sitting on Edward Klug to keep Edward Klug from testifying in this trial. That's the purpose that Mr. Thompson is being called for, Your Honor. He's going to testify that
You said Mr. Jensen was then going to get on the stand and maybe I misunderstood, and I think.
Well, you did. Well, if I said that.
Odd turns, but this is.
If I said that, Your Honor, I misspoke, and it's possible. I've been very sick over the weekend, and I'm still in the recovery stages. But what if I did say that, Mr.
I don't know if you did. I thought you did. She says no.
Okay. So what I thought I'd said was that Mr. Thompson is going to be testifying about a phone call that occurred between himself and his fiancee. And in the midst of that phone call, Mr. Jensen got on the phone and was speaking with Mr. Thompson's fiancee. And that this conversation was in furtherance of this conspiracy or this plan to abduct Mr. Klug and prevent him from testifying in his case. That's the purpose of Mr. Thompson's testimony.
Did you want to comment on this at all, Mr. Albee?
No.
Is this something that requires a special instruction?
I don't believe so.
Well, it's evidence of other crimes, wrongs, and acts, but it's not what we typically encounter. So unless I'm requested, I'm not going to give any kind of a special instruction on it. And I'm hearing nothing, so, okay. All right, ready to go then?
I think they're still trying to figure out how to get this computer to work, Your Honor. There's a technological problem. If worst comes to worst, we've got a CD player. We can just bring it up here and hook it up. But we were hoping to be able to use it on the.
Say it again. That's what I say, okay. Hello? Hello. Hey, everything is planned. Okay. Okay. So good. Good? Yeah, good. So good. All righty. Okay, appreciate it. Okay. Okay. Thanks. Yep. Is it? Thanks. Yeah, so, we'll probably get a call sometime today to go, we'll get to that. Okay. Huh? Yeah. You talk to Mom, sir? No, I called, nobody answered. Sorry, okay.
Okay, Your Honor, I guess we're ready to proceed.
There were large portions of that I wasn't able to make out, just so you know.
I hope the jury can hear it better.
Well, I will admit that age takes its toll on hearing, and so
And you're off to one side.
This is going to be juicy, Chad.
anyway.
If we actually, because Mark Jensen supposedly was on the phone with the girlfriend of this guy, and if
Dreaming of changing the world.
talking about kidnapping Ed Klug to prevent him from testifying, this is going to be insane. It's going to be insane. So the inquiries, because these testimonies are so long back in 2008, and we can only go live on Facebook for 8 hours. Some of these testimonies we're gonna have to start a brand new stream. So we looked at Kelly's. Kelly's is a 6-parter. So, we only have an hour and a half left on this, on the Facebook stream of this. We'll still be live on YouTube to finish Dave Thompson. But once the stream completely ends, we're gonna go live again because we're gonna marathon the shit out of this 2008 thing, which is gonna be a long 2 days for me. If you guys can't watch all that, I get it. That's a long day. They'll be up on our YouTube channel, and 8 hours obviously on the Facebook page. Will be live on both platforms. But you guys can come back and watch the stuff later too. So what's up, JK, over on YouTube? Here we go, guys. So this is Dave Thompson. He is another jailhouse snitch, supposedly going to be testifying to a conspiracy to kidnap Ed Klug to prevent him from testifying from this trial.
Thompson, you're presently an inmate, a federal prisoner, is that correct?
Yes.
Have you ever been convicted of a crime before?
Yes.
How many times?
9 times.
And that includes 2 most recent convictions at the federal level?
Yes.
You just pled to 2 charges in December of 2007?
Yes, I did.
And what were those charges that you pled to?
Bank robbery.
2 counts?
Yes.
And have I offered you anything in exchange for your testimony in this case here today?
No.
Have you, when you entered into this plea agreement, which apparently you entered into with the federal, with the U.S. Attorney's Office, was any discussion made about your participation in the testimony in this case?
No.
So you received no concessions from the U.S. Attorney as a result of your cooperation with the authorities in this case?
No, I did not.
Now, Mr. Thompson, there was a time when you were in the Kenosha County Jail at the same time as Mark Jensen, is that correct?
Yes, sir.
And how is it that as a federal inmate, you'd end up in the Kenosha County Jail, do you know?
Well, they have a contract with federal marshals that hold federal inmates there.
So tell me, who was in the jail first? Were you there first and Mr. Jensen arrived, or was Mr. Jensen there first and then you arrived?
He was there when I arrived.
And tell me about your first interactions with Mark Jensen.
Well, when I first got on the pod with him, I didn't say much to him. I had at one point asked him to make a phone call for me, which he did after we had a brief conversation. And from that point on, I think maybe over the next couple of days, we just started talking on a daily basis.
Well, let's go back to this first conversation with about a telephone call. You'd asked him to make a phone call for you?
Yes, I had asked him to call my fiance for me.
And did he agree that he would do that?
Yes, he did.
And then did he make the phone call that you requested of him?
Not at first, he didn't. Maybe like the third request that I asked him, he made it for me.
Okay. And was there any physical contact between you and Mr. Jensen before he did make the phone call that you requested?
Yeah, we had a slight misunderstanding, and I ended up shoving him a little bit.
So you pushed him?
Yeah.
And it was after you physically pushed him that Mr. Jensen then made the phone call that you requested of him?
Yes.
Well, tell us about what happened then between you and Mr. Jensen after that, after he'd made the phone call.
Well, after that, I came and apologized to him. And from that point on, we just started conversing on a daily basis, just small talk at first. And I saw his picture hanging in his cell with his suit on. I asked him what was that about, and he described to me what his case was detailing.
So this picture that you're describing was that just a normal photograph, or
no, it was a newspaper clipping.
Okay. So he has a picture of himself in a suit with a newspaper clipping hanging on the wall in his cell?
Yes.
And so when you and Mark Jensen first started talking to each other, what sort of things did you and he talk about?
Basically just family at first, then it slowly progressed into the aspects of his case, and then he started telling me about it.
Well, tell me about everything that Mark Jensen said to you about his case.
Well, first I had asked him, I said, what you charged with? And he explained to me that he had been charged with murder for murdering his wife. And then he went into the dynamics of it, said, what they said he had done as far as, poisoning her. And he was explaining to me that, she wasn't, mentally intact, that she had a history of family mental illness, and that, the doctors would prove that her family had a history of mental illness, and it would vindicate him of the charge he was charged with.
And so he seemed happy with this case in that respect.
Yeah, he seemed pretty comfortable with it.
Now, was there any aspect of his case that he expressed discomfort to you about?
Other than the fact that he was incarcerated at the time, no.
So he was not happy about being incarcerated?
That seemed to be the only thing.
Okay, and then what happened after that? What did you talk about after that?
We had briefly talked about, he had mentioned his, a guy named Klug was one of his co-workers.
And what did he say to you about Mr. Klug?
He said that Mr. Klug was testifying against him in this case, and that probably would hurt him.
Tell me everything that you can remember about what he said to you about Mr. Klug.
He said Mr. Klug would ultimately be the one that would bring him down to get him locked up in prison. And he wished that he would just go away. So I asked him what he meant by that. I mean, he said he wished that he would just disappear till the trial was over. And at the time, I really was like trying to pinpoint exactly what he was trying to, come about in this conversation.
So what did you do in order to try to figure out where he was going with this conversation?
I asked him, well, what did he want done with Mr. Klug? And he said he wanted him, to be held or to, just go away until the trial was over with. At that point, I wasn't for sure whether I should believe him in what he was saying or not. So I just, took it upon myself to see just how far he was willing to go with this.
And what did you do in order to accomplish that objective?
I told him that I could possibly make it happen for him. And so I set into motion a series of plans with phone calls to my fiance. And I told him, I said, well, this may cost you about $1,000. And he wanted to say, that's pretty cheap, and I just gave him a ballpark number to see, what he would say. So when he agreed to that, that's when I made the phone call to my fiance and told her, just say everything is as planned and to, pick the money up from his mother.
Now, before you talked to your fiance, was there any more specific conversations about this $1,000, about how it was to be paid, whether it's to be paid all at once or in installments or anything like that?
Yeah, it was going to be paid in installments. One was $575, the other would have been $425.
So the $575 was paid up front, and the $425 was paid later?
Yes. Before the first one was going to be before Mr. Klug, and the second half would have been after his release, so-called release.
And what was the objective of picking up Mr. Klug and sitting on him for a while or holding him for a while?
So that he wouldn't be able to testify in this trial.
And how far along were you and Mr. Jensen in your discussions concerning this plan?
We pretty much had reached the point that I had convinced him that I would be able to make that happen. He gave me the name of the business and his address in Appleton. So when I had my fiance check on the computer to see if it was true, in fact, it was.
Whose address in Appleton?
Mr. Klug's address. It was a little town outside of Appleton, like Kimberly or something like that.
And did you and Mr. Jensen discuss the manner in which the payments were to be made?
Yes, he would pay the $575 first, then after the trial was over, and Mr. Klug was released, and I would get the other.
Well, how did Mr. Jensen explain to you how he was going to do this in view of the fact that
he was going to have his...
Please, sir.
Okay.
Let me finish the question before you start answering, okay?
Okay.
So did Mr. Jensen explain to you how he was going to get the payments to you in view of the fact that both of you were at that time incarcerated?
Yes, he was going to have his girlfriend give the money to his mother, and my fiance was to pick the money up from his mother at some disclosed location between them.
Did he ever explain to you why he would have his mother get the money instead of just the girlfriend herself getting the money to him?
He said his mother was more understanding of what he was doing. He said his girlfriend would have a fit if she had to partake in any of that.
And as you're sitting here now, do you remember it was his girlfriend or his wife that he was referring to?
Well, whoever the young lady was, his wife is dead. I mean.
And so in furtherance of this plan, did you have any discussions with your fiance?
Yes, so I called her and I wrote her a letter telling her to get in touch with the district attorney. And when I made the phone call, I made the call so that it would seem as though we were in accord with what Mark was trying to plan.
And tell me what you mean by that.
When I got on the phone, I told her that I was going to put someone on the phone to talk to her, and I wanted her to say that everything is as planned.
And who was the person you put on the phone then with her?
Mark Jensen.
And you just heard that phone conversation? You just heard it played, correct?
Yes.
And is that the phone conversation you're talking about?
Yes.
And that was Mark Jensen's voice that we hear coming on the phone?
Yes.
Your Honor, at this point, I request that I have the opportunity to play this to the jury.
Objection. Other than I'm not sure if this has been marked.
Right, it needs to be marked.
Madam Clerk, what would be the exhibit number?
92.
Okay, we'll have it marked after I'm done with it.
All right, states 92 is received.
So Mark says this was extortion money to not beat him up. That's his explanation to all of this. Once this commercial is done, we'll get back to it. But defense in this trial their theory was that this was extortion money. You heard there was a physical encounter already between these two, and it was extortion money to not beat him up.
It's right here.
Hi. Excuse me, you ready to camera? Yeah. Oh, okay. We'll just carry on. Yeah. Come pick up somebody. Yeah, excuse me? Yeah, or yeah. Say it again. That's what I say to her? No. To him. Oh. Okay.
Hello?
Hello.
Hi.
Hey, everything is planned.
Okay.
Okay?
So good. Good?
Yeah.
Thank you.
So good. All righty.
Okay, appreciate it.
Okay.
Okay, thanks.
Yeah.
Here's it.
Thanks.
Yeah, so, you'll probably get a call sometime today to go, let you know where to go get it at.
Okay. Yeah. You talking mom, sis? No, I called, nobody answered. Sorry, man, we're good.
I was going to have this marked as the exhibit, so. So, Mr. Thompson, that was exhibit 92, and is that the phone conversation that occurred between you and your fiancee Kim?
Yes.
And that third voice we heard was the voice of the defendant, Mark Jensen?
Yes.
Oh, it's still going?
I don't know, chat. What do you guys think? You think that proved conspiracy to kidnap Klug? Could it be extortion? Could it be other jailhouse favors? What do you guys think? Type that in the chat.
Get that thing to turn off. Now, after that phone conversation occurred, was there any further activity between you or discussion between you and Mr. Jensen concerning this this plan that you and he had hatched?
Yeah, he just, seemed real. He was real happy that everything, was coming together. And I assured him that it would be okay and that he had nothing to worry about.
And were there any further conversations after that concerning this plan?
Yeah, he was more or less worried. He said, what if he decides to talk after the trial? Then I told him, I said, well, you have a plan B then. He said, excuse me. He said, plan B. He said, well, what about go away permanently? I said, well.
I'm sorry, what would plan B be?
Yeah, plan B would be for him to go away permanently. I said, well, that'll cost you more. He said, well, we'll see. We'll see what happens.
Did he ever discuss with you plan B again?
No, not after that. We didn't talk about it anymore.
Were there any further conversations about the original plan about abducting or holding Mr. Klug?
Yeah, as far as just for the amount of time that he wanted him held, I asked him would it be 2 weeks, a month, or he said 30 days would be good. We had. Go ahead.
Well, go on. What else had he said about that?
Well, no, we had exchanged a few notes too, as far as what the plans were on pieces of paper, and I would write down my responses. He would write down his responses, and we would show them to each other. Just to keep down some of the conversation from going on around us.
Now, why would you hold up notes instead of just talking to each other?
Well, I went to court down in Chicago, and when I got back from court, they had moved me to the other side. So this was our only way to continue to converse about the subject was to hold notes against the glass, and he would read mine, and I would read his. And I saved all the notes that we had talked about.
So these were different cell blocks, but they were separated by glass panels?
Yeah, we were on the same cell block for about 2 weeks until I went to court. Then when I came back, they put me just right next door to him.
See, remember earlier, chat, I was saying how the cell blocks in Kenosha County Detention Center are set up. You have one cell block on one side. There's a guard station. It's all glass. And then you have another pod right across from that. I don't know, man. This is interesting. This part's interesting.
Well, how long were you two in the same cell block together?
For about 3 weeks.
Now, during the time that you and he were in the same cell block together, could you describe the layout of that cell block?
Yeah, when you come into the cell block, all of the cells were on the left-hand side. And at the end of the cell block, there was a radiator where people would come and congregate at. And in the middle of the cell block, there was a table we would play games at and eat dinner at, and some other seats off to the side. And there was big plate glass windows, like 6 on either side with the control center in between the two of them. So you could see both cell blocks. And at the back of the cell block, it came to like a corner, and I would stand on one side, he would stand on one side. This was after I got moved, and we would just, talk right there in the corner, either through the radiators or through notes. I would press mine to the glass, he would read it, and he'd press his to the glass, and I would read it. That was after I got moved.
Now, what do you mean talk through the radiators? I don't understand what you mean.
Yeah, you could yell through the radiators, you could hear what each other was saying from either side.
There's a ventilation system or something?
Yeah, kind of like a little ventilation, yes.
And now, during the time that you and he were in the same cell block together, did Mr. Jensen ever try to show you any of his paperwork or any transcripts that he had with him?
Yes, he showed me a little bit of it where...
I got to pause for a second, chat. Listen, I don't know how many of you have been in jail. He's right. You can chat through the vents. Shit, in some jails, there's even ways to chat through the toilet system. Here's the thing, though, chat. This is not like you can whisper through the fucking vents, okay? You have to yell through there in order for that voice to carry to the other side. So how the fuck are 2 pods worth of people, right, at least 10 prisoners in each pod, not hearing this? I don't know about this part, chat. So, look, I'm just pointing out discrepancies. Make sure you guys hear this, right? Don't put me on this goddamn jury because I'm pointing out too much shit. That's my job. That's what we do. We write about corruption within systems. So my ears are just trained for bullshit. So I just point this stuff out. So please, nobody take it like I'm trying to stick up for Jensen or anything. This guy's definitely not innocent. I'm just trying to point out discrepancies to you guys and bullshit and give you guys an understanding of how certain things, work out here in goddamn Kenosha.
He was talking about where he was supposedly had poisoned his wife, and it's basically about her mental health condition. I really didn't get too much into it with him because I told him it shouldn't be showing paperwork to everybody, but what he showed me was enough for us to converse about, about the case.
Well, as you're sitting here today, do you remember what it was that he actually showed to you?
Well, he first put out the newspaper clippings and showed me all of those and what was being said in court and what his bond was and, how he would, bond out. And I was like, well, what you gonna do when you bond out? He said, I don't know. He said, I'm trying to beat this case. And he was talking about just getting away, and I mentioned Panama to him. I said, he was talking about getting away when he was on bond. I mentioned Panama to him. I said, Panama is the only place that doesn't have an extradition treaty with the U.S. And from that point, he told me that what his family was trying to put together for him as far as bail with a house and some cash for him to get out on bail again.
And did he ever talk to you about whether or not he actually murdered his wife?
Yeah, that came along right before I got moved. I went down to his cell one day, and he was sitting there on the side of his bed. He had kind of had a rough day, a couple of guys were giving him a hard time, and I guess it just was the overall case came crashing down on him, and he teared up, and I asked him, what's wrong? It's like, oh, nothing. I said, come on, man, we've been talking this long now, just tell me what's going on. And he broke out into a full-fledged cry, and he said, I didn't mean to do it. I'm sorry. I'm like, sorry for what? What you talking about? He said, I'm sorry. I didn't mean to do it. I said, you didn't mean to do what? He said, I didn't mean to do it. He just kept saying he didn't mean to do it.
I'm going to request these items you marked as exhibits, Your Honor. You've seen these?
So we have an hour left before the Facebook stream ends. We're obviously not going to get through all of Dave Thompson. So here's what I'm going to do. Instead of letting Facebook end in 1 hour and then continuing over on YouTube, which, is the way we do it, because then, full disclosure, right? It draws you over to YouTube, which is great because we need you guys on YouTube as well. But what I'm going to do, because there's just so much shit, and I just want to marathon stream all this stuff. So once Facebook ends, or right before Facebook ends at that 8-hour mark, probably like 5 minutes before, I'm just going to end the stream on both platforms, right? And then I'm just going to pause the video that we're watching. I'm going to end the stream on both platforms and then set it up again and just immediately start restreaming right where we left off. So give it a couple of minutes and then jump back on YouTube or Facebook, wherever you're watching. But during the actual trials, okay, Facebook ends in 8 hours, and it's just unfortunately too bad for Facebook. And we continue the stream on YouTube. So, but that's what I'll do today. 5 minutes before the stream ends, I'm just going to cut it and then immediately start restreaming some more of these jailhouse snitches. Because Kelly Labante's testimony is so goddamn long, tomorrow morning at 8:30, I'll start the stream off with her testimony instead of the pathologist, like I was going to do. Because I know you guys really want to see her stuff, and you'll be bored out of your minds with Chambliss. Make sense? Everybody got that? Here we go. Of course, they play a commercial. Now is when I could have done it, right? Stupid. So, yeah, tomorrow morning, 8:30, I'm going to go live because they're not in court tomorrow because of the holiday. And I'll do Kelly's testimony for you guys. I know you guys are itching to see that. Because I really wanted to theme today out with the Jailhouse Snitches because they're expected to testify in the new trial. So I'm kind of glad it worked out that way. We could keep to that theme. I thought Kelly's was only a couple of videos, but it's not. It's 6 goddamn parts. And I'm still not sure what happened with the Aaron Dillard thing. There's 2 other parts, but it's all like repeat of what we already heard. So who the fuck knows what happened Monday morning when they came back? Because it's obviously, I'll have to look at it tonight. And if I can find something different about it, I'll stream that, I guess, at some point. But I don't know what the deal was with that, Chad. Sorry about that. But yeah, Kelly Labonte tomorrow morning, 8:30.
Each one of these documents marked as an exhibit.
That'll be juicy for sure. You know that. Roxy, thank you for consistently.
Well, she's marking those as an exhibit. Do you know a person by the name of Aaron Dillard?
No.
You never heard of Aaron Dillard?
No.
Did you believe that? Look at his face when he said that.
Well, you were in the same cell block as Mr. Jensen. Was he talking to anybody else in the cell block, or were you the only person he was talking to?
No, there were a few other people that he spoke to on a regular basis.
Who were those people?
Mr. Clanton, Mr. Bush, a few other guys I really didn't know. Bush was my cellmate, and Mr. Clanton, he was another Fed inmate in there. So those pretty much the only people that I really talked to were those 2 and Mr. Jensen.
When you were having these conversations with Mr. Jensen about abducting and sitting on or holding Edward Klug, were any of the other inmates present, or did any of the inmates in a position where they could hear what was being said?
I mean, a few of them tried to, hang by the radio to see what we were talking about, but I would either be quiet when they were around or told them to move around and go somewhere else while me and Mark talked.
I'm going to show you these items and marked as exhibits 93 through 99, and I'll ask you if you can identify what those exhibits are.
Yes, this is my handwriting. These are some of the notes that me and Mark would pass back with, writing, hold to the glass back and forth.
And these were your notes?
Yes, these are mine here.
So these are the communications that you were making to him, and then he would write something back to you?
Yes. Yes.
Okay, so let's go through these one at a time. And these aren't necessarily in order? Are they in order?
No.
Can you, if I gave you the opportunity, would you be able to put those in order, do you think?
Let me see here.
Chat, are we really, this is really happening in this trial? You have one way, this guy could have written this shit at any point. You don't have Mark's notes?
Oh,
There's
this
no
is the first
jail
one
searches?
where
No cell
S93 is the
searches?
first one?
Yes, where he said he got a call from someone
I
inquiring
can write
about
anything I
Kim.
want right now and be like, oh, I talked to Mark.
And I
Here's
told him I
notes
didn't
I
know who
wrote.
that,
What
who
the
that could have
F?
been. And this is the second one.
Okay, now this reads.
I don't know why Albie didn't object to this. This is
S93. S93 reads, my dad said they got a call this AM, questioning calls from Kim's number. Well, who wrote that? Did he write that or did you write that?
That's more or less his handwriting there.
I'm sorry, I didn't hear.
I heard your objection. I didn't hear there was something said over here.
And I didn't hear either one, so.
My objection is the witness already identified it as his own handwriting.
Right, this one here is from Mark though, because it says right here that he got a call from his dad, questioning a call from Kim's number, don't know who. That's not my handwriting right there. And this is his also.
I'm looking at S94. Now, so S94, could somebody be watching that place? That's Mark's.
That's Mark's handwriting.
Okay, now let's stop here for a minute. Let's go back to S93. Put the S95 down. Is there anything on S93?
I'm going to object to any opinion by this witness as to whose handwriting. He's not an expert in handwriting.
Well, if he claims to have seen it displayed through the glass.
But he's also the witness who identified it as his own handwriting.
Well, that's subject to cross-examination, of course, but he can make an identification if he's familiar with the history of the document and can link it to the accused.
Now, so let's look at S93. Tell me again about this note. Tell me everything you know about this note that's been labeled S93.
Okay, this one, it says they got a call from someone about.
No, I know what it says,
Okay.
but it's not. I'm not so much interested in knowing what it says. What I'm interested in knowing
What was
is
it leading up to?
how did you come into possession of this note?
I don't know how that note came to be mixed in with mine, but that's the one that he showed me through the glass.
So this is Mark's handwriting.
That's Mark's handwriting.
And this is the note that Mark left for you, or displayed for you.
Yes.
And that reads, my dad said they got a call this AM, questioning calls from Kim's number. Don't know who, I don't know what that means. And then there's a line that goes up here, talk to my dad this AM, haven't been able to get them all day, question mark, question mark. Now, did you respond to any of that? Is there any of this communication over here that is your response to that or not?
Yes, let me look through here.
Listen, chat, I'm sorry. I can't. This is too much for me. Look, I wish I was a lawyer. We need a goddamn attorney on this station here, on this platform, because we need an attorney to sit and fucking be with me to just object where these attorneys are not objecting from both sides, right? State and defense. We need a goddamn Never Stop Media attorney. This is making me, I'm like, you see me, like I'm throwing my hands up. I'm losing my shit over here. Where's the handwriting expert? At any point, they're not even in the same block at this point. They're holding notes allegedly up against windows. Okay? This guy could have had another jail guy fucking write this stuff. I'm sorry, we use naughty words here if that offends you too fucking bad. This is pissing me the fuck off. How is this even allowed? You know what I mean? I'm not a lawyer, so I don't know the right legal jargon, the objections, but What the actual F is happening here? Do you guys feel the same that I feel? What are your thoughts? This is fucking beyond me at this point. You know, it's great because I know too much about this case, and I'm trying to really look at stuff objectively. And because of what I do, we expose corruption, right? So I'm really pinpointed on that stuff in this thing. But, you know, there's things where I'm like looking at Mark and I'm like, fuck this guy. But then there's a lot of stuff where it's very circumstantial bullshit.
These are Mark's communications to you.
And
Do you
then you
remember
have
what kind of
testimony like
communications
this?
you
What
gave
is
back to
happening?
him?
Yes, I told him, I said it probably was the detectives that was investigating the bank robbery I had did, because that's the only clue I could come up with that may have made them call back to that number. I figured maybe my line had been tapped, but still wired, you know.
And that's, and then he asked on Exhibit S94, could somebody be watching that phone?
Right.
And you know which phone he's talking about? Is he talking about your phone or is he talking about?
Yeah, Roxy, we did the Rittenhouse trial. We did
when
Theodore Edgecombe, because that happened out here. Rittenhouse happened out here. And we did we have another trial up on the thing. Some mass shooter dude, I forgot his name. It's up on the thing. But we could never like stream like this because we were using a dinosaur computer, so our streams were kind of ghetto. This is the first like real stream. We did it for Rittenhouse. Somehow it sort of worked. There were some issues and we had to ghetto stream, but then sort of real stream. It's kind of fucked. Long explanation. But yeah, we've done a few. But this is, I'd say this is our first like official, you know, that we can stream the right goddamn way. Sorry, just answering questions, guys.
Before he wrote this, could somebody watching that phone, what was the last thing that you'd written to him? Do you remember?
This is how it was in the Rittenhouse trial, though.
That was like the beginning of our
all the lies
I had just got moved to the other side. And after that is when all this other took place.
And then we were showing our footage.
So let's direct your attention to S.
Rittenhouse testimonies.
And now, can you put these in order?
Okay.
Starting with the beginning and go through them in order.
You want to see me really lose my shit in the trial? Watch our streams of the Rittenhouse trial. I was really losing my shit for that because I was there. I filmed Kenosha. I was on the street. I watched Anthony Hoover get shot and fucking killed right in front of me. And there was a lot that we filmed. You know, plus we were hanging with Andrew Mercado. We were hanging with DJ at the time before, you know, we became arch enemies. So there was a lot of, all three of us, you can watch all of our streams. We were all losing our shit on our streams, pointing out the lies. But yeah, you want to see me like lose my shit on a trial live stream? Watch the Kenosha stuff. But we've done a few. They just haven't been as cool as, you know, quality like we do here. But yeah, this witness is just pissing me off with, I know how jail works, you know. Unfortunately, I've been there, I know how it works. Some of the shit there is super legit. Other stuff, I'm just like, bro, you're fucking full of shit, man. You are full of fucking shit. I don't like this guy at all. Fuck this guy. Somebody look him up on CCAP. Is this motherfucker still in jail? I hope he is. I don't like this guy at all. This guy's pissing me off, chat. Sorry, that's my rant. That's when I'm out of cigarettes.
So
That's
now
what
these
happens.
are in the order that you believe that you wrote them out?
Yes.
So that would be S98 is first, S97 is second, S96 is third, S99 is fourth, and S95 is fifth. Okay, so let's start with S98. Does it start at the top and work its way down, or start at the bottom and work its way up?
It's kind of intermingled.
So looking at these, which was the first thing that you wrote, if you can recall?
The middle one where they called Kim down to the station and asked her if I did any more crimes. They think I've done more banks and some other stuff.
That's not stuff. But read exactly what it says.
Oh, bullshit. Okay, but I came clean when they first questioned me. There isn't anything else, but handling things okay for a change. I was referring to, how I was going through with my daughter, but it is a must. Let me know after your visit Sunday. I'm going to go call Kim now. It was the last statement is a referral to had his mom received the money from his girlfriend yet for Kim to go pick up.
And then how did he reply to that? Do you know?
Well, he replied on some different paper. I don't know what he did with his copies, but I kept all of mine.
But you know what
he said basically that he wasn't able to get in touch with his mom, but that she would have the money, and her and Kim were to contact one another by phone for them to make arrangements to get the money.
And then when did this portion up here get written?
We need a fucking lawyer, dude. How the fuck? Listen, I understand some of these other people, Ed Klug, I get it. Supposedly they're in the same fucking room and they're chatting. Okay. Aaron Dillard, I get it. They're in the same room and they're fucking chatting. This motherfucker is talking about like telepathy through fucking glass windows. How is this fucking happening? Is anybody else losing their shit? Am I the only one, chat? Am I losing my mind? I have a couple of cigarettes that are like half butts, like 3 drags. I'm going to lose my fucking shit. This fucking trial is going to make me start fucking drinking. What the fuck? This guy is pissing me off, chat. I'm sorry. It's too much with this guy. I don't understand how is this allowed? How is this allowed? JK over on fucking... JK says, look at everyone, the whole chat on YouTube and fucking Facebook is like, you're the only one, bro. Settle the fuck down. Look at everybody. Mali's like, bro, you're fucking losing your shit. You're the only one. JK over on fucking YouTube, you're the only one. Christine over on Facebook, you're the only one. J Bean, thank you, J Bean. JB says it's Schroeder's fucking fault. Fuck my life, chat. This is, I don't know, dude. This guy is pissing me off, dude. You see me throwing my arms up? I'm going to fucking throw these headphones across the goddamn fucking room. I'm fucking gonna. This guy is pissing me off. Somebody find out. We CCAP'd fucking Aaron Dillard. He's in custody in Dodge for multiple things. We posted that for you guys up on fucking Facebook. Somebody find out about this fuck. Did he get hit by a bus? What the fuck? Is he in? He better be in fucking federal custody. Fuck this guy, bro. I don't like him at all, chat. I don't. I'm sorry. I'm gonna keep losing my fucking shit over here. I'll try to keep the mic muted because I'm gonna snap.
That was in regards to the money too. That was like right after this here. Because when I called Kim would say all his asses should be. He was supposedly talk to his mom and let her know what Kim would be talking to her about.
Well, now, were you and he in separate cell blocks at that time?
At this time, we were.
Then how was it that he was able to get on the phone as you were talking with
you? We were almost in the same cell block then when the phone call transpired.
I see. So this was written before or after that?
After that. This was so that we were trying to figure out a way that his mother, that Kim could go get the money, something that she could say that would let things know that it was okay for her to come get the money.
And then that was S98, Counselor. I'm sorry. And I'm going to direct court and counsel's attention to S97, and that was the next communication you held up. Is that correct?
Yes.
Okay. And what's the first thing, as you're reading this, what's the first thing that you wrote on this note?
Can't mom drop it off?
And what's that in reference to?
Could his mother somehow get the money to Kim?
And how did he reply, if you recall?
Kim would have to come down and meet her somewhere.
And what did you write in response?
That's all good. Who drops it off, it doesn't matter.
And and then I see this is written here. Was this written in response to something from Mark, or was it Mark Jensen, or is this something that was part of this note here?
It was part of this. It says, can Kim come pick up the 575 from mom today? Kim can call her
does it say, can Kim come pick up the $575 from mom tomorrow?
Yes, and Kim can call her now for the money, $575.
And how did Mr. Jensen respond to that, if you can recall?
Well, he wanted to be picked up from a mailbox, from someone's house in a mailbox.
Did he say whose house or whose mailbox?
No, he didn't say who.
And then I'm looking at, for court and counsel's benefit on XS96. I see there's writing right side up and upside down. Which of these notes is written first? This one that's right side up or the one that's upside down? And here's the one that's upside down.
Yeah. So Jamie over on YouTube says, well, if Mark cleared all this up, would it make you feel better, Kev? Yeah. Yeah, it would. Yeah, it would. Should we go visit him? I'm going to fucking ask him. I'm going to ask him. And I'm going to take his word for it. I'm going to. Fuck this guy, bro. Legit. Fuck this guy. Tara says, Kevin is the man with his leg cramps and all. Yeah, dude, I got it. Seriously, I'm telling you, chat. I got my fucking left calf from like the back of my knee, probably down 6 inches into my calf. I want to fucking cry. I'm in so much pain. It's not even funny. It's from sitting in this chair for 48,000 fucking hours.
Or don't you remember?
Oh, that's something totally different there. That was about my sentencing guidelines.
That was about my.
Sentencing guidelines, some federal stuff we were talking about.
Who was talking about that?
I was talking about that with someone else.
Okay, so
you were talking to the fucking glass, motherfucker.
Note that says,
Yeah.
after
What are you
lunch, let's
talking
work
about?
on this guide sheet.
Right.
Work on guide sheet after lunch.
Yes, that was federal sentencing guidelines. There was another federal inmate on the unit with us, and he was on the side with Mark, and I had got the papers in the mail. He was going to show me how to calculate my federal time.
Calculate. Shut the
I see.
bro. I swear to God. I know. I need to drink.
So,
well, look, that's the thing. I'm out of money, chat.
Which of these notes
legit
were
shit.
written
This
first?
is no bullshit. I am out of money. I spent my last fucking $3 on ramen yesterday. You guys have seen me. I drink my fucking Nalgene. I usually have some liquid IV in here or some drink element, electrolyte stuff, and I'm fucking out. So I've been drinking coffee, which is not good, and whatever. Anyway, I'm fucking ranting now. Sorry, chat. Sorry. I'm losing my fucking mind over here with this guy. I'm going to fucking lose it. I'm losing it with this motherfucker, dude. This guy, look, chat, he is talking to the fucking glass and a heater, for fuck's sake. Who knows what other inanimate objects this motherfucker is having conversation with? Okay? What the fuck conversations? Is he talking to the pillow? He's talking to his metal bunk, maybe the fucking metal toilet in his cell. And this guy's over here fucking testifying to notes that Mark allegedly wrote on the other side of fucking glass. Now, mind you, chat, there's probably 4 feet in between these glass panels and this like CO fucking thing. Okay, there's definitely ways to communicate. I'm not saying there's not. There's definitely ways to communicate, especially when COs don't pay attention because they're in there, who knows, jerking their fucking thing, fucking on the computer, stroking each other off. And most of the fucking times, chat, they're not even in the motherfucker because they don't give a fuck what happens to you as an inmate. They're off in the hallway, stroking each other off over there and doing fuck all knows what. So, sure, maybe there's some shit happening, but how the fuck this guy is testifying over notes held up to glass? Okay, what in the fuck? I don't know. I understand. So he's got his notes. I get that part, and what it's reference. I'm fine with that. I'm fine with that, chat. But when he's saying what Mark's notes fucking said, I don't know why that's allowed. I don't like it. I'm not buying some of this shit. This guy has made some squirrely ass fucking looks. I don't like his shifty ass little fucking eyeballs. Okay, he's made a few. You guys watch Mark. Watch this motherfucker with his shifty shit. I don't like this guy. I cannot wait. I hope this I'm waiting for my buddy over at Corporate Media to send me the fucking witness list. I hope this motherfucker is on the list because I want Jensen's team to fuck this guy up on the stand. All right. I'm sorry, Chad. This is what happens over here on Never Stop. And this is why views end up going up, because even our stalkers and our haters, this is what they want. They want Kevin to lose his fucking shit on stream. And this is how we get views, because I go into just a fucking rant. A rant. Motherfucker. This shifty fucking shit right here. And look how Weasley Jamboy is. Weasley, little motherfucker, just like Binger is. Fucking D.A. Binger. You guys seeing the similarities between these two fucking clowns? Shifty fucking Weasley, little fucking fucks. I don't like him. I don't like him in this trial. He's arrogant. He's cocky. He's a Weasley little fucking shit. He's making his fucking tea all goddamn fucking morning with the tea, okay? And I got to listen to him crinkling his fucking tea wrappers all morning. I'm trying to listen to a fucking trial, and this guy, I'm going to lose viewers over this because there's going to be a lot of viewers going, whoa, this dude's fucking crazy. This motherfucker, I got to listen to his crinkling of fucking tea wrappers. All morning we had to listen to that chat. All morning. And then watching him just fucking, with the tea bag all fucking day. I don't like this guy. I don't like him. And then he wants to yell at the judge in the modern day trial. Fuck this Weasley ass little motherfucker. I can't stand this motherfucker. Fuck this guy, bro. For reals. And this fucking Fed snitch ass motherfucker.
This one up here or this one down here?
The one in the middle. It says, I hate to bury you, but do you think mom could leave me $30 for stamps, soap, toothpaste, and deodorant and lotion? And he said, sure.
And then you leave your name and what,
My
number? And
yeah, a jail number. And she was supposed to leave it when she came to visit him Sunday, but I don't think he talked to her about it, so she never did.
And then and how did he reply to that?
He said, sure.
And then I see up here, what does it read?
Don't forget to tell mom to leave me $30.
So what kind of communications occurred between you and Mr. Jensen between this point here where you're asking for the $30 and this point up here where you're reminding him to ask her for the $30?
Because he's fucking extorting
Do you
him.
remember?
I mean,
this was between.
Listen, here's how jail works.
Let me see what's up.
Okay, you've already fucking had physical confrontation with this fucking white Weasley, shifty-eyed fucking murder suspect. All right, you physically assaulted him in fucking jail. He's a scared little bitch. Okay, and your fucking homies are on the other motherfucking side. What happened to fucking 575 and 425? That's the deal for the kidnap. What the fuck? And now it's $30, little fucking payments here and there. That's fucking jail extortion, motherfucker. You guys, are you listening to this shit, chat? Fucking shifty fuck. Don't put me on a jury in this fucking.
Yeah, this was between.
Kenosha will hate me 10 times worse
first
than they
exhibits
do.
and
I'm
the
acquitting
plan
this
for
motherfucker. I'm acquitting him based on this guy.
to disappear.
Fuck all the other fucking corrupt shit that
Now
happened.
directing your attention to Exhibit S99.
This motherfucker, bro.
Which of these was written first?
The top one.
And what is that? And read that, will you please?
It says, how long will it take or how long will he be kept? That's your call. He asked me, basically, how long should he be held down or where will he be kept and how, what will be happening to him? And
So he was doing that with a written thing. He was asking you how long he'd be held and where he'd be held and that sort of thing?
Right, and I asked him how long. And he said 2 weeks. So then I wrote, 2 weeks is cool, but he can be made to leave town or made to sign an affidavit saying he totally lied on you.
And how did he respond? How did Mr. Jensen respond to that?
Basically with questions because he was speaking about suing Mr. Klug. And
Through
I was
the
like,
glass.
well,
Through
why
the
sue him?
glass.
I mean, for what?
Get
And he
the
said,
fuck
well,
outta
you can make him
here,
sign an
bro.
affidavit saying he totally lied on you.
Get the fuck
And
out of
then
here.
what's the next thing that you wrote here?
This is all for you, so whatever you want done will be done.
And how did Mr. Jensen reply to that, if you can recall?
He said, okay. He nodded his head through the glass and said, okay.
And then what's the next thing that's written there?
Listen, me as a motherfucking attorney, where the fuck are the videos from the fucking pods? Where's the videos? They better show videos. They better show fucking video footage from inside this fucking jail, because these pods are fucking, they're filmed. There's cameras. There's fucking cameras. And maybe that'll clear it up for me. Show these two fucking glue sticks fucking, post-it noting the fucking glass. Where's the fucking video proof?
Getting the job done is what.
No, it's right here.
It's all good.
I'm
No
pretty
time
sure
to
they
keep
had
from ever
cameras in
saying
2008.
anything. You know this case has no statute of limitations.
And how did Mr. Jensen respond to that?
He says, I know.
Yeah, okay,
And then what's the next thing that you write here?
We should have a clarification that Mr. Thompson is reading from a letter. In terms of Mr. Jensen's responses, there's nothing in writing.
Yeah, it's about time!
Claims
It's about time, Albie! What
As I
the
understand
fuck?
it,
4
the
hours
document
later?
From what you are reading
fucking
is
idiot.
one that was prepared exclusively by the
About
witness.
fucking time! Your
And
client is
that
fucking
the recitations about the responses
Are from his memory.
attributed to the accused they're from his memory, and they're not on the
Rest
paper.
your fucking head on your recliner.
That is my understanding, and
Your fucking
I
Emperor
certainly
Palpatine
wasn't intending
recliner.
to convey anything other than that.
No, I was just concerned that because it sounded like question and answer so rapidly. So I just wanted to clarify.
Okay. You think that's been done adequately, or, okay.
Chat. I'm sorry. I can't with this guy. I just can't, chat. You see him? You see him on his Senator Palpatine fucking throne over there? Goddamn Schroeder. You hear me? I'm losing my shit with this fucking witness, guys. I've tried to be calm. I've tried to use the cringy, reporter voice. I do that intentionally because I think it's fucking funny as shit. This is how I am. This is how I am with this shit. And I try to
And
use
it
the
says here,
cringy
getting the
reporter
job
voice for you guys.
done is what he does best.
Right.
And had you ever given Mr. Jensen any information when you were in the same cell block so he would know whom you're referring to when you talk about he?
Yes, I told him that a friend of mine would abduct him for him.
Would abduct Mr. Klug?
Yes.
So tell me about the conversation that occurred between you and Mr. Jensen in the cell block when you two were in the same cell block together. Don't look at this exhibit now.
Okay,
But just
thank you. Let's get to
Go
that.
back to this conversation that occurred between you and Mr. Jensen in the cell block where you were describing to Mr. Jensen's benefit this friend of yours who you felt could abduct Mr. Klug.
I told Mr. Jensen, I said, well, I might have a solution to your problems. So I have a friend of mine that, does this kind of work, and I'm sure he'll do it for you for a decent price. Yes, we went on to talk about what the price would be, and then we came upon that statement there. I mean, like I said, I told him, so this is what he does best. Is take care of situations like this, and Mark was in the court with it.
And, you're even sitting on or holding somebody for 2 weeks for $1,000 seems like a bargain basement price. Did Mr. Jensen comment on that?
Yeah, he said that seems kind of cheap.
Is there such a friend, by the way, or are you just making this person
No, I'm
up?
just making all this up.
And then what's the next thing that's written down here?
Trust me, Mark, come October 8th, you'll just about have your old life back.
Now, as you're sitting here today, can you remember
the views-
between this
views
point where
went
you'd
up on
written, getting the
YouTube and
job done is
Facebook. I'm
what he
losing
does
my shit.
best, and then where you wrote,
I
trust
told
me,
you.
Mark, come
I
October
told you
8th, you'll
to
just
go
about have your old life back. As you're sitting here now today, can you remember what it was that Mark Jensen had written and held up for you to see?
Come on.
No, not exactly.
Oh, now you don't
It
know?
was a short
Now you don't
response, so
fucking
I
know?
mean, I'm just speculating what to
No, don't speculate,
No,
sir.
don't speculate, motherfucker. Now you don't
Then
know
the
what
next
he wrote
thing,
on the
I'll be
fucking
here for
window?
at least 2 months, but I know this process won't have to be done again. What is that? What are you referencing there?
And that reference, it was to the contest that once Mr. Klug was kept and held, that we wouldn't have to repeat the process again.
And had Mr. Jensen sent you or written up for you any kind of communication that you can remember that caused you to write this response?
Yes, he said, what if he talks? And that's when I responded with that.
And he wrote, what if he talks? And you responded with this, or you responded with this?
Both of those, because I wrote that, then I was running out of paper and I wrote it on that.
So this is now Exhibit S95, and read what it says that you wrote there.
It says he won't. His life depends on it. But like I said, to eliminate that possibility, there's always Plan B.
And do you remember how, if at all, Mr. Jensen responded to that?
No.
Now, these notes that you identified as having been notes that Mr. Jensen held up for you, S93 and S94, do you remember if these notes that Mr. Jensen wrote were written before, after, or interspersed with these notes?
It was before all of that.
Okay. I'd request that exhibits, let me get all the exhibit numbers here. S93, S94, S95, S96, S97, and S98 be received in evidence subject to cross-examination.
Any objection?
Object to 94.
May I see them, please?
Yes, Your Honor.
This guy's writing a fucking novel on fucking little tiny pieces of paper pressed up against the glass.
Yes, those are the subject to 93 and 94.
What is the objection?
His ability to identify.
I'm sorry?
His ability to identify Mr. Jensen's writing.
Well, according to what he states, as I understand it, and you're welcome to correct me, he states that Mr. Jensen held these up to the glass.
No, you fucking idiot.
They're Mr. Jensen.
They're not his notes.
The witness is claiming that he was expressing these thoughts via these documents. So your objection's overruled.
Get the fuck out of here. He's not a fucking handwriting expert. I don't even believe the shit's real. It's fucking speculation. It's fucking argumentative like a motherfucker. Fuck this guy, bro.
I have no further questions of this witness, Your Honor.
Holy shit. Chat.
Cross-examine.
Bro. Albie better. I hope this guy testifies in the current trial. Renner is going to fuck him up on that stand. Roxy on Facebook says, don't get brazen with me. You see, I'm getting brazen with his ass.
Thompson.
Let's get him, Albie. Get his ass.
It's fair to say.
Fair to say, fucking Daryl Brooks, that's where he got it.
For you.
God damn it.
Sure. Yes.
And on September 6, 2007, you arrived in the Kenosha County Jail, right?
Somewhere around that date, yes.
Oh, what the fuck, dude? Everybody in this courtroom
You were
is
there
dying.
because you had robbed a bank in Gurnee, Illinois in June 2007, right?
Yes.
You and your wife had robbed the bank together, right?
No, I robbed the bank.
Well, your wife was your accomplice. And when I say wife, I mean the person I should say fiance. Your fiance was your accomplice in that bank robbery, correct?
No, she had nothing to do with that.
Your fiance went into the bank in Gurnee, Illinois, examined the interior.
Hang on, I got to respond to this comment. So Yolanda asks, why is there a new trial? There's a new trial because the Sixth Amendment confrontation clause under the Sixth Amendment changed in 2004. So for whatever reason, the letter from the grave that Julie wrote a letter saying, hey, if I die, look at my husband. That was allowed in during this trial, the 2008 trial. And then this case just kept bouncing all these courts, appellate courts, whatever. And they challenged it. There was some shit that happened in 2016, 2017. They challenged the letter under the 2004 change of the Confrontation Clause in the Sixth Amendment. Wisconsin Supreme Court agreed that it violated Mark's Sixth Amendment right. The state didn't like that ruling, so they took it to the U.S. Supreme Court, and the U.S. Supreme Court said they didn't want to hear the fucking case, so it upheld Wisconsin Supreme Court ruling, and he was then allowed a new trial. So we do have a lot of other streams where we talk about this stuff, and obviously I'll keep repeating these things because we obviously have new viewers that come in. But we have other streams where we really go into a lot of detail. We read the whole Confrontation Clause from 2004, how it changed, a very iconic Supreme Court ruling. I believe, if chat correct me, I believe it was Crawford v. Washington. So it's a big iconic Supreme Court case. But we talked about that. We talked about the letter, the criminal complaint, a lot of that stuff.
Superior of the bank came back to the car and told you what that bank looked like, right?
Objection, this is irrelevant, Your Honor.
I asked her who was inside the bank and how many tellers there were. I asked her that.
Right. After she had gone in and looked around and noted how many tellers there were, right?
After I questioned her, that's what she told me.
And then you went in and stole $24,000.
Yeah.
And you've said that was just an act of desperation, right?
Yes.
And that act of desperation you undertook because your home was being foreclosed upon, right?
Two homes
were being foreclosed upon, right?
Yes.
You have a child at home with your fiance, right?
Yes.
You didn't have any money, right?
Yes.
And then you committed another act of desperation in August of 2007, right?
Yes.
You robbed another bank, right?
Yes.
You robbed a bank in Madison, Wisconsin in August 2007.
Yes.
True? And you did that with your wife as well?
She was in the car. I already did that myself.
But your fiance was with you, right?
Yes.
Yeah, she's still an accomplice, you fucking twat. The fuck? She's the getaway driver.
And as you sat there on September 6, 2007, in the Kenosha County Jail, you were also facing a charge for theft of firearm, right?
Yes.
That is, your mom had accused you of stealing a firearm from her home. True?
Yes.
And you had admitted to your mother that you stole that firearm.
No,
right?
I did not.
Well, you knew from the criminal complaint that your mom had said you admitted stealing the firearm from her, right?
I never read that.
Are you telling me that you didn't know that your mother was the one who had told
I knew
police?
I knew who made the complaint, but I never admitted that.
And your mom had said that you stole the firearm to pay off drug debts, right?
That's what.
Your Honor, how is this relevant?
And how does this come in? I'm.
I know.
What is it? 901.8? Is that the thing?
All motive, Judge.
What? I don't know what the thing is. Whatever the fuck the thing.
And bias.
Well, and I agree with that. And then also,
Come on, Palpatine, get to it. Get to the ruling so we can get back to shifty eyes over here. Look at him with the fucking law books and shit. Let me look at the law, people. I'm gonna look it up. Let me tell you a history about the law. Look at Palpatine, Jesus.
90608 subsection 2 this last sentence. Well, the whole subparagraph. 906.08 subsection 2.
Yeah, that's what it is. 906. Yep. Law is only based on that one statute, 906.08. That's it. 906.8. That's it. That's all the law. That's all we ever hear in these trials is that one fucking statute.
Go ahead. Objections overruled.
Yeah, thank God. Okay, you're an idiot.
Could I have the last question read back?
And your mom had said that you stole the firearm to pay off drug debts, right?
Yes.
And had you stole the firearm?
No.
Your Honor, I object. I don't see how this comes in under section 906.08, some paragraph 2. It indicates.
Well, let's give us a few minutes, would you, folks? Please don't talk about the case.
Please all rise. I mean, you already know this is coming. Why don't we excuse the jury 5 minutes ago?
What do you want to say, Mr. Jambois?
Your Honor, this witness has not been asked to testify about his reputation for truthfulness, and he hasn't testified about his reputation.
That's in the disjunctive. That's one possibility. The other is a cross-examination of a witness. If the evidence that is about which he's being questioned, if the questions pertain to whether he's a reliable and honorable, honest person or not.
What? Here's what it reads, Your Honor.
Listen, Jar Jar Binks.
Specific instances of conduct.
Okay, that's what we're talking about.
That's correct. Specific instances of the conduct of a witness for the purpose of attacking or supporting the witness's credibility, other than a conviction of a crime or an adjudication as provided in section 906.09, may not be proved by extrinsic evidence.
So that part means that he's going to have to take the witness's answer.
Yes, tell him the history.
And he's not going to be allowed impeachment on it.
Well, all it says is they may not be proved by extrinsic evidence. Okay.
Right. Extrinsic evidence means he can't call other witnesses.
Now, here's what they can do. They may, however, subject to section 972.11 sub 2.
That's the rape shield law, which has nothing to do with it.
I understand. If probative of truthfulness or untruthfulness and not remote in time, be inquired into on cross-examination of the witness, or on cross-examination of a witness who testifies to his.
Don't read that part. That's not relevant. Just end up with may be inquired into upon cross-examination of a witness, period.
This fucking guy's memory, though, for real.
If it's probative of truthfulness, if it's not remote in time, he can ask him about it, but he'll have to take his answer. He won't be allowed impeachment.
Okay.
So if the defendant, whether he steals a gun from his mother, whether he uses money to buy drugs instead of pay off his house like he claims, these are all things that the jury has a right to consider in deciding whether this is someone who ought to be believed.
Okay. I understand now.
Okay. Did you want to say anything else?
Just to add in terms of motive and bias, anything that he has pending at the time that he begins putting into effect a plan to set up Mr. Jensen is all relevant.
Well, I wouldn't think that but there's nothing pending about whether he was stealing to buy drugs or stealing a gun from his mom. Well, is that charged, theft from a firearm? Theft of a firearm?
It was charged in September.
You did say that.
Yeah.
So, but the drug part would not, but I let it in under the.
And I think
section.
There's some, well, if we get to it, we'll get to it. I mean, there's some other things as well. I think is general obstructing of justice while in the jail, but.
All right. Ask the jury to come back in, please.
I think that's the end of that video. So we got part 2 now of Dave Thompson. Part 2 of this dude fucking. Why don't we do this, chat? Since this is a convenient time, part 2 ended. Let's do this. So part 2 ended. So here's what I'm gonna do. I'm gonna end the stream now because this is just actually a great part to do that. This way we're not having to play like 10 minutes of 10 minutes of this dude's part 2 testimony and then fucking stop it. That's stupid. So what I'm gonna do, because we're marathon streaming all day, and we'll do this shit tomorrow too. So I'm gonna stop the stream here on both platforms, and then I'm gonna reset the stream up. So just give me a couple of minutes to do that. And then we're going to put part 2 of Dave Thompson up here. There's a part 2 and a part 3 of Dave. We got a couple other Jailhouse Snitches. So we'll keep it on Jailhouse Snitch theme for today. We'll see where the streams get us. So we'll do another 8 hours or whatever. Yeah. So I'm snapping over here. I don't like this guy. I don't find him credible. So whatever, that is how it is. But yeah, make sure you guys like the stream, share it out, whatever. Make sure you're following all the things. If you guys want to support the platform, because we need it. That's how we keep putting content and all this stuff. Otherwise, poor little Kevin's got to go back to a fucking day job, and then we can't be streaming this case anymore. So there's links and all that jazz. All right, I'm going to end it and then restart. Just give me 3 minutes to set this up.